just stays the same. Wake up, feel that emptiness of face. Wash away the pain and put some makeup on my face, yeah. Every single day just stays the same. I am giving all to you in vain, but I guess I had it coming, so why should I complain? Why should I ever stop, ever stop? Why should I give you up, give you up? And when do I see myself every day? Repeat itself, repeat itself. They say I'm out of my head, 'cause I keep telling myself one day you'll find me, and one day I'll find you, and we're off to what they call a good start. And then I wake up. Every single day just stays the same. Wake up, feel the emptiness of face. Wash away the pain and put some makeup on my face. Every single day just stays the same. I don't really care and it's a shame. I know I had it coming and I don't care to explain. Why should I ever stop, ever stop? Why should I give you up, give you up? And when do I see myself every day? Repeat itself, repeat itself. They say I'm out of my head, 'cause I keep telling myself one day you'll find me, and one day I'll find you, and we're off to what they call a good start. And then I wake up. One day you'll find me, and one day I'll find you, and we're off to what they call. And then I'll wake up.
Good morning, everybody. We are back for day 106 of the Young Thug YSL Rico trial. Yesterday was bananas. We had fun yesterday, man. We went 8 hours, man. Shout out to you, Felicia. Fee. Say good morning, morning, morning. Good morning to you. First one to hit the live. First one to hit the comment. Yeah, we went hard yesterday, man. We went 8 hours yesterday. Yeah, it was crazy. Yesterday was insane, man. You had John Melnick came to testify. You had Caleb Bumpus testified. Some other DAs. So yeah, we're gonna have a treat today, I'm pretty sure. The question is still out there about the judge if she's going to rule on those motions for retrial. I mean, for a mistrial. I think one was no retrial. And yeah, right. Yesterday was a roller coaster. And also yesterday, last night, Caleb Bumpus hopped on the lead attorney's channel. So we may watch that in the intermission of the court while they're in recess and stuff like that. We may watch that during that time. And also there's a video by Dear Woke Christian that's like super, super dope. Super, super dope. Now we might get to that as well. Yeah, I doubt it too. I doubt if it's going to be a mistrial. It doesn't seem like the lady is interested. Judge is interested. So yeah, I don't think a mistrial will happen. Ricky E, what up, though? What up, though? What up, though? Everybody come on in, man. Everybody come on in. I'm TikToking away at this at Law and Crimes. They said it's supposed to be 8:45, so I kind of started the live a little bit early so we can get it in. All right. Yeah, yeah. Last night, Caleb Bumpus hopped on the lead attorney's channel, man. He was actually doing a live with AV about her testimony. And his reaction to her testimony was pretty, it was like it was such like a lawyer. And he said some things that we all said similarly yesterday, where you are a lawyer and you come to a courtroom and you have a deputy come to escort you to the office of the chief judge that is ruling over a case that your client is involved in, your client is involved in, and you don't see the defense attorney at all. You don't see anybody from the defense there, but you don't realize that this is a ex parte meeting that's happening. Even if no one told you, hey, we're about to have an ex parte meeting, you could just read the room and tell. Like, you got a court reporter, you got deputies, you got two investigators in here, you got the chief judge, you got the prosecutors, and you got your client in chains. You don't know it's an ex parte. Somebody's missing. Someone is missing. You're a lawyer, baby. You're a lawyer. So all that is just crazy. AJ Taylor said, "What it do? What it do, man? What it do, man? Appreciate you stopping by, Biz Nation, bro. Hey, man, we a family over here, man. So come on and join us, man. Come on in and relax with us, man. We are a very intimate chat, man. We don't have all the big numbers yet, but we getting there, man. We on the road to 1,000. The last time I checked, I think I'm at 840 subscribers to you on YouTube here. So man, we're trying to reach 1,000, man. Once we get to 1,000, we're gonna have some more fun. We definitely gonna have some more fun. I'm not sure if they're starting late or not, but it is what it is. It's all good. Donald Trump, the president of the former president of the United States, talked about Young Thug being treated unfairly on Aiden Ross's live stream. You know, I'm curious about the Aiden Ross live stream that he had with President Donald Trump. It's kind of crazy. AJ Taylor says, in my opinion, Kayla is lawyer slow. She's a baby compared to the rest of the attorneys around here. She's struggling, but wanting to be an influencer and an attorney. Okay, I got you. See, yeah, I see what you're saying. I don't know. You know what's so interesting about this, AJ, is the fact that you actually worked in the district attorney's office under Paul Howard for a long time, for quite some time. I think that's where she cut her teeth. And so I don't see how you not know certain things. You know, when she testified and said that she didn't realize it was an ex parte meeting until Brian Steele came in good faith and told the judge that he was aware of the ex parte meeting. I'm like, you didn't know what you was doing for real. You didn't know what was going on. Is that we can't tell? We can't tell. You right, man. Hey, you right about that. Can't tell. We can't tell if I don't know I don't know if it's the lack of knowledge or the lack of just interest. I think one of the things we noticed too, because she went live after her during the lunch break, I believe, and when she went live, she talked about she felt like she helped the defense. Is what she said. It's what she said. Hey, man, and so that was her perspective. That was her observation. But yeah, man, I don't know. I don't think a lot of people are saying, man, she did a bad job. She can't recall anything. She did. I don't recall. It's like Lil Woody. You know what I'm saying? Like Lil Woody. We got the number one mod chill in the building. What up, Doe? Saying good morning to everyone. He said, AJ said she's turned her cameo in the YSL trial into a main character. Exactly. And I have no idea why I mean, me personally, like I said yesterday, me personally, man, if I had a motion or a hearing that with a judge and it gets dismissed because the judge has been recused and all that kind of stuff, and I'm cleared from the case, I'm cleared from any type of anything from the case, man. She live in Houston, Texas. I'm in Houston. I'm at the crib, and I'm rocking out in silence. I'm not trying to uh, see what's going on with this case. I don't care. I don't care, dog. I'm out of here, bro. You feel what I'm saying? I'm out of here. I don't care about none of that junk. I don't care about none of that junk, dog. Mm-mm. Nope. Not me. If it gets denied that I have to come to court, uh, and I'm free to go, I don't have to talk to nobody at all. I am not trying to come back to this case. For what? For what? Exactly. Exactly. She volunteered to be a part of this circus. Exactly. And and then she said, this is the part that becomes disingenuous. She says she's trying to expose the corruption that's going on in down there. Okay, let's, hey, if that's what you're saying for face value, we'll take it. But I think the defense counsel is doing a pretty good damn job of that. I don't think they need any more help. Okay. And so it's really serves no purpose. The whole Rule 22 thing, and she made the little snarky line about passing the smell test because Miss Love in the secret ex parte meeting that happened on June 7th, we had the transcript inside of the motion, the supplement motion that Weinstein did. And in that motion, it mentions, how they were gossiping about what's going on in the courtroom and all this kind of stuff. And then the line that was at towards the end of the transcript said, I don't like Kayla's over here hugging Thug and she hugging, Mr. Kendrick, and she's trying to do all this kind of stuff. And it just doesn't pass the smell test, is what Miss Love said. So when Kayla Bumpers got up there for the Rule 22 to get that to record in court, she said she said the same thing. Judge, I'm just up here to just pass the smell test and da 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 da. And then she looked at Love, stared her down, and gave her the little black woman, whatever thing. Look, man, hey, it's uncalled for. It's totally uncalled for. You know what I'm saying? And what do you need to record for? And you talking about you need to do this for exposing the corruption. Look, we already know it's corrupt. We don't need no more exposure. It's already exposed. It's a matter of, is the judge going to rule fairly and correctly? And so far, we don't have a lot of confidence in Miss Whitaker. So far, I'll say one thing: she is she's playing this very fairly. To be honest with you, she's not picking a side, and she's also not trying to appear to be unfair either, which is really technically her job. So as judges go, she's actually doing what she's supposed to do, which is to keep us all guessing. You know what I'm saying? Keep us all guessing. I think court is gonna start at 9:00, but watch this though. Let's check out what former President Donald Trump said about the quick 17 seconds. Quick 17 seconds. Check this out.
Are being all terrible. They're going after him. And I hear Young Thug is being treated. I heard the name.
Yeah.
I heard it from other people where they say he's being treated very unfairly.
Very unfair.
So he's got to be treated fairly.
Please.
Or being all
Ain't this something, man?
going after him. And I hear Young Thug is being treated. I heard the name.
Yeah.
I heard it from other people where they say he's being treated very unfairly.
Very unfair.
So he's got to be treated fairly.
Please.
Okay. Now, I got a question for everybody. Do you think if Donald Trump becomes the president again for the second time, do you think he would grant if everything goes if everything goes to the point where he goes to jail, right? Let's say Young Thug goes to jail for a long time, and would you think that he would release or try to get clemency for Young Thug if he was if he became the president? That would be very interesting because he has given a lot of people clemency before and released them early, especially for nonviolent offenses. He's too old to be running for president, not to mention his 34 felonies. Jesus Christ, here we go, man. Oh my God. He's too old to be running for president. Okay. Well, how would you want your president to be? How would you want your president to be, AJ? Old and competent or young and young and crazy? I mean, which one you want to take? It depends. So would you going to vote for Kamala Harris? AJ, you going to vote for Kamala Harris, man? She's a better fit. Excuse me, guys. Just taking care of some business real quick. $30 to $60 for 80 is too old to drive, let alone be president. 30 to 60. Okay. But is he you know he was the president already though, right? So he was the president before, man. Like people keep forgetting. Like this dude already ran the country, man. So I don't know, man. You vote for Kamala. Oh, okay, I see what's going on. Gotcha. Okay, hey man, everybody got their own. Everybody got their own choice, man. Ain't nobody mad at that. Nobody mad at that. Oh yeah, they did. They changed the time. It is at 9:00. So hopefully we get some good stuff going on here. This trial. What do you think about this trial today? What do you think will happen today when it comes to this trial? Let's see. I wonder what's going to happen today. You think we're going to get an actual motion, an actual order on these motions for mistrial today? You know, we talked about it yesterday about how we don't understand her logic in a sense where the judge has people doing things as if this trial is going to continue, but also but she hasn't made her decision on mistrial or not, you know. So it's like, okay, what if they doing all this work, all this more you know, unpacking things, doing all this, and then all of a sudden they still say, okay, well, it's a mistrial. I mean, all the things we had to do, all these meetings we had to have, all these things we had to come up with means nothing, especially for the prosecution. You know, it's on them. It's their time. They're the case in chief. It's their burden of proof to prove. They need to do this. Clean slate. What up, though? Good morning. Good morning. AJ said more fact checking from Judge Whitaker. I feel that. I think so. For sure. It's going to be a lot of fact checking for sure. It's going to be a lot of fact checking. I can see that happening for sure today. I believe we have another witness from the DA side of things. I believe they're trying to disprove the fact that there was any type of Brady evidence, any type of Brady violations that happened in the ex parte meeting on June 10th that was off the record. That's what Kayla Bumper said. She did mention, I think the only valuable thing she really said the whole time was the fact that off the record, Woody said something about the Infinity and about who unalived Mr. Thomas, and about he knows who may have possibly who has done it. So that information was not revealed to the defense at all. All right. And so we're gonna see. We're gonna see what she does with that and see if she even believes that. But Miss Love has someone coming in. They couldn't come in yesterday because it was like 40 minutes away from court. So they couldn't come in yesterday. But she said something about a person coming in. All that. Good morning to She Lee. And everybody put a She Lee in the chat real quick, man. She is such an awesome person, man. She cashed at me for her monies for her membership. But she just did she just was rocking out with me yesterday, along with Ricky E. Everybody pretty much in this chat, man. You know what I'm saying? Everybody just rock. I really appreciate y'all, man, for real. I really, really do.
The position that alleged violations of the rules of professional responsibility are sufficient to support disqualification. For a couple of reasons, Your Honor, I just ask that the court allow us definiteness on what grounds the court will continue to hear motions to disqualify. I know that we started out with the witness, that we were a necessary witness, and then after the June 7th transcript came out, there were other grounds. And today I'm addressing the ones that have been proffered by the defense. But my take on Ford is that it, like Piedmont Hospital, which Ford cites, they're both obviously cases regarding civil matters. And I think, Your Honor, that it's interesting that both of them also involve conflicts of interest. There are cases within the state of Georgia that do involve disqualifying prosecutors in criminal cases. And of course, there are, two general grounds. We've addressed that in a previous response. But as it relates to this, our position is that all that Ford does is addresses whether two attorneys who appeared pro hac vice violated the professional rules. And it specifically authorizes the trial court to consider those rules when considering whether to revoke the pro hac vice admission. That is, the question was whether the attorney who is not a member of the Georgia bar would be allowed to practice in Georgia. And of course, that's not the issue here. Ford cited Piedmont Hospital versus Reddick, which had held that it was appropriate to consider the professional rules on a question of disqualification. And one of the claims at issue in that case was whether an attorney for one party violated the professional rules when it contacted another party's board members and employees. And if true, that was something that the trial court could consider in a motion to disqualify. The Court of Appeals emphasized that the right to counsel is an important interest, which requires that any curtailment of the client's right to counsel of choice be approached with great caution. Disqualification not only curtails a client's right to counsel of choice, but results in expense and delay that are costly both to the client and to the administration of justice. And they go on to say that courts have been reluctant to disqualify an attorney despite misgivings about an attorney's conduct, perhaps because disqualification has an immediate adverse effect on the client by separating her from counsel of her choice. And that's Piedmont at 76 through 77. Finally, the court held that a party did not have standing to base a motion to disqualify an attorney to file a motion to disqualify an attorney based on a conflict of interest violation that did not involve that party. In Piedmont Hospital, the claim which was rejected was one entity's claim that an attorney was disqualified because of a conflict of interest where that entity was not in an attorney-client relationship with the attorney. Here, Your Honor, the state did not violate the professional rules of ethics. We didn't violate Rule 4.2A regarding communication with an unrepresented person. The court has heard the testimony of Mr. Melnick in the court can gauge the credibility of the witnesses after Attorney Melnick informed the state that he represented Mr. Copeland. The state had no further conversations with Mr. Copeland about the subject of this case without either Attorney Melnick or Attorney Bumpus present. And in its response to Mr. Melnick's email, the state agreed it wouldn't communicate with Copeland further, but noted that we had arranged for transportation and that an investigator would pick Mr. Copeland up the following morning for his court appearance. So that interaction was to bring Mr. Copeland to court as we had previously planned. For the reasons that we've stated in our prior filings, the hearings in chamber were proper. And even assuming arguendo that the court concludes otherwise, the state acted in good faith based on its understanding of the law. Indeed, at least 2 judges so far have concluded it was not improper. Disqualification is not an appropriate remedy under any event, especially given all of the circumstances here. We would ask that the court deny the defendant's motion to disqualify, and if there are other grounds, we would ask that the court, if they bring other grounds, we would ask that the court require that they list out all of the grounds that they're seeking so that we can address them at once, with Your Honor.
All right. Well, I think both Mr. Weinstein's and Mr. Shark's motions that are pending right now, Mr. Weinstein's for a mistrial and Mr. Shark's for a fair trial, set forth additional bases and suggest that as one of the potential remedies or grounds for relief. So I think the state has filed a response to Mr. Weinstein's motion on behalf of Mr. Kendrick. I don't know if y'all filed a response to the supplement, and I don't think I've seen a response to Mr. Shark's amended motion for a fair trial. So
That filed Friday.
yeah, that was filed Friday, and I'm not quite sure when the supplement was filed, sometime last week.
Okay.
So if y'all want to get something to me, can you get me something? When can you get me something?
Is Friday too late?
You can get me something by Friday.
Oh, thank you.
Okay.
Oh my gosh, she gets so much grace, dude. She gonna go on AI lawyer and do another motion,
All right.
do another response like she did before.
And so I assume you have made the determination not to present any further evidence on that one issue about whether the state was aware of the proposition that Mr. Melnick might be representing Mr. Copeland. Is that correct? Okay. All right. Yeah.
One more thing. We did receive the communication from Mr. Steele regarding proffers, and if an attorney rejects a proffer and insists on evidence.
With regard to Copeland or?
He said generally it may
Oh.
be specific.
Oh, yeah. Oh, okay. No, proffers from an attorney. Okay, yes. Mm-hmm.
And so to the extent that that is the way that that we would move or operate, we would to therefore require, if we're gonna put up evidence, we're gonna put it up. I don't know how the court views proffers, and
Well, I mean, I think that the case stands for the proposition that proffers are fine unless one party objects, in which case then you need to present evidence. And so
if that's the case, we would ask to any circumstance where it's proffers, we would, if we have to put up evidence, we don't want to be dueling proffers with evidence. If it's evidence, it's evidence. But where proffers are okay, I'm okay with that.
okay, thank you. All right, how about on the discrete issue of the phone calls, jail calls?
Yes, Your Honor. So I went back and reviewed what all we covered. So
Okay.
got through the 5 jail calls the state intends to introduce Mr. Copeland. And I also confirmed and spoke with Mr. Sharp.
Cameraman, you were on for that, dog.
That we handled those jail calls related to Mr. Copeland on Friday.
Okay, I'm sorry. I just thought there were like two things outstanding that y'all said, let us huddle and then we'll get back to you.
Yes, Your Honor.
So I'm incorrect in that recollection.
In relation to the
Jail calls.
jail calls, yes, Your Honor.
Okay. So, okay. Well, can y'all do me a favor then and refresh my recollection about what it was that was decided about the jail calls? Because I don't remember y'all putting anything before me. Did y'all just come to agreement, but y'all haven't told me what that is?
Your Honor, there was some that we agreed on, and there was other parts where, like, for example, one of them was Detective Gaither. You asked if we could, basically we either agreed or redacted or argued those 5 calls. And it was at the very end on Friday.
Okay.
You need to turn your mics on.
Deputy Hilton had the notes from that, and so I will work on, and we'll get those notes from Deputy Hilton.
Okay.
Captures what all we discussed in our.
Okay. All right, so then moving on to our next issue. Yes.
Good morning, Your Honor. Good morning to everyone. I agree with Mr. Atkins. We spoke last night. I think that the only outstanding issue on the jail calls for Mr. Copeland, the 5, was the redactions, and the court ordered us to look at it and then bring up any other issues with your court. So that's what I have in my
And
notes. And I
that's
think,
what I'm talking about.
and I think,
So,
yeah, but I don't think that the state or us have done that redaction yet. I think the state was trying to do it. If I'm wrong, Mr. Atkins, please correct me, but that's what I thought we discussed.
Yeah, and so right when we left court yesterday, when we and Mr. Shard spoke about the jail calls, and remember I had asked, we covered everything with it and we were in agreement. Yes.
That's right. And then the only thing we have to do is the redactions, and we have to look at them. That's my
yeah, so I think that there was, I mean, I've got highlighted now, I made a ruling on those things. So, okay. So, but yes, there was still something outstanding y'all needed to do. So
Yes.
those 2 little pieces of redaction, I think. And y'all were going to get together on that and figure out whether you could come to agreement.
Yes, Your Honor. I will speak with Mr. Steele and Mr. Shard. I guess there was some miscommunication because we spoke yesterday afternoon and thought everything was.
It wasn't no miscommunication. She said this yesterday. Talk to each
Okay.
other.
All right. Thank you.
No miscommunication. You didn't talk to each other. Ridiculous.
All right. So then our next sort of big topic we need to sort out is what, if any, part and how we're going to handle the fact that Mr. Copeland gave testimony prior to the motion for recusal and then further testimony following the motion to recuse. And we all kind of agreed, okay, things that occur after a ultimately granted motion to recuse basically need to be redone. But if everybody can come to agreement as to, you know, these things, these parts of the testimony are okay anyway, then y'all can by agreement say these parts are okay and we can move forward. So have y'all gotten together now that I believe you have all of his testimony thus far to decide what, if anything, you think, how to handle it and what you think might need to come out, if any part?
Judge, we had been in communication with the defense, and I believe that the last time that Ms. Hilton spoke with Mr. Sharp, that they were representing the defense would get together and see if they came to some collective understanding about what it was that they wanted to stipulate to and get back with us. But if I read correctly last night, they indicated that everything beyond the point of Mr. Kendrick's motion, they wanted to do over. If I read that wrong,
I don't know. I mean, if y'all had email communications overnight, I don't know what those would have said. But does somebody want to represent to the court what the defense position is, if it's a joint position?
Your Honor, I can speak on behalf of Mr. Williams, Mr. Stillwell, and Mr. Kendricks. The stance is that everything post the recusal needs to be redone.
Okay.
Just because we feel that that's the applicable law, and that's where we're at.
All right. What about Mr. Matthews? What's
Good morning to the court. On behalf of Mr. Healy, we are in agreement that everything posted in the future file should be taken from her.
okay? And then Ms. DeWilliams, what's y'all's position? Speak into your microphone, please.
Oh, thank you. How many times I got to say this?
Same position as Mr. Matthews, Your Honor.
Okay. All right. So I've got another question for the defense, and that is, I think that everyone has joined into the assertion in both of the pending motions that I mentioned before that the William, Stillwell, Kendricks, Huey, Ryan. Oh, guess, I don't know. Sorry. Nichols.
Clearly the forgotten person in this case who should be severed and who continues to object to the admission of any of Mr. Copeland's testimony against Mr. Nichols. So our first position is we object to the admission of Mr. Copeland's testimony against Mr. Nichols. Second position, that if it's admitted, it comes in with a 105 instruction.
All right, I've asked you a couple of times to give me a proposed one.
Yeah, we have it. We
Okay.
have it. We're going to give it to you prior to the time the jury comes in, if it comes in, because that's still outstanding. And
Okay.
And number three, we would, as the third layer, and alternatively, we would join the motions on the floor.
Okay. So on the proposed limiting, I mean, jury's coming back before too much longer. So go ahead and get that to me and the state so that we can contemplate language and whether, I mean, I think it would be appropriate to give, so, but don't wait till the evidence is coming in. Give me a chance to look at it beforehand.
Assumes the evidence is coming in, and I don't make that assumption since the motions are still outstanding.
Exactly.
I'm trying to cover things in terms of eventualities and, you know, conditionally and things like that. So I understand that. I hope you're not chewing gum. Are you chewing gum? Okay, great. No chewing gum in class. All right. So it's my understanding that everybody has joined in the position that Mr. Copeland's testimony was coerced based on what occurred during the June 10th ex parte. So, and yet I know at least some of you want that testimony and said that yesterday. So are you waiving the issue of its potential coercion?
Good morning again, Your Honor. I am not waiving that
All right,
issue.
so then how do we handle that?
I thought it's two-stage. I was answering your question. If Mr. Copeland's resumes testimony, then my understanding of the rule is, or the law, is the way that the court announced, and I think all parties understand it, that once that motion by the Honorable Douglas Weinstein was filed on the 12th, everything thereafter is excluded and we redo it. And that's what we, Mr. Atkins sent an email last night. That's what three of us responded to. I don't want to waive, though, the issue. I thought we should have a hearing with Mr. Copeland to determine did that in camera, if it's in camera, ex parte rather, June 10th meeting, did you feel intimidated, coerced under the Archer case, which from Maryland, I know it's from Maryland,
Right.
that we discussed? And if yes, we were going to ask you then, if a witness was intimidated, that he should not have to test. If, you know, he could choose what he wants to do, and then we would strike everything he said.
Okay, well then let's go ahead and find that out. I mean, can you get him here so that we can explore that issue? Because here's the thing is that, yeah, if, you know, everything after June 10th, whether the recusal motion was filed or not, that's kind of a separate issue from whether his testimony post June 10th ex parte meeting was coerced. And if it was coerced, then what then? Do we, then how do we still say, oh yeah, but I want, you know, some of that testimony? That's still good.
I thought you, and listen, I have so many, you know, going on. It's just the reality of our case.
Yeah.
But I thought you said that either yesterday or last week, that we will find out whether Mr. Copeland actually wants to testify, continue testifying. And then if he doesn't continue testifying, my understanding of the law is then he would never have been given an opportunity to be cross-examined.
Right.
And therefore you strike all of his testimony. Then you give the command to the jury that wipe out everything that you heard, saw. There were writings introduced, all exhibits are struck, give me your notes.
Right.
That's what I thought. Now,
Okay, I just didn't understand because, you know, and thank you for clarifying, because what I was trying to sort out is, are y'all kind of taking the position, it was coerced, you know, we have to redo all of it based on the coercion, but then also, yeah, we want to keep parts of it anyway. So if it's a, yes, if it was coerced, then we need to redo all of it. Or, you know, find out, does he at this point kind of redo are you intending to take a stand and testify, or are you going to be held in contempt?
that's what I thought.
Okay. All right. Just so sounds like, well, then we're on the same page. Just wanted to make sure y'all weren't wanting it kind of both ways. Ms. Levy, you look like you want to say something.
I was trying to get a full grasp, Your Honor, on everything that was being said. And when I hear that we're looking into whether or not his testimony was coerced, of course I'm going to defer to the court. I would object to that for several reasons. One of which is that the court has had an opportunity to review what went on there. And I believe that based on what is there, right there on the transcript, the court can see, and I believe could make a determination that there's not coercion. So based on the way that the witness has conducted himself, and based on the concerns that we have expressed, the concerns that the witness expressed during prior interviews before I even came onto the case, I would ask that the court not revisit or go back and see if have a hearing on whether or not he felt coerced.
Okay, so this isn't a revisiting of the issue because the issue is live and still pending before the court in Mr. Kendrick's motion and supplemental motion for mistrial, and in Mr. Shart's on Mr. Stillwell's behalf. revised motion for a fair trial. That's a big claim in both of those motions. And I mean, I just gave you to Friday to respond to them, but and yeah, I think that on the record, it's a legal determination to be made. We don't necessarily need to hear from Mr. Copeland because I'm not sure about Mr. Copeland's credibility on anything anyway, but.
And so for those reasons, I would ask the court to not have us bring him in before that time that he has to testify. I'd also point out that his counsel was present.
I know.
So thank you for hearing me.
Okay, well, I mean,
Sit down, lady.
I hope that it is not up for debate that some of what was said to Mr. Copeland in terms of potential ramifications if he didn't testify was incorrect. I don't think that there was any kind of, purposeful or nefarious motive in that. But I mean, at least with regard to the notion that he could be held until the trial of even the severed co-defendants was completed, I don't think is a correct statement of the law. If you believe that it is, then please provide me with what you're basing that belief on. But I mean, I also don't think that he paid much attention to that at all. He doesn't even seem to have, he kind of basically moved on from that, but that was incorrect. I think that some of the assertions about statute of limitations potentially were incorrect. I don't think that with regard to he seemed to be worried about a particular crime, the statute of which had apparently already run. But I think that in terms of the notion that he faced no potential jeopardy with regard to crimes based on statute of limitations. I mean, there's the immunity issue, which is wholly separate, but y'all are basically saying you don't even have to worry about it for the statute of limitations reason. They're saying, well, then how are we sitting over here charged with RICO for crimes, the statute of which, when the statute has run on the overt acts that are in support of the RICO. And I can't remember right offhand what the other potentially incorrect statement was about. But I mean, some of the this is or isn't perjury things are a little
Lies.
I don't
They're
think
lies.
quite exactly
Jesus,
accurate
just say
either.
it. They lied to the man.
Okay. So I guess what I'm saying is you run a lot of risk, even if I say it wasn't coerced, if that is the legal determination I make. I mean, I'm saying it's a really close call. And it might be better to just pretermit that issue and deal with it a different way.
Okay, so when that took me to the question I had yesterday, that I thought I had gotten completely wrong with respect to the motion to compel that we had filed. Because if we got to a point where he's trying to not testify, we would of course ask the court to compel him to testify. And the things that have happened. And he was, as I said, represented by counsel, as of course I already acknowledged. But I do understand what the court is saying, and I will respond to the motion.
Okay. But I don't want to be dealing, and I can give you to Friday to respond, but I don't want to be us having no idea what we're going to be doing Monday morning. I want it sorted out this week. And your motion to compel was filed when? To compel his testimony. I mean, that was Yeah, and the order was entered on the 7th, and I don't think there's any issue that can still be in effect. I don't think we need to redo that. If you want to redo it, and I'll consider it anew. But, I mean, the more prudent course would really be to just bring him in here like tomorrow and say, and if anybody wants to come up with, he's probably been advised ad nauseum about everything at this point anyway. But given that I just said, I think some of it's incorrect, a correct advisement of here's what the issues are, here's what you potentially face. And we're going to do it in court with everybody in front of us. Y'all can have some input on what he is advised of. Does he have counsel currently? I know he's gotten rid of Mr. Melnick and Ms. Bumpus at this point.
Yes, that's correct, Your Honor. Mr. Melnick withdrew representation. His Bumpus was fired, so no one has said anything to us
Okay.
about a lawyer on his part. So we are unaware of whether he has any
Okay.
representation. And I'd also point out just that since he is still under that immunity grant from the state, it's my position is that anything what he testifies about would not subject him to criminal exposure. We can't use it. We can't go out and.
Yeah, and I agree that with regard to the immunity, he doesn't, but it's because of the immunity. It's not because there's some statute that protects, some statute of limitation that protects him from criminal liability. It's the immunity that would protect him. And he was not exactly accurately advised as to that, I don't think, at least potentially. Okay. So, I mean, I just think it might be cleanest to give him correct advice as to all of it and then find out what his intentions are.
Or you could make
Would that
you
work
could
for
actually
everybody?
rule on something.
Can I get an affirmative if that is in fact the case, not just a, like on the record, yes, if it's a yes.
I'll be back to Mr. Williams, yes.
Okay.
Yes. Yes, Your Honor.
Yes, Judge, with the caveat that no party, no state, even though they say it's our witness, not have any communication with that person.
They need to use their microphones.
Which he still is, presumably. Thank you.
Okay.
And Your Honor, with respect to Mr. Harvey's request of the court, I would openly request that the court allow us, because like we have had to transport the witness, I'd request in front of everyone that the court allow us the opportunity to continue transporting him, doing as we have been.
I mean, he's under your subpoena. Y'all are the one that needs to get him here, but no substantive conversations. Understand?
Yes.
Okay. All right. And y'all think you'll be able to achieve getting him here tomorrow?
Your Honor,
Can you get him here this afternoon? I mean,
Yeah, get him here.
no, that's fine. But can you get him here tomorrow?
I believe that we can.
Okay.
And Your Honor, how much inquiry is the court going to allow or examination?
We don't need to examine him about that. What we need to do, I think, is, given everybody has agreed, is just properly advise him as to what the immunity order means, what the consequences or potential consequences of refusing to testify regardless of the immunity order mean, and find out what his intention is. Okay, so I would love to get from y'all a proposal on what to advise him of. And let's let everybody kind of agree to it before we do it. And then it might not be a bad idea to have counsel for him. I don't know whether he's going to want to hire somebody, or whether he is, I mean, he's not a criminal defendant, so he probably wouldn't be entitled to counsel from the public defender's office, but maybe I can find somebody willing to take it on, whether he can pay them or not. I don't know.
So, Your Honor,
Suggestions?
Your Honor, when the court just said about compelling him to testify regardless of the immunity order, we wouldn't seek to compel it without it because there's potential criminal exposure.
No, I know. I think you might have, I didn't mean to say that. The consequences if he does not testify despite the order. Any ideas about counsel? I mean, I think he's probably entitled to counsel if he wants it to advise him. I don't know. Hadn't done the research on that one.
Your Honor, on behalf of Mr. Williams and I think the rest of the defendants, it seems to me most appropriate for the court to at least inquire of Mr. Copeland himself, whether he is currently represented by counsel or not, and or what his intention is if he is not.
Sure. I mean, yeah, I agree. I guess I can't find that out before he shows up here.
I can have someone who just bring him in. We
Okay.
know where he is, so I can actually ask.
All right. I mean, yeah, if we can find him and even, I mean, I don't care if he shows up by Zoom for me to ask those questions, you know? I mean, that's fine with me.
I got Woody. I represent him, man, for sure. You have the right to remain silent. No,
All right. So
no, man.
if he ultimately then says, yes, I'm fine with testifying, then does everybody want to start everything over, have me tell the jury, we're doing a do-over to all of it and start over with him? Or then do y'all want to agree to using some portion of what he's already testified to, some or all of what he's already testified to pre-recusal motion? I can't hear you. Y'all can think about that for a few minutes. Ms. Firstfields let me know that the 6/12 transcript, which was the last outstanding transcript of his testimony, has just been completed and is getting mailed out to y'all, emailed out to y'all. All right, so y'all think, ponder, and in the meantime, do we want to move on to the whatever motions in limine there are about Mr. Zachary? I think you said you had at least a good portion of that ready.
Yes, so counsel for Mr. Stillwell sent over a series of redactions that they'd like to see made, but we have objections to those, and so that is
Okay.
criteria.
All right. That sounds good.
Would the court permit me to just step out?
Sure. Is Mr.
Yes.
Atkins going to take it from here while you're
No,
out?
I'm just asking them about Mr. Copeland and seeing if I can get him on the phone and get an answer to the court today.
Okay. All right, so the Zachary evidence, can somebody provide that to the court? Whatever we're going to be
Yes, Your Honor.
sorting through?
I'll send the transcript from this interview, Your Honor, and if any defense counsel objects, I can send what Mr. Sharp sent us so the court knows what we're
walking through.
Yes, Your Honor.
That'd be great.
Because it's broken down by numbers.
Okay, good.
And does the court already have the transcript?
I did. No, but Mr. Atkins just said he'll send those.
Just tell everybody to keep their
Your Honor,
microphones
the
on.
transcript, they are
Okay. Yeah, and maybe pick up your mic. And y'all, I'm trying, I think I told y'all yesterday, I'm trying to get longer stems for these, but
I didn't even turn my mic on, so I didn't even get through step one yet. So it's now on and I am holding it. Mr. Atkins, Miss Love, Mr. Zachary's statement, his statement that I did not review yet, or I've reviewed it, but I haven't given you the total redactions. Are you planning on playing if allowed, the part where he talks to the AT feds about the guns?
It's possible, and there were two statements.
you should talk into the mic too, so everybody can hear you.
I keep remembering how loud I am. It is possible, and there were two. Yeah, I think yesterday when I spoke, I was expecting one more from you. There are two: the 2015, the August 2015 one, and then I think it's the March 2017 one. And we have your redaction request for the I think the August 2017 one. So, do you mean for both of those, or are you just asking about the March 2017 one?
The transcript doesn't, I don't believe, say what date it was, but the time he talked to the federal agents after speaking to Investigator Gaither.
And so when you say put it in, I wouldn't, outside of impeaching him, I wouldn't have a need to put in all of that. I would be asking the witness on the stand about that. So I can, with the court's permission, I can break away and talk to you about exactly what it is that you're concerned about.
Okay, well, I'm gonna send over my proposed redactions for the statement to Investigator Gaither, with the understanding that I didn't list out any redactions for the discussion with the federal agents.
Okay. So you're sitting over the 2015 one, and then,
Yes.
okay.
All right, so there's one that has been done completely, the proposed redactions, right? So we'll just start on that one, and then I'm sure we'll have a morning break at some point. Y'all can maybe, if you need to huddle more on the another one, then that's fine.
Thank you.
Yeah, I'm a bit confused too, about this. We need to just hear him out for a second. Because this whole thing about Rudy testifying and throwing his testimony out after the first recusal motion is interesting. And I think, again, she needs to look deeper into the coercion. You already know this stuff was incorrect. Incorrect is a lie. So they lied to this dude to get him to testify, and then slapped the immunity on top of it to force him to testify. That's coercion. And then threaten him with long jail time. That was absolutely incorrect. That's coercion. I mean, that's prosecutorial misconduct, man. And the fact that we are not getting a ruling on these motions
Transcripts of
is irritating.
Zachary's potential, I guess it's statements over Ms. Percefield, or?
Yes, Your Honor, and I was gonna also inquire, we have an extra physical copy of the transcript, if that
Right.
works for the board.
Sure.
And then I will just email the redaction chart that we discussed.
Okay. Waiting on that to come through, and then we'll get started.
I don't even see the need of why we even doing this. Honestly. She's not even fact checking today. She's not doing any of that. She is just, let's just do work as usual. Then I'll figure out if I'm going to continue this trial or not. No, you need to do that first. That's priority number one. You already did. Yesterday was enough testimony, was enough fact checking that you need. You got transcripts that you live and breathe by. Everything that you're doing, you got it written in front of you. And on top of it, you got witnesses saying that hey, this was happening. Body cams was turned off. The body cams was turned off. Jeez, oh Pete, sitting up in court doing nothing. Now we worrying about somebody's testimony and evidence, and like, for what? For what? Ms. Love is unprepared constantly. The defense is like, where do we go from here? Where do we go from here? That's what exactly what Bruce Harvey is even saying. Like, I'm not going to do anything without you ruling on those motions yet. Like, I understand what you want, but you haven't even ruled on the motions yet. So we don't even know if we're going to continue in this direction in the first place. I know, man, Ricky E, I know, man. There might not be no mistrial. That's what I'm saying, man. This is absolutely bad, man. This is all bad. This is all bad. This is all bad. Maybe it's me. Maybe I'm too much right now. I don't know. But this is not good. You mean to tell me that you got prosecutorial misconduct? You have more evidence of that than you have of RICO evidence. You don't even have RICO evidence. You got evidence of prosecutorial misconduct, though. You do have that. On all levels. And I don't think, and another thing too about Miss Love, I don't think Miss Love read those motions at all. I don't think she read them at all. I bet money she didn't read them, boys.
All right, do you want to hand up the hard copy of the transcript? Because I don't have the electronic one quite yet, but I'm sure it'll come through at some point, but we can go ahead and get started with the hard copy. Wow, that's a lot.
That's the transcript, Jesus.
This teal colored one is gonna be what we're gonna discuss first.
Okay.
The red may come up later.
Put the red to the side right now, though.
Perfect.
Thank you.
Mr. Atkins about to be a defense attorney in a minute. Watch. Yeah, I'm sick of these chicks. I'm out of here. I'm done. I'm done, dog. What are y'all thinking so far? Well, yeah, am I tripping? Am I off? Like, all of this is just crazy. Another mod is in the building. What up, though, Drea? She's saying, "Hey, everyone." I'm a spot on. Sheely, thank you. I thought I was tripping. D. Peel Amon, a member of the channel. What up, though? Good morning to everyone. She says. I thought I was tripping. She was saying, "Nope, you're not
Ready with
tripping."
the first one on, that's, I guess, page 11, lines 10 through 12. Is that what that means? Or is that a timestamp?
Your Honor, that is correct. There was a couple Mr. Short had that, for the most part, I could follow. So if there's a discrepancy, I may ask Mr. Short specifically what line he wanted, but I believe for the first one, that is correct.
All right. And is this mine to keep, this teal one?
Yes, Your Honor.
I can write all over it if I want to.
You can highlight it, write it.
Okay. All right. So, Mr. Sharp, the document that I'm looking at that says Quindarius proper session proposed edits, and it's all numbered 1 through whatever. Okay, so where am I supposed to be looking with regard to that first one? Because it's a lot of different numbers. I'm not sure what they all mean. Okay. I see him 11, 10 through 12 means page 11, lines 10 through 12, but then it has 10 again, which I don't know what that 10 is, and then
Just saying.
It should be when it ends. So it would be like 10, I'm pulling up my document.
okay. It is, sorry, go ahead with what?
So that first one would be. That first one would be page 11, line 10 through page 12, line 10.
Okay, that makes more sense. Gotcha. All right. And is one of the objections to all of this going to be these aren't proper under the co-conspirator exception?
Well, not everything that he says in these sessions is based on what arguably a co-conspirator said to him. Some of it may be, so some objections may be it's improper character evidence, it's irrelevant, things of that nature.
right.
But there is a lot of things that he was told, and quite frankly, Your Honor, there's some that I don't know him to have allegedly been present for something, and the source of his information is unclear. It may be rumor, it may be something he was told, and that is probably something that we're going to need to wade through at some point.
Okay. All right, so the very first one is, I'm about to tell you something, and I've just said I wasn't there.
That's in page 11, line 10.
Right. So it's obviously hearsay, so what's our exception?
Your Honor, part of it, when he's saying that he's at Crucial,
No, he's saying I wasn't at Crucial.
when he's saying I was not at Crucial.
Right.
And he can't speak about being at Crucial.
Mm-hmm.
I don't have any objection to him speaking about or trying to speak about being at Crucial. I don't have any objection to taking that out.
All right, so are you good with the redaction of 11 line 10 through 12 line 10? Have you had a chance to look at these proposed redactions yet?
I looked at them. I haven't synced them up with my transcript and my.
Okay.
recording.
Just say no, you haven't.
Because I've read the transcript and listened to it so many times.
Okay.
I went through it with that knowledge.
Okay.
I haven't synced it up.
Boy, she is a liar, boy. Good Lord. We all know you haven't done a lot of stuff right.
Line 10. I
Okay.
don't have any objections to it. Page 11, line 10.
All right, so that's out by agreement. All right, so that one's out by agreement. Do you want to, is it, if I gave you 30 minutes, could you decide which ones you agree to? Is there something else anybody needs to take up before we take our morning break and let Ms. Love do that? All right. Anybody else? Nobody? Okay. All right. We're just going to take our little morning break early. So we'll be back at 10:30.
Guys, I don't know. Hey, look, low key. I'm not about to. I can't sit through a bunch of just preliminaries. But this whole thing is just bad, man. This is just so off. I thought. I mean, this is just way off to me. Obviously, Miss Love has not read the motions that Shart and Weinstein. Well, she probably read Weinstein's, but not Shart's for sure, because she has not responded to it at all, and she doesn't even know what it says in there because she keeps trying to defend the prosecutorial misconduct situation, but that's a whole part of their motions. You need to respond to that, not constantly saying it in court, but actually file a response. Okay, that's number one. This is another, exactly. This is what this is: wasting taxpayers' time and money. Okay, that's all you're doing. But I know what we can do. I know what we can do while they're doing that. Because she said 10:30. So what we about to do is we about to go to the Lee's channel real quick, because last night Kayla Bumper was on the lead, and she had some things to say. All right, she has some things to say. Let me mute this one. So, let me see something real quick, guys. Give me 1 second, all right? All right. This is wasting taxpayers' money for sure. Get to the comments real quick here. Should always have the correct love. Exactly. Always. Everybody in the courtroom knows a drug dealer personally in here too. Exactly. Like this is Hot Wayne. I appreciate you stopping in. This doesn't make sense. And so once again, we know that the statute of limitations in that transcript was wrong. We know that jail time that he could face was wrong. We know that the immunity that was forced on him was filed the evening before he had to testify. We know that they talked to him behind the lawyer's back. They also have asked the defense. I appreciate you subscribing, Hi Wayne. Thank you so much, man. Appreciate it. They also asked the defense for reciprocal discovery, which you're not supposed to do because you're a case in chief right now. Stop asking me, the defense, to give you whatever I discover. I'm not case in chief. I don't have to prove anything right now. So that's another prosecutorial misconduct. You've done so much prosecutorial misconduct. This is a mistrial. And let's not forget about the opening statement. The opening statement had prosecutorial misconduct when she put that slide up there and it had Brian Steele's name in it. And he filed a motion to mistrial right then and there. And she was supposed to hand over all of the stuff that she was going to use in the opening statement, and she did not do it. Miss Love never does her job right. And she gets grace after grace after grace, chance after chance after chance. It's ridiculous. It is. She could just do whatever she wants, man. And that's the part about prosecutors that's so messed up. They got more power They have so much power. Like, this is ridiculous. This is absolutely ridiculous. Okay, what I'm about to do right now is we're gonna go ahead and react to this. We're gonna react to Lead, and Kayla got on here last night on the Lead Attorney channel. This is absolutely crazy. When you put the defendant's lawyer on the stand, it's a mistrial. Exactly. If you're putting, here it is. This is your witness. Woody is your witness. Okay. Woody is your witness. You putting look, man, defendant's lawyers. Come on, man. That's crazy. That's crazy. Anyway, let's go ahead. Wait, that was funny. Let's go ahead and watch this real quick, man. This was absolutely interesting. Remember, Kayla Bumpus decided they gave her, according to her, it was last minute. It was like 5 minutes before she had to hit the stand, but she decided to testify anyway because, according to her, she wanted to expose the corruption in Georgia, whatever. All right, this is what she said she wanted to do. But here we go. This is the Lead, and Kayla's going to come up in a minute.
Do you recall what was being talked about when Deputy Brown told the sheriff's deputies to turn off their body cameras?
Nothing. That was the first thing that he said when he walked in the room.
And at that point was Ms. Hilton, you, Mr. Copeland, judge, court reporter, and DA's office investigators.
Oh,
wait.
I don't remember
right
who was in
here.
the room. It may have just been me.
We got Kayla in the house. Let me drop the link, man. Shout out to Kayla becoming a member. We got attorney. Somebody write Kayla in the damn chat. Kayla, I'm gonna drop this link, man. See if you want to come up. This is crazy. Everybody was streaming on this today. Your boy was out. Now I'm back in. And God damn, shout out to Kayla. I'm gonna drop the link. See if she want to come up. But shout out to Kayla. Let's keep it going. But let me make a link for our girl here. Should somebody write Kayla in the damn chat?
So it may have just been you when Deputy Brown said to the sheriff's deputies, turn off your cameras?
I don't remember exactly who was sitting in the courtroom.
But that's
in the
chambers, but that's possible?
It is possible.
It's possible it might have been when you and Mr. Copeland were just in there together?
It wasn't.
Well, Mr. Copeland had to have been in there, right? Because you said the deputies didn't show up until Mr. Copeland arrived.
No, what I'm saying, Judge, is that was the order as he walked in.
Right, but what did you say might have just happened when it was just you?
Nothing. I was saying I may have been the only one sitting there. I can't remember, but there wasn't like, oh, step out. It's as soon as they walked in, this is what was said as Mr. Copeland was walking in.
And was there any, did you request at that point that they brought him in to have a private meeting with your client at the time?
At that moment, I hadn't requested anything.
All right, let's pause it right here. We got key witness Kayla up in the dang chat.
I don't have time to play with you. They say you went over here being mean to me. So what you been saying?
I ain't mean to you, girl. I'm calling it straight though. You up here talking about she, them, they, and the judge don't know what the hell's going on.
Okay,
Am I right or wrong?
In the middle.
No, I'm right. All right. So we just call everybody watch this, but I was busy today, so I couldn't watch it. So we are.
Okay, let's pause real quick. Why is the Lead saying this? Remember when Kayla was testifying, she kept saying they, us, whatever. And what Lead was saying last night, as far as like how to testify or how to speak, is when you are actually unpacking something specifically in court, you want to use names. You want to use the actual names of the people of who was in there. Myself, Miss Love, Miss Hilton, blah, 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 blah. So that's why when he hit the pronouns, like, okay, you say he, she, them, they, and then the court is like, okay, who are you talking about? As a lawyer, you should already know how to do this. This is the whole point. You should remember what happened because it was an ex parte meeting. You should remember what happened and you should know how to testify. That's basically what he's saying. So you're coming up here saying she, they, them, thus, us, whatever, we, you know, it's like, yo, you are supposed to know how to testify at the same time. And so, exactly, Drea, exactly. Good point right here. That's why the judge was interjecting. She did not know who you were talking about. So much stuff was happening in that meeting that you have to be specific. No, like who told you? Like Brian still asks. Okay, who told the deputies to turn off their body camera? Deputy Brown. Okay, that's how you're supposed to answer. This is just like see, they do that in practice court and court of law. Exactly, law school. Look, you don't even have to be a lawyer to know that if you telling on somebody, you telling on that person. I don't have to be exactly. Listen, I don't have to be a lawyer to know that I'm having a private conversation with somebody. How many ex parte have we all had? Okay. Especially like you and your homegirl, you and your homeboy, y'all talking about somebody that y'all both know or whatever, and they're excluded from the conversation. That's an ex parte. Okay. That's a secret conversation. I don't have to be a lawyer to know that if an officer of the court is leading me to a judge's office and no one from the defense is there, only the prosecutors and the court reporters, I don't know that's an ex parte. I don't have the inclination that it's an ex parte. Stop playing with me. Stop playing with me. You see what I'm saying? Call the names, even down to what they were wearing. Exactly. You are a lawyer. First of all, you used to work in the DA's office. Now you're on your own doing your thing. You are a lawyer. You don't know how to retain information. You don't know how to retain information. Are you kidding me? I would not have this person on retainer. I'm sorry. And it ain't got nothing to do with her personality. I think she's a sweetheart. You know what I'm saying? She can be. Possibly, she could possibly go the other way, extreme. I don't know. Who knows? But I am not putting you on retainer if you cannot remember something that impacts my life. Okay. I need you to know what's going on. So you don't have to be a lawyer to know that you're having a private conversation with someone, or you don't have to be a lawyer to know how to remember stuff. Anybody who knows me personally, a lot of people who know me personally, because again, I'm from Detroit, but I live in Indy now. A lot of people who know me, they know that my memory is like to the T, to the detail. To the detail. I can, if I look at a woman for a long time in her face, and then 5 minutes later she look different to me, I can point out exactly what it is that's missing. I don't know if it's eyelash, eyebrow, I don't know what's going on, but something different. I can point it out. It's called observation. It's called attention to detail. You need to be paying attention. Okay. No, I didn't know it was an ex parte. It just came off rip. Okay, so what? You a lawyer. This is what you do. This is what you do. So don't come in here talking about somebody being mean to you and all this kind of stuff. And he halfway right. No, the lead was on point last night. We're gonna go back to if we got enough time, because it's 10:09. We're gonna go back a little bit to what the lead was saying, because we said this yesterday. You know what I'm saying? We said this yesterday, yo. So let's keep watching this.
Are replaying it now. And it's interesting. And I'll be honest with you, when you first came on here, up until the day, I'll be honest, everybody loves them some Kayla Bumpus. Everybody. I didn't want.
Hold on, Sheely. Hold on, for real. Well, answer if Miss Love needs to wear a Spanx. Yes, she does. Okay. That thing is thinking. All right. I got you. she need to put it all together. You know, she need to put it all together. You feel me? I got you. Abundance in another mile. What up, dog? Oh man, let's go. That's funny.
Watch this today. I don't know what the hell happened. Can you tell us why the big change? What the hell is going on? Like, why is it? It seems to me that there's been a turn. Like, you know, what happened?
Well, I don't think there's been a turn. I think there was a temporary turn because, you know, the internet, they like to hear one part and then run with it. But I think as soon as the other person testified long, that they came back to me. I saw so many people saying, oh my God, Kayla wasn't lying. You guys have to forgive Kayla, like all kind of things, because he got up there and said everything that I said.
I saw that in my chat too. I saw that today in my chat. In the afternoon session, people were a little bit more understanding.
Did they think you were lying, or like what was the initial reaction?
Yeah, they thought I was lying.
What did they think you were lying about?
I have no idea.
You don't recall, Kayla?
I don't recall.
I don't recall. Like, how did you know that you were going to? Because some people in the chat were saying that you were not prepared. Like you didn't know that you were gonna come up here, come up to testify. Kind of what was the situation surrounding you testifying? I'll be honest, I did not expect this when people were saying. I saw a screenshot of you with your hand up on not on Facebook, on X, on Twitter. I was like, no, I cannot believe that Kayla's testifying. That's when I clicked on a little bit of AV stream and saw that she was streaming it. Everybody was streaming it. So how did it come about that you were testifying in this case?
Well, I just was sitting in the courtroom, and I think Doug was trying to introduce a video clip of me and Mr. Copeland talking, and he gives a proffer of some information, and Judge Whitaker says, where are you getting this information from? And he says, I'm getting it from Ms. Bumpus. And she says, well, I guess she said something to the effect of, Ms. Bumpus is here. I'll take that from her. And then we go on a 2-minute recess, and then they call me as a witness.
Oh my God. And so now you're up there and you're testing. And again, my heart does go out to you because I have been in your shoes where you are covering for an attorney friend and you show up to court and all shit breaks loose.
Well, yeah, now me and Melnick are on trial.
What's that? Yes. Someone said that Melnick testified in this too, right?
Yeah. Testified before her for a few hours. So it's been an interesting morning. That was
hours?
Yeah, that was all the morning session today.
But see, they told him that he was going to testify, I think, on Friday. They literally, I did not know until 2 minutes before I got up there, but maybe 5.
Okay, let's stop right there. Let's stop right there. Melnick had time. He knew he was going to testify. And she didn't have enough time to testify. Let me ask you a question. Do you think that matters when it comes to people who actually practice law for a long period of time? Does that, if some, even if something catch me off guard, that doesn't mean I'm not prepared. Okay. Just like, for instance, what just happened. All right. Sheely asked me a question about, well, answer if Ms. Love need to wear a Spanx, right? Now that caught me off guard, but I'm prepared to answer the question because she does. Yes, you do. She needs Spanx. Okay, that's a fact. All right. If I'm a lawyer and I'm sitting in the courtroom and there is a video, my video on my channel with my former client. Thank you. I also feel expect the unexpected. Absolutely. You're a lawyer. You're supposed to expect the unexpected. Period. Period. Anything can happen in law. All right. But it's my video, it's my content that Weinstein is using to admit. And they're like, okay, the judge, even though the judge was like, well, we could just get Ms. Bumpus up here. You know why? Because she's a lawyer. You should be prepared for at all times. This is what you do. So the fact that you were not aware that you was going to be you wasn't aware that you were going to testify. Melnick knew he was going to testify. All right. I believe Melnick did do a great job, and I believe that Melnick wanted to testify as well. So, but the thing is, they're asking you questions about you and about what you heard off the record, about stuff information that you have that involves you and Woody and the people in the court. So I can't accept the fact that, oh, I only had 2 minutes and I wasn't prepared to testify. I can't accept that from a lawyer. I'm sorry, lawyers are held to a certain standard, man. Look at what Drew said. The difference is there's a different expectation for how attorneys should conduct themselves. Absolutely. Absolutely. I can't accept the fact that you only had a few minutes before you went up there to testify. You're testifying about something that you were involved in. You should know what happened around you. And I just cannot accept that. So the fact that she said, oh, well, Melanie had more time to prepare to be a witness, and then they're saying, hey, oh, he's at the okay. We got word that Woody is in the court. Okay, we got word that Woody in the court. Let's go. Hopefully, hey, they might come back before 10:30, huh? Somebody make sure y'all look out for me, okay? Look at what Shelee says. I'm sure that she has coached a few clients on testifying. Yes, absolutely. Absolutely. Again, you can't tell them what their answer should be, but you can tell them how to answer it. You could go around that, But you cannot tell me that you are a lawyer and all of a sudden you don't know how to testify. You've been doing the law for a long time, okay? Drea says, plus she has been speaking about it constantly on the YouTube street. Yes. You talk about this all the time. You talk about this ex parte. You got it to detail. As a matter of fact, you had Melnick on your first live. You had other people on your live. You had Woody on your live. You had all kind of people on your live. So you've been talking about this. You've been talking about this for quite some time, and now you don't know what to say because the judge caught you off guard. Come on, man. That's like a basketball player. That's like a professional basketball player goes to the playground in regular street clothes. You know what I'm saying? Just chill clothes. And then they're like, hey, man, you want to play? You like, oh, I wasn't expecting to play. And then you just start bricking all because you wasn't expecting to play. No, you still a professional hooper. Go hoop. If that's what you're going to do, go ahead and hoop. So at the end of the day, I don't want to hear it, man. I think that was a whack excuse, man. It doesn't matter. I'm sorry. If I have you on retainer, I'm gonna need you to know how to do some stuff for sure. All right, let's keep watching.
Yeah, and Caleb, please rectify that too for everybody to know. He had notice, but you didn't. Is that right?
Correct.
Okay.
Wow.
Doesn't matter.
And most witnesses go through witness prep. I didn't go through any witness prep. I didn't go through anything. They said, well, we just need to talk about this off the record meeting, and that's all you're going to talk about.
Oh my God, man. I'm sorry. I mean, look, with all due respect, man, I don't care. I don't care. It just happened. The ex parte just happened. You don't have to be prepped to tell the truth. You don't have to prep me to tell the truth, man. It's just simple. And he was only using 10 seconds of that video about the fact that the transcript was incomplete and there was an off the record conversation. What she said, according to what she just said, what she said about the off the record comment is true. Woody has information about the Infinity and about who unalived Donovan Thomas, and the people who did these things are not in the courtroom. That's what was said off the record. And that was something that was withheld. The entire meeting was withheld in the first place. And that portion of the off the record comment was also withheld. And the prosecution knew that. So if you know the truth, you don't need to. I was just about to say it, Dre. Look, Judge Judy says if you tell the truth, you don't need a good memory. You don't. All you have to do is repeat what the truth is. Witness prep. Witness to what? An off-record conversation that was being said that had Brady material in it? You don't. Yes. Thank you for remembering that. But the fact that you cannot inclinate an ex parte meeting is ridiculous to me. The fact that you cannot remember who was in the courtroom or in the judge office when you was by yourself, or if you was having Ms. Hilton, the fact that you don't know this, the details, it's kind of like, okay, now people are questioning your ability to be a lawyer. That's what they're doing. Nobody's saying you lie. If you're telling the truth, you're telling the truth. The truth is going to come out regardless. But I'm gonna need you to know how to be a lawyer. That's all I'm saying. I'm gonna need you to know how to do that.
So it's not like anybody put a subpoena on you. I guess it was kind of the judge kind of sua sponte saying, wow, so the judge. Now let me ask you this, because I'll be honest, and just listening to this judge is a 20-year.
Now, sua sponte at your own will, at your own risk, right? At your own discretion. Now, again, you hear the word subpoena? You were not subpoenaed. You always have the right to remain silent. Kayla, you didn't have to say anything. If you didn't feel comfortable, if you didn't feel, and that's what I'm talking about. That's the reason why I can't give her an excuse. You knew that Melnick knew that he was going to be a witness. You did not know. You was caught off guard. If you were so caught off guard, your lawyer hat should have came right on. You see this hat right here? Lawyer hat. Boom, right on. Hey, I am not prepared to be a witness. I need to be subpoenaed to be a witness. I need to be witness prep, blah, 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 whatever. This is not so spontaneous. I have the right to remain silent, blah, blah, blah. I mean, start quoting some laws. She like, no, I'm gonna get up there anyway because I want to bring some justice to the corruption that's going on. You weren't prepared. So if you wasn't prepared and you knew that, you have the right to remain silent. You don't have to be a witness. They're like, oh yeah, well, she's in the courtroom. She's right here. Well, Your Honor, with all due respect, I have not been subpoenaed to be a witness in this case. I have no details of this case at all. I don't feel prepared at all to be a witness in this case. So I could either get witness prep or I'm going to invoke my Fifth Amendment right to remain silent. What the judge going to do? This judge is one of those judges that's like, she's balanced. She's fair. I can't lie. Judge Whitaker is fair, even though she irritating sometimes with her crazy laughter, but she's fair. We got to give her that. Okay. Now that's what we wanted, a fair judge. So we got that. All right. You could invoke your Fifth Amendment right to not speak. You're speaking and people are like, wait, what? You confused the law, the courtroom, you confused your own, you even confused the defense. If you notice the defense, after they asked a few questions, they was like, no, we have no further questions. They were done. They were like, you know what, we good, we straight. We got what we needed. You know what I'm saying?
Your attorney, the judge sounds kind of stern. Do you think the judge at times was throwing some shade, throwing some shots at you? I mean, be honest.
For sure. But I think she didn't believe me. And then I think after he got up there, then she didn't believe him long.
Why do you think that the judge is so skeptical? Do you think it's because of you in particular? Do you think it's because of who y'all are kind of aligned with? Like, where is the judge skepticism coming from? Because if we look at Judge Glanville, we saw him only being skeptical on one side of the aisle. He was never skeptical of the prosecution team. He was always skeptical of the defense. Why is it, do you think, that this judge was being skeptical? And I'll be honest, I saw some shots. Like, it was almost rude when she basically intimated that you didn't even know what ex parte meant. Like,
yeah, I mean, we were both playing at that point, because what I was saying was, she asked me, when did I know about an ex parte?
Did she say we were both playing at this point? Ain't that what she said? Ain't that what the lady just said? What you mean? What you mean? Like, Woody, what you mean?
You know what ex parte meant? Like,
yeah, I mean, we were both playing at that point, because what I was saying was, she asked me, when did I know about an ex parte or whatever. I mean, like, I don't know what she asked me, but
yeah, that was
my whole thing was, I was supposed to be there to talk to my client, and they turned it into a meeting. And that's what I was trying to tell her. And there was never a time to process it until it was done.
Stop it. This is a car crash. Stop playing with me. Stop playing. Stop playing. You gotta be kidding me. You knew it walks like a duck and it quacked like a duck. What you think it is? Use your lawyer. You are there to represent a client. Your lawyer hat should be on. You're coming there to represent a witness in the biggest case in Georgia's history. Okay? Or the most expensive case in Georgia's history, according to the lead attorney. You're playing at the, we both was playing. No, ain't nobody playing with you. Vanessa Fluffy Murray says, playing. The judge is not playing and may report her to the bar. You don't know what. So you only found out that it was ex parte when Brian Steele made the good faith motion to the judge, to Judge Glanville, about this particular situation. How and what do you think was happening? What do you think was happening in the judge's office when you saw the court reporter, you saw the deputies, you saw the two investigators, Long and Hamilton, the one that be trying to get up on the witnesses and stuff. You see Simone Hilton. These are people you know. You worked in the DA's office before. You know these people. You know who Love is. You know who Simone is. You calling her by first name, Simone. You know who Glanville is. You know these people. And she started, and then the court reporter, the stenographer, is starting to type in all the stuff that's being said. What you think you in? What do you think you in? You trying to play dumb and say, well, I didn't know it was an ex parte meeting because no one told me it was. Stop it. Stop it. Stop it. Vanessa, first of all, I appreciate you watching. I appreciate you watching and stopping by Biz Nation. Says when you're an attorney, you cannot get on the stand and constantly say, I don't remember, I don't recall. That worked for Woody, but not for an attorney. Exactly. I can't really remember what happened, Judge, but you know, and that's why the judge said, no. Hey, y'all. Judge was like, no. See, we're relying on your memory. Ain't that what the judge said? We relying on your memory. We need you to remember. You was there. You was there. D. Pill says her name came up numerous of times. She knew sooner or later she would be called. She was in the ex parte. Exactly. Exactly. Okay, so at some point you was going to be a witness, because if Brian Steele amended his witness list and included Glanville, Hilton, and Love, you were in there too. Investigator Long was in there. Investigator Hamilton was in there. And Deputy Brown was in there. Even Miss Weaver was in there. Any of y'all could have been a witness. You mean to tell me you had no idea that you could potentially be a witness in this case at any point? You should have been prepping yourself for at least saying what happened off the record. Just stop it. This is a good point. These guys have to recall things from 2013 to 15, and she could recall something from a month or two ago. Yeah, come on. Stop it. Just stop it. Just stop it. All right, I'm about to head back to the court to see if there's anything popping right now. They're not back just yet. Hold on, let me speed up a little bit. A little TiVo. So you don't have a clue. You walked in the judge's office. This was in his actual office. It was in his office. Remember they said something about a small little courtroom that they use as far as chambers for ex partes. She said that they had her in the man's office where his emotional dog be at. All right. Come on now. Vanessa said she kept calling other attorneys by first name. So exactly. Yeah, Simone, Adrian. You see what I'm saying? And again, the cattiness. the cattiness that was going on between them two was absolutely insane as well. Absolutely insane as well. So I saw a little bit of movement. Saw a little bit of movement of the camera. Oh my goodness, man. When I saw that last night, and it's more to unpack with that. When I saw that last night, I was like, wait a minute. You mean to tell me you can't remember what happened 2 months ago in a secret meeting? In the secret meeting, as Lee, yes, she said that she didn't know until Steele said it in court that day. That's crazy. That's crazy. Okay, Brian Steele said it in court. There was an ex parte meeting, and then in her mind, she's like, "Oh, that's what that was. That's what that was. That's what that was. Oh, well, I didn't know. I got blindsided." And look, and then on top of that, right? And then on top of that, like ladies, how about this, ladies, you got a homegirl, right? Let's say you date the dude, you got a homegirl, right? And you and your dude doing the dude do y'all thing, whatever, you know what I'm saying, whatever the case may be, right? But then you talk to your homegirl about it, but you don't talk to the dude about it. That's an ex parte. All right, that's an ex parte, man. You done excluded the man from the conversation. That's ex parte. Now watch this. If your homegirl says something that inclinates that she knows something that y'all did without him knowing, he like, wait a minute. Wait a minute. How did you know about the fact that I do that? Oh, you've been talking. Y'all remember the movie Boomerang? Was it Boomerang? Yeah, remember Boomerang? When Grace Jones' character said, when are we going to, Marcus? When are we gonna? I heard that you were great in bed. Jacqueline told me about it. And he felt some type of way, didn't he? Didn't Marcus feel some type of way for some reason? All of a sudden, he felt some type of way. He's like, I can't believe you. You talking about what I do? You talking about what I do in the privacy between you and me? Jacqueline. Look. Everybody put Jacqueline in the chat, dog. Jacqueline told me. Okay? She told me that you get down with the get down. They was having an ex parte meeting about Marcus, darling. Hello, Marcus. Even Lady Eloise didn't say nothing. What she tell Marcus when she gave him a hug? They had an ex parte right there in front of everybody. I don't have any panties on. They was having an ex parte in front of everybody, man. Oh my God. I'm sorry, y'all. I'm acting a fool. I'm having too much fun right now. Here we go.
Agreement on anything?
Judge, I have just been reviewing Mr. Sharp's proposed redactions, and there are some that I agree to.
Okay.
Not
Microphone.
But he's already given the court the first one. Does the court have a copy of his redaction?
Yeah, the proposed redaction, yes.
Okay, so looking at Mr. Sharp's chart, number one, we've already discussed. Number 17 is the next one.
All right. And that's agreed to?
Yes, I don't have any problem with that. That's the discussion of the search of the defendant Williams' home, revealing the gun, and the gun and the contents of that search were suppressed, so that should not come in.
All right.
As well as number 19, which is on page
Right, guys, I don't want to cover the caption.
73 of the transcript.
All right.
That is, just to call it out, speculation.
Okay.
Specifically, it's 67, line 15 through 19. I'm sorry. Mr. Sharp has a description that is different than the lines that are listed. So so on page 73, I don't have any objection to lines 10. He has it right, lines 10 through 13, no objection.
Could you just give me the number of the section?
17.
Judge, tell everybody to use the mics, please.
So 17
Thank you.
and 19, I also don't have any objection to. 23, I don't have any objection to.
Okay.
Could you clarify what the first one you did not have an objection to?
The first
Everybody-
one that I did not have an objection to was number 1. And number 1, if you have, you already have the redactions? Okay, so it was Mr. Zachary, after saying he wasn't at Club Crucial, he talks about what happened at Club Crucial. And Your Honor, I will say that as it stands, I'm not trying to get that in. I don't know if something else changes, but right now I agree that it should come out.
Okay. All right, so we had gone through 23.
24, 25, 26, I don't agree with. Going to 27, it is 9211 7. It is 92. Keep out all the way through 9422. Mm-hmm. 9211 through 9422. That's what I've gotten to agree to. If the court permits me to further review the rest of them, because some of them I was looking and I don't agree to, I'm ready to argue those, or I can.
Let's do that right now, and then over the lunch break, you can go through the ones you hadn't hit yet and see whether there's agreement on any of those.
Did the state agree to 27 or no?
It's
No.
no. Sounds like so far just 1, 17, 19, and 23. Okay. All right. So I guess that means 2 through 16 we need to take up.
Yes.
Okay.
And Your Honor, will we just follow the same pattern we did last time where the defense tells what their objection is?
Yes. So, I mean, the objections are essentially on the proposed redaction. So I guess the objections generally speculation about why they shot up the house.
So page 13, line 16 starts at Dennis talking with the witness about the house getting shot up, and this is following, I think you have to go back a little bit further to page 12 to get better context. In that conversation, the witness is talking with Demikion Garlington about people that call him that night, starting on page 12, line 14. And Quindarius Zachary is talking about his girlfriend telling him what's going on.
Right. Yeah, so it starts at 13, line 16. He doesn't have objection to him saying, hey, this house got shut up. It's why the house got shut up, which the objection is speculation.
So my argument, assuming I established the proper foundation, is that with Quindarius Zachary saying that Trevante was helping D fight. He's talking about Demikion Garlington.
Right, so what would his basis of knowledge be? You would need to establish that he's got a legitimate basis to know that.
That's the point that I'm making. Like, without doing it, I wouldn't, if
Okay.
I were not able to do it, I wouldn't proffer it or even try to play
Okay,
it.
and so you think you can?
Yes, that's the point. Especially, Your Honor, when we're talking about, he goes all the way through to line 2.
Right, 14, line 2.
Okay, I was looking at line 14.
And
unless if I don't establish that foundation, I won't tender that. But if I do, I just want to be able to play that part about his.
Okay, so how about this? Right now, it's out on the, granted as to speculation.
Okay.
And if you establish it,
okay,
then that'll be a different story.
That'll work. Okay, so the next one being page 25. So 25, page 25, line 9 through 25:12 is a direct statement from the witness about an incident that's listed as an overt act on the indictment.
Okay.
And what they were doing, it's an admission.
All right.
It's an admission against his.
All right, so what's our objection there, Mr. Short?
My objection is drug use, and the character that's associated with that, and the statement, they didn't, where is it? They really didn't care. That's speculation about someone else's mind state, or state of mind. The reality is, within this context is a story about that Mr. Zachary gives, that he describes my client, as well as others, shooting up houses. And I'm not, of course, I don't want that to be admitted, but that's a fight for another day. But I'm not objecting to that on any of these bases, but I am objecting. So I'm not objecting to him talking about that at this time, but I am objecting to him pontificating about my client's state of mind as this was going on, because he can't really speak to that.
So that would just go to the, they really didn't care part. And then you're saying the fact that he's saying they were taking Xanax is,
I don't know his basis of knowledge of that, but I don't believe that to be true, but I don't know his basis of knowledge of that.
all right, Ms. Love.
So Judge, my argument right now until I speak to him is that he is in the car with the persons that he's speaking to the detectives about. He has the opportunity to observe them up close. The question posed, as the court can see, is did they feel some kind of way that you didn't get out of the car? We believe that the evidence has shown and will continue to show that these people he's in the car with that are shooting up these houses are his friends. He's known them for a long time, and his personal observations of them and personal knowledge of them is what allows him to make the assertion that he does, that as to why they didn't care that he didn't get out of the car while they're facing arguably danger. They're the ones getting out, according to Mr. Zachary, doing the shooting, but they were high, essentially. So that's the reason why they didn't mind him not getting out of the car. We'd argue that it's intrinsic. It could go to why they would be so brazen as to do something like that. But the fact that they were high while they were shooting, the fact that it incidentally touches on someone's character.
Okay, so I don't have I don't think I'm going to overrule it as to character. And if you can establish that he actually knew they were on Xanax and high, that's fine. On the they really didn't care part, are you maintaining that part should come in?
Yes.
Because his observation is that
they didn't mind. He's offering up an explanation as to why. Basically, the investigator's a little bit incredulous that, wait, you...
Right, what's the motive? The motive's just, they were hot.
Yes.
All right. Well, if you can establish that he knows that they were on Xanax, then I will let you use that part. So overruled as to character and sort of like to be determined as to the basis of knowledge on whether they were high or not.
I put subject to foundation.
Okay.
So that is number... So the next one is further down. Mr. Zachary is asked by the prosecutor, what was you all's intention when you all headed over there? He says that we were going to kill one of the boys. And then the prosecutor says, and one of the boys, I know we talked about a bunch of names, but which of the guys were you looking for? And then Mr. Zachary responds, the request is to take out 17 through 25 all the way.
Yeah, I think just
I'm
17
sorry,
through
25.
17 through 20.
Yes, I'm sorry. So
Lord have
17
mercy.
through 20.
Right.
He's specifically talking about their intentions when they went on this shooting spree. I think that it's not only relevant, intrinsic, it gives a motive for what they were doing. He has personal knowledge of it. He was in the car. They were riding together.
Okay, well, as long as you establish that he knew that's what they were planning to do, and it's not.
And he doesn't say they, he says that
Oh,
we
he's-
were going to kill one of the.
Oh, I'm sorry. Actually, I maybe need to put on my glasses. Thought that said they were, but that we were, yes.
So, Your Honor, let me just back up. So this is an incident where houses were shot up. Mr. Zachary was charged, and in this proffer session, he's given testimony to try to get himself a deal. And I understand that's subject for cross-examination. My client was never charged.
Okay.
Mr. Zachary is throwing my client's name into this. And I understand that's subject for cross-examination as well. But when he says, what was y'all's intention?
Mm-hmm.
Now, it strikes me that Mr. Zachary can speak to his own intention, unless he says Mr. Stillwell was there and this is what Mr. Stillwell said or something of that nature. He can speak to his own intention, what his intention was, and the state can ask him on the stand, Mr. Zachary, when you went over to the house, what was your plan? But unless someone else articulated their plan to Mr. Zachary, I don't think he's authorized to speak to what anyone else's plan was or intention was. And when he starts saying, and it's not his fault because
Of the way
Mr.
it's
Bailey
asked.
inartfully asked, what was y'all's intention? And that prompted him to speak for other people.
Well, I understand, and it may very well be that you can establish that they all had a joint intention because they had had some sort of talk about it beforehand, or.
And they actually he reveals earlier in the interview that they do discuss it.
All right, so where's that?
So up. On line 4, he says, because he said we're not going to shoot a house, leave that to them. So on line 2, investigator Dennis asks, why does Moontoon, and that isn't actually Antonio Sledge, it's spelled wrong, tell you not to get out of the car? He said, Mr. Zachary said, because he said, we don't shoot up houses, leave that to them. That's one point that they're talking. Further back on line, page 24, when Mr. Zachary is talking to Detective Dennis about the kind of guns that they have, he's naming them.
Okay, I mean, it does look like they kind of had.
Well, Your Honor, he's talking about what Moontoon said. Moontoon's not even here. My client is not Moontoon. And so I don't find respectfully what Ms. Love said to really address the issue.
All right, so where is it that your client gets, what is it that is indicating that he's talking, his speech includes your client if your client's not in the car?
No, my client is supposedly in the car according to Mr. Zachary. But what Ms. Love talked about is Moontoon telling Mr. Zachary to not get out the car, saying, we don't shoot up houses, leave that to them. What that has to do with my client's intent to kill someone, I'm not seeing that link at all. And my whole point is this, Your Honor, if they can establish that that through Mr. Zachary, that my client indicated what the intent was, what the plan was, that's not in this transcript. That's going to come across through live testimony, which would render these prior statements, out-of-court statements, irrelevant anyways, because it would have been established through live testimony.
Right.
So I don't know why we would keep this in the transcript.
Well, Judge, I thought that the whole purpose of this exercise was assuming that they don't.
It is. Okay, so assuming you need to use it as a prior inconsistent statement.
Yes, and in response to Mr. Sharp, Mr. Zachary is talking about his own intent and his understanding of what the conspiracy was. Arguably, this is a conspiratorial act of going out to shoot. We were going to kill one of the boys. So he does not, I don't think that it's improper for him to be able to talk about what the intentions of the group that he is acting as a part of were, as shown by their actions and their words throughout the course of the conspiracy itself.
But if his statement is just based on assumptions he's making through the actions of others, then the jurors are in a similar place as Mr. Zachary to make that, to draw that conclusion.
But Mr.
So
Zachary,
I don't understand why Mr. Zachary, his conclusion about what my client's intent was would be particularly helpful or relevant to anything unless my client articulated it to him. And from my understanding of what Mr. Zachary's saying is he gets a call from his girlfriend, Summer, Mr. Garlington and Mr. Sledge leave the club. Mr. Zachary doesn't know, according to his story, he doesn't know how Mr. Stillwell gets in the car because he wasn't at the club. And then they pick up Zachary last. And Zachary does not describe any conversation in the car on the way to these houses or anything like that. He doesn't give any context about communication. He's just kind of like, I got in the car and this is where we went.
So Judge, this is also the third interview that Mr. Zachary gave. He gave one earlier in 2015. This one occurred in 2017. So there are statements about this same incident in the 2015 interview as well. So we haven't gone through that one, but I could cross-reference that as well and provide those cross-references to the court. But the reality is that an assertion by a co-conspirator, if everyone is acting towards the same goal and people are getting shot up, houses are getting shot up, and
With assault rifles that are in the car.
right.
Yeah, I'm gonna overrule that. All right,
25.
28, line 17.
The
No.
font is a little small on this head.
I'm sorry?
I need the court's glasses. I'm
Yeah,
just trying to
28,
get down.
line 1 through 3.
And with this one, Your Honor, I'm not trying to mislead anyone. If one of my colleagues tells me I'm wrong, then I'm wrong. My recollection, there has been no testimony about someone being shot in these houses.
Okay.
If I'm wrong about that, feel free to correct in this instance. The
So
shooting at
this
the houses.
one, we have given the list of 30 witnesses, and one of the first witnesses after Mr. Zachary is the young lady who lives at this house and her sister
Okay.
getting shot at. So there hasn't been.
Did somebody get shot at this house?
Yes.
And that evidence will come in through this other, what's the name of that witness?
Miss Bell and her sister Cecilia.
So they're coming to testify?
I see them on the witness list.
You don't see them?
Yeah, I do. I see Denise Bell. I don't know what the other person's name is. So you intend to call somebody who says somebody at this house got shot? Okay, so then that is all right. All right, number 6. And I guess let's make this 3-page proffer of proposed edits a record of part of an exhibit to today's proceedings. So in the event of an eventual review, whomever is reviewing it will know what we're talking about when we say on to number 6.
Can we make you don't want us to use the one we're writing on? You want to?
Yeah,
make it,
just a
easier.
clean copy.
Okay.
Yeah, I know we're all writing on ours right now. So yeah, just a clean copy, and it can be,
We can do that.
I don't care who makes it an exhibit.
Okay.
It's basically just for purposes of the record. I can make it a court's exhibit to today, court's exhibit 1. I'll print out a clean copy right now. All right.
Okay. So the next one is page 29, line 10 through 29, line 11. So going back, Your Honor, you can see from page 28, line you can go back up as far as line 7, but you'll see that there's context. You want to pause?
No.
Okay, you can see that there's context. Mr. Zachary is talking about where they went, what they did. And at line 18, he's talking about the house on Oak. And later on, you have Investigator Dennis talking about his familiarity with the house.
Right.
The fact that he offers a concrete fact, his knowledge about the house, and Mr. Zachary doesn't correct him or doesn't say anything about it, I would argue it
How
just
would
goes
he
to the
correct him
effect.
to that?
I mean, it's not something that by itself is very material. There's just,
Then take
I
it
don't,
out. Strike it. Granted.
you're, okay.
Dang. Jeez, oh, Pete, man.
All right. I'm just writing August 6th, 2024, Courts Exhibit 1, as to this 3-page proposed reductions. Okay.
So the number 7 is page 33, line 1 through 35, line 14. That actually starts back up on page 32, or actually 31, where Mr. Zachary is talking about Trevante. So page 31, line 16, where Dennis says, got it, you were sitting behind Munktunk, Demikian is in the back with you and Shannon is in front, and then and then Mr. Zachary says they were in another car, yeah. And they go on and talk about that. My argument is that the portion that they're asking to keep out is all information Dennis is exchanging with Quindaria Zachary about activities that YSL and Rivals are sort of involved in. Mr. Dennis talks about how they thought it was kale, and Mr. Zachary says, no, he corrects them, no, and then Dennis says, well, enlighten me, and he's like, no, you go ahead. But Zachary later on line 17 says they tried to say that we did it, acknowledging that there is a we, acknowledging in a way that helps to prove count 1 in our indictment. There is a they who is an opposition group who tried to say that we did it, we being YSL.
Where is the part where the opposition group is saying they thought we did it? I see the investigator saying we thought y'all did it, but
no, line 17 where he says they tried to say that we did it on on page 33.
Oh, it's back on page 35. I'm sorry. Okay. And so this would be to establish
the existence of the enterprise, the gang, and the fact that there is an opposition and a they and a we.
All right, Mr.
So,
Sharp.
I mean, that's not factually accurate.
Okay.
On this.
Pull your mic towards you, if you don't mind.
On this alleged.
It moves, so you can just move it up on your desk, maybe, I don't know. I know, they're all annoying, they get in the way.
With this alleged incident, the shooting up the houses, Mr. Zachary also puts a gentleman, two gentlemen, a Trevante Turner and a Tay, as being in the caravan with them shooting up these houses. Trevante Turner is sadly deceased. He has never been, I've never heard anyone allege that he was a member of YSL. The paper just reported that he was associated with, I believe it was If Gang.
I'm
but
not sure I'm gonna go on what the paper says.
I understand, but the state has never alleged that. He's not charged in this.
Okay.
This is a gentleman who, you know, has not, there's been no allegations that he's been affiliated with us. I believe that there's a suggestion that he's a friend of Kenneth Copeland's, but that's it. So I don't have, I mean, I don't want it to come in, but I don't have a legal argument at this point against them. Mr. Zachary saying Trevante Turner was part of this mission that he's claiming existed. But at the times that I highlighted that I have a problem with, it's talking about a wholly unrelated incident where Trevante Turner, who's not one of us, and Shell Kell, who is Kelvin Watts, were having their own side beef and shooting at each other. And I believe Trevante was shot maybe by Shell Kell. Mr. Watts was maybe shot by Trevante, but it has nothing to do with this indictment. It's not alleged as an overt act, and it has nothing to do with, if I were to, for the purpose of this argument, agree that there's a group called YSL and it's a criminal street gang, which obviously is an issue here, this incident would have nothing to do with that. And it's just talking about, and they're just really treating it as small talk. You know, that he's telling a story and then it's a little aside about Trevante, which has nothing to do with this case.
All right, Ms. Lett, what do you have to say about that?
We had served in discovery a PowerPoint that involves, just as it relates to the assertion by Mr. Sharp that Trevante Turner was not associated with YSL. And in that PowerPoint that we served, we reflect on one of the slides at January 27 of 2015 incident 150262801 on Stanhope Circle, where shots were fired, specifically where Trevante Turner was shot. And it's listed that he is an associate of YSL/30D. Just to go to the assertion that there's never been any indication about Trevante Turner being YSL.
Well,
but
an
that's
associate of YSL and a member of YSL aren't the same thing.
They aren't, but I'm not asserting one way or the other as it relates to associate or member with respect to Trevante Turner. What I'm saying is that in saying that they tried to say we did it, Quindarius Zachary, when we charge the gang act, associate or member, it doesn't matter. Associates commit acts with the gang. So it doesn't in any way cut against, is my position, my argument that in saying they try to say we did it, he's not just talking about a random group of men, he's talking about them as a group that operates as YSL is the argument that I would make.
Well,
Who's the they here?
The person.
Go ahead.
So.
Who did they?
So If Gang is the gang that.
So is that the they here? This is the
associates
part of the gang
yes.
that there's the alleged beef back and forth and the
Yes.
series of shooting, the members that are involved in this little, even if it's a side incident, are all that gang?
Yes.
Okay.
Well, if that's the money line, they tried to say, like, how's that admissible? They tried to say we did it. I mean, false accusations by an unnamed group about something that the declarant, in this case, Mr. Zachary, is actually saying they were wrong about. How's that admissible to anything? You know, and if that's the key section, that's inadmissible in itself. But I think this whole section is just wholly irrelevant and it's confuses the issues.
And if the court goes on further down, and investigator Dennis elaborates, that basically you all were laying in wait for Kelvin Watts. It says Watch, but it's Watts, W-A-T-T-S, Shell Kel, who also has a gray Charger. Just in the continued conversation with everything he asserts, he is making an affirmation about the existence of the gang itself. Yeah, that's what they say. Is what Quindarius Zachary says. He's not pushing back against the notion that they would be laying in watch for Shell Kel. He's just saying, yeah, that's what they say. There's an acknowledgement still of an opposition and of a group that he belongs to.
All right, so.
He's literally saying, no, that didn't happen.
Right, but she's not offering it for whether it happened the way they said it happened or not. She's offering it for the concept that Mr. Zachary is saying, yeah, there's this we here that is YSL, and that is certainly relevant to the issues in this case. And if you want some kind, I mean, if it even comes in, because I assume, this is all if he doesn't testify as the state thinks he will, and then they have to impeach him, although, it would be interesting to see how you use this and what you would be using this to impeach for. Because if your purpose with it is to establish there's a we and a they, then he'd have to testify inconsistently to that for you to be able to use this. Do you understand?
Yes.
Okay.
And Your Honor,
And if that is what you're able to then use it for, I mean, I'd be happy to limit that this is only for the purpose of that, and it's not for whatever may or may not have happened with regard to some side shooting incident.
And let me just say that in his statements, Mr. Zachary, in his statements, and if he testified, I anticipate, he doesn't deny that there's a group called YSL.
Right.
He doesn't deny any of this. So I don't think that these issues are really.
Yeah, that's what I'm saying is this one may be one that never materializes, because I would say this is potentially admissible as impeachment on the issue that you're saying you want it for, not anything as to whatever this actual shooting is. Understand?
yes, and
Okay.
my understanding about the exercise overall is just to identify those portions that just absolutely cannot come in.
Right. So I don't want you up here saying, so, hey, tell me about this time that, you
Right.
and whomever were involved in this shooting with the, whatever it is.
So unless, right, I understand fully. Like,
Then
in
he
other words,
says
don't
something
try to
different. You're like,
don't try to impeach him just to get in some ancillary, otherwise inadmissible thing.
Correct.
Yes.
Okay. All right, moving on.
That was interesting how that she
Number
admitted that,
8
but she
and
restricted
30, page
that at the
36,
same time.
lines 1 through 30.
I'm sorry, I haven't read it all, but if it is gang members being happy because Gaither's not working anymore, how's that relevant?
So, Your Honor,
Yes.
I would argue. But I can concede that and say that there's really not, I can let that one go. I
Alrighty.
can stipulate to that.
Okay.
I just like it.
And Your Honor,
And
I think I may have made an error on that. I don't, 36, 1 to 24 is certainly about that. I'm not certain 37, 8 to 18 is about that same thing.
Okay.
I thought we were just doing the 1 through 24 first.
Yeah, all right. Well, I mean, he's got it all as number 8. So,
Okay.
all right. So agreed that 36, that part is out. So turn into 37, 8 through 18.
So in 37, 8 to 18, as I understand it, they're trying to identify Tay, and they're showing picture of Tay with a car, and they're saying, is that the car? And then investigator Underwood and Dennis and Zachary are agreeing, no, that's not the car. That's the car that got shot up by another person named Kel. It's just about Tay's other car that was not involved in the April 28th, 2015 shooting up houses being shot up. It's just
Okay.
talk about another car being shot.
All right. Is
Has
that
nothing to do-
relevant?
So Judge, in context 37, Mr. Sharp's objection goes all the way into page 38, unless I'm reading it wrong.
No, it's 37, 8 to 18, right?
Correct.
Okay. For now, Judge, I can stipulate to that. I don't see any reason to keep that part in right now.
All right. So that is also out by agreement.
And Your Honor, should anything, and I don't anticipate it, but should anything come up that causes me to ask the court, hey, there's something I agreed to that I need to get in now because
What?
this
Let's not wait
happened.
until the last minute to do it. Okay.
It would only be it would only be by virtue of something happening on the stand.
Okay. I mean, can you imagine a scenario why it suddenly becomes relevant that some other car that
It's not the car being shot up, it's Mr. Zachary giving the description of
What?
the individuals
No.
and his knowledge of certain individuals.
Tay?
Mm-hmm.
Okay. So that's lines 3 and 4. Is that Tay? Yeah.
And 16, where he's saying, he's talking about the other boy called Kale. Those sort of instances. I don't foresee them being necessary, but I didn't want to not say to the court, hey, this might come up.
Okay. Well, so maybe if there's some issue as to who Kel is. Okay.
That's wild.
And then I think that the next one on number 8 is all of page 38.
Yeah.
It's 38, line 8 to 39, line 11.
Hold on. 38. Line 8.
Okay.
Through 39, 11.
Really to 39. It's
Through 39, line 1.
the end of 39.
Okay.
Oh,
It's two different incidents. It's a discussion about Tay, people saying on the street. Again, I'm just trying to clean up this transcript. It's just going to be confusing to people. I don't care if all sorts of bad things come up in against about Tay one way or another.
Right.
But I'm just trying to limit confusion that
Right.
the jurors would have. And they're talking about people on the street saying that Tay shot up Rich Homie Kwan's dad's barber shop. Rich Homie Kwan's
I have no
father
objection
is a
to-
barber and runs a barber shop.
All right. She may agree.
I have no objection to 8 through with the clarification that he made because I thought it was the whole page.
Okay.
So I have no objection to 8 through 24
Okay.
of
So,
page 38.
all right.
And then on 39, 30 to 3919, 1 through
39.
19.
39-1.
39, 9 through 19, or
1
just
through
all
19.
one? Okay.
I have no objection to 1 through 13, where he stops at.
Okay, so 13 is the end of the Rich Homie Kwan
Right.
barbershop. And then
Yes.
they start talking about Tay shot Kel.
And
I don't. Again, I don't represent Tay. Tay's not associated. So, but it's just I just think it would be confusing.
Why is it?
Tay is associated. That's what we were just talking about. Tay being Trevante.
Right. Who is dead and not on trial here, right?
That's true. Unfortunately.
Okay, so is it relevant? I mean, I would assume you want a clean, clear story to the extent you can have one as well. So is this relevant to the story the state is attempting to tell?
Yes, it goes over into page 40. There's a video that we're going to have with Quindaria Zachary, Antonio Sledge, I think Demekion Garlington, and they're saying they're talking to Shell Kell, who is If Gang, and I think that they have a gun. That's my memory, that they have a long gun, and they're saying we ain't going back and forth, and they're saying disparaging things.
Mm-hmm.
And it's over a girl named Antrevia Smith. And when the court sees Tree in this transcript, they're talking about Antrevia.
Okay.
So to the extent that we're talking about one associate or member of YSL Trevante, and we're going on into the fact that Antonio Sledge and Shell Kell were seeing Antrevia. We're getting into information that we've noticed the defense that we're gonna introduce anyway. So I don't know why this would not.
I don't know or understand the nexus between Mr. Sledge threatening Kel on social media over a common girlfriend and Tay shooting Kel. I'm not talking bad about the guy. I think there was probably a lot of people that had problems with Mr. Kelvin Watts, and
We'll take it out.
Tay shooting.
All right, they'll take it out.
We'll take out. So it's going to be 15 through 21.
All right, so we already agreed to 39, 1 through 13. So I think this would start at 14. 39, 14 through what?
14 through 21.
I have 4215. It bleeds into number 9. I think that's why I was unclear. I made it its own separate one, this issue.
Wait, what?
To number 9 on my list is the continued discussion about the beef between Kel and Trevante. And this,
Welcome to Biz Nation.
They start out with Trevante shooting Kel, and then they talk about
politics.
how Kel
What's up?
allegedly shot up Trevia's house. Again, something that I don't believe that the police believe is true. That was Mr. Zachary.
We don't.
Saying his understanding was that Kel shot up his girlfriend Trevia's house.
All right, hang on. Ms.
So
Love.
in as much as Mr. Sharp said that the police don't rather believe that Mr. Zachary's line about Kelvin Watts shooting up Antrevia's house, that part is correct, because Antrevia Smith relayed to police when she gave them that video that Kelvin Watts was in the house with her. So in as much as
Definitely, I
Quindaria
appreciate that.
Zachary is attempting to push responsibility from what we believe is one member of his group to a member of the opposition group, I would think that would be relevant. It's not, it wouldn't be the first thing that I would ask him. It's something that I don't think is inadmissible, but it's also something that at this time, we're going to talk to him. We've noticed the defense about our intent to talk about when Entrevia Smith's house got shot up. It's just not every line of this portion that Mr. Sharp has labeled number 9. We may not get into every single line there, but the topic itself is what we did notice them that we're going to introduce evidence of.
If they bring up shooting of Trevious house, that's one thing, and that's, it may or may not be relevant. But my issue, and I don't agree with the state's characterization about Mr. Zachary lying about it. What we're dealing with here is not Mr. Zachary lying. Mr. Zachary wasn't at Trevious Smith's house. Mr. Zachary was not shooting at Trevious Smith's house or being shot at Miss Smith's house, Trevious Smith's house. Mr. Zachary is passing on rumors that he's heard through the grapevine about who did what, and the police are saying, well, we don't believe that's accurate because we believe that Shell Cal was in the house. So how could he shoot up the house? So it's whether it's a relevant topic or not, it's all based on hearsay that Mr. Zachary has no firsthand knowledge of.
Excuse, Judge, I just point the court's attention to the first line of page 41. And I'd also point out that Mr. Zachary was in that video that Entrevia gave over to the police after her house got shot up. He was in the video along with Antonio Sledge, where they were threatening Kelvin Wise.
All right, let me ask you this. Could you take a closer look at the rest of 39 through 42 and maybe sort out what part of that you think, if he doesn't testify as you think he will, you would use to impeach him on a relevant issue? And then maybe get back to us on this one?
Yes.
Okay.
This is the reason why
I kind of hear
Bruce
you
Harvey made the
saying,
motion he made.
even you think not all of it is anything you would want or need. Okay.
This is why Bruce Harvey
That's
said, "As
probably
judge, it's going to be impossible for you to catch up with things." All this can be done privately between these people.
All right. So
This is what y'all should have been doing in the first place: is communicating with each other to see what you want to admit, what you don't want to admit, all this kind of stuff. So that way, by the time you get to court, you can just admit
42.
the stuff. It's ridiculous.
Line 17 through 44, line 6. What is it? So when the objection is lack of personal knowledge, I am laboring under the assumption that Mr. Sharp's belief is that Mr. Zachary lacks personal knowledge. I would just ask that the court allow it, because it's all opposition actions towards one another. Shell Kell shot up the gambling house. On McDonald Boulevard, Dennis asks on page 43, line 1, that's when Thug's car got shot, right? I believe, if we haven't already, I believe that we have we've touched on that there was a shooting where his car got shot. But it may have been with Kenneth Copeland and some of the stuff that we have to redo.
right.
But Mr. Zachary is saying, yeah, shot up Thug's car. Thug wasn't studying it. All of that information, maybe not like that, but that information we anticipate bringing out. So to the extent that Mr. Sharp objects and has as his basis lack of personal knowledge, I would just ask that the court find that it's admissible subject to the proper foundation being laid for it.
I'm okay. That seems reasonable if you can lay the foundation.
Okay.
Yes.
Okay. Okay. After consulting with others, we're going to withdraw our
Okay.
objection.
Okay. All right. All right.
So I'm take that out.
All right. Number 11.
45.
That should,
15.
number 11 should be 46, line
Okay.
15.
Okay. 46, 15 through 16.
Yes.
Okay.
Well, maybe I'm wrong. I'm wrong. It was supposed to be 45.
Okay.
I'm sorry. They're all talking about an unrelated, they're talking about a girl named Clenethia Rant. And then Mr. Zachary just says she's dead. And then they talk about the circumstances of her
Okay.
murder.
I don't have.
All right, that she agrees.
Coming out. Mm-mm.
Okay.
What's her name?
So
That's 45, 15 through 46,
Yeah.
16. I agree. Okay, let me interrupt y'all a minute. I have word that Mr. Copeland is here and available right now, so why don't we pause what we're doing with this and have him in, see if he has an attorney, see if he wants an attorney. We don't yet have anything put together that I'm going to advise him of, but
I'm good.
we
with that.
could get through a little bit more of this, tell him to hold tight, take a lunch break where y'all can come up with something. But I could at least find out about the attorney issue right now.
I think that's
Okay.
Finally, let's do this. Jesus. She-Lee, if you can hear me, come on through. She said she was cleaning up her bathroom while this preliminary was going on. The moment we've been waiting for, man. Let's go. Let's go. That's right. Sit down, love.
Yeah. All right, good morning, Mr. Copeland. I'm Judge Whitaker. I think you've been before me before in unrelated matters, but I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask you right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you.
I know wanted to testify.
Okay, the first, well, right, want to is maybe the wrong term, but my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney? I would think that would be a no then, if you don't know
I
whether.
was saying, I was talking to Melanie, but
Melnick?
yes,
Okay, didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
I don't.
You don't remember?
Here we go, dog. Here we
Does
go with
anybody
this,
know whether
man.
that actually occurred?
I don't believe it occurred.
Okay.
I believe that Ms. Bumpus,
I know she was stand-in. and
she was stand-in, and I believe something was said on the record to the effect that Ms. Bumpus was relieved. but
Yeah, I know
don't-
she was,
There was
but,
nothing about Mr. Melnick to my knowledge.
okay, maybe
There was, Miss Bumpus actually said, yesterday, I believe, during her testimony, that Mr. Melnick had directed her to tell Mr. Copeland that he could either exercise his, he
well,
could do
choose
one
not to
thing,
testify.
right?
I don't recall.
Or if he chose to testify, according to Miss Bumpus.
Yeah, I remember she said, there's this paper I'm supposed to get him to sign. I'm trying to figure out whether it got signed.
So I never got Mr. Melnick off my case,
Okay, so he's still your attorney then?
I guess.
Okay, all right. Well, then that's the answer we've got for that. All right, so I'm going to try to get a hold of Mr. Melnick
Appreciate
and
you,
see
Lisa.
if he can be here with us this afternoon, because some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the state. And there was a discussion that Ms. Bumpus and Ms. Hilton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct.
All of that
And
information
I
was
want to
wrong.
make sure that you have the opportunity, understanding what it is that the immunity order means, understanding what the potential consequences are if you do testify or if you don't. We're basically going to kind of start over and
So if
do
I
that
don't
over.
testify,
Huh?
so if I don't testify, how long you gonna hold me in jail?
So, I mean, that's still an issue that you can be held in jail through the end of this trial, but I'd rather have Mr. Melnick here to advise you about the potential drawbacks of and benefits of what, if there are any,
This
of any
trial
of
right
your.
To the end of this trial,
Yes,
not the other people.
not as far as I believe, but the state, what did you
Look
want
at
to
the
do
judge
some
looking
further
at love.
research on that?
Yes, just to advise the court of.
Okay, so I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, then your attorney may have some information, advice, and research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least. I don't know who was in communication, but we need to reach out to Mr. Melnick, see what his availability is. So just be on standby in case I need you here like at 2 or 3 this afternoon.
2 or 3?
Yeah, because we're about to take a lunch break before too much longer. So you're okay to leave for the next couple of hours, but stay where whomever reached out from the state can reach you to let you know whether you need to be back here this afternoon or potentially tomorrow instead, okay?
All right.
All right, thank you.
Interesting, guys.
So, I don't know who. Okay, my litigation manager is going to reach out to Mr. Melnick, see if he can get a hold of, see if she can get a hold of Mr. Melnick and find out what his availability is. And depending upon his availability, we'll just see when it is that we have Mr. Copeland back. Because I want him to have the benefit of counsel. And then I also want y'all over the lunch break to work on whatever you think ought to be the correct advice to him. And if you, the state, believe that it is possible to hold him past the trial for which he is under subpoena, then you show me what authority lets you believe that. Okay. All right. Yeah.
One thing, I think that the transcript reflects this from June 10th, and as well as Ms. Bumpus's testimony yesterday. She was emphatic that Mr. Melnick said, if you testify, I'm not representing you. So, and with the fact that Mr. Copeland said.
No, what he said was, if you plead the 5th, I'm not representing you. So I don't know, what that means. I'm just going to reach out to Mr. Melnick, and at least Mr. Copeland thinks Mr. Melnick is still representing him. And if Mr. Copeland never signed whatever that was relieving him, I don't know exactly what their arrangement is, but let's find out from Mr. Melnick.
Yes, Your Honor.
All right. Okay, so let's get a few more minutes in of this before we break, because it's not even noon yet, and we were making some progress, which is good.
I'm gonna mute this for one. I'm sorry. I'm gonna pause this for 1 second. I'm sorry, but this judge is not hearing things correctly. Melnick specifically said, if you testify, there is a document that said he will discharge me. I'm going to remove myself because I don't know what the state told you. That's what was said.
Number 12.
Number 12 being page 47, lines, if I'm reading correctly, line 14 through page 50, line 8.
Yes.
Okay.
I honestly don't even know why we still continuing.
So, Your Honor, the objection to this portion of it, just to give you a little bit of background. So, this fight happened around January the 6th, and it did begin with Mr. Copeland, according to the reports from our investigators.
Exactly.
But it involved more than one member of YSL, more than one alleged member of YSL. Mr. Bloody J, who is a member of If Gang, was on the other side of the fight from YSL, and other people who are in the courtroom now participated in that with them. So Mr. Zachary's rendition of what happened, we would argue it's Mr. Zachary's knowledge of and participation in this gang is what allows him to be able to tell this to Detective Dennis. Mr. Shart's assertion, it does not appear that he was there, I don't think is a ground to exclude it, assuming that the court is satisfied with the foundation that the state lays for Mr. Zachary's
being
ability
a
to
co-conspirator.
Yes, we would argue that it's admissible. It's
So do you know whether he was there or not?
So
let me ask Mr. Shart, is the basis for you saying you don't think he was there that no on line 23 when is that the basis of it?
What page, line 23?
47, line 23? Because I don't think that no is actually an answer to.
No,
Okay.
it's not based on that.
Okay.
You
have no reason to believe.
No.
Okay.
I actually do not know
Okay.
he was there, and I haven't heard anyone talk about him being there.
Okay. Do we know whether he was there?
Page 48, line 5. Start at line.
Oh, so we went back there. Yeah.
Okay.
Okay.
If he was in fact there, then
And then
I would
somewhere
draw-
else, he says, would he? Okay. All right. Well, then you'll withdraw that objection?
If he was there, then yes.
Okay. So that number 12 is withdrawn.
All of this and not
All right, number
one
13.
order of motion for mistrial. You haven't even talked about it.
My understanding is this is page 54 54, line 18 through page 55, line 11.
Yeah, let's take that up first.
So the state has no objection to page 54, lines 18 through 22, where investigator Dennis says, who they say killed him, meaning Donovan Thomas. Zachary repeats the question. Ultimately, Zachary says, shoot, they say Woody and them, I don't know for a fact. So I would agree and argue that he don't know.
Okay.
So it's
He's
not,
telling them,
No, you
Okay.
good, Lisa.
So 54, line 18 through 22, you concede should be redacted.
so, and let me also give further clarification. Mr. Zachary, later, he tells earlier in 2015, he relates to law enforcement about statements made to him by two people in the courtroom now. And two people admitting having killed Donovan Thomas.
Okay.
This statement right here is after 2 years later. So, when he says, they say Woody and them, I don't know for a fact.
Mm-hmm.
If somebody argued that that's an inconsistent statement that should come in, I'm not objecting to it coming out because what I feel is a lie is irrelevant, but I'm not objecting to it coming out.
Okay.
so, Your Honor, we got a lot of moving parts here. Because eventually, I agree with Ms. Love. Eventually in this statement, Mr. Zachary claims that Mr. Kendrick told him that they killed Nutt and Mr. Stillwell told him that they killed Mr. Thomas.
Okay.
So I anticipate, because, I was doing this for Mr. Stillwell, but I anticipate other counsel in this courtroom arguing that are affected by this, arguing that this is spilling the beans and it's not a statement by a co-conspirator and therefore not admissible. Oh, okay.
I think.
Okay. So, right. Okay.
Okay.
So if I guess I'll rewind. I will say that if there is testimony, either through direct testimony or or impeachment,
Mhm.
that my client said something to Mr. Zachary, or that Mr. Kendrick said something to Mr. Zachary, then I would want to get that in.
18 through 22.
Right, because it would be inconsistent with the claims he says later on. Here he's saying, well, they're saying Woody and other people,
All right,
but
I
then
don't know.
later on he says, my client directly said this.
All right,
So if that comes in, I'd want to use that for impeachment.
I'd have to know who the they is here. Right, before that could be, if the they is Mr. Kendrick or Mr. Stillwell, yes. But if the they is some random amorphous gossip rag,
Well,
no.
it would be relevant because if he's telling the truth, okay, assuming he's telling the truth.
Oh, I see I see what you mean. If he's already said, or he will later say.
He's going to say that he already said in a different statement, and later in this statement, he's going to say that my client told him at night. And if he's holding that information, then him answering, they saying Woody and them, I don't know.
All right, I still need to find out who the they is then, because the question posed by the investigator is who they say killed him.
I think
right? So
who the streets are saying.
Okay, well then, for Mr. Zachary to say, here's what the street is saying, It's not inconsistent with, but I actually know because the perpetrator told me it's the perpetrator. So that would not be in this 18 through 22 would not be inconsistent to a statement by Zachary that Mr. Kendrick and or Mr. Stillwell told me personally that they're the ones that did it. You see what I mean?
I see what you mean. I would argue that that would be the time a reasonable person would say, who they say did it. Well, if my client had said he did it, say, well, I don't even need to tell you who they
All right, well, I would reject that argument. So that's out. All right, so next. Is what, 20, page 54, line 23 through 5511. Is that all going to be the same
That is all.
chunk of whatever? Okay.
So we're starting at page 57, line 22?
No, 54. Because all we dealt with was 54, 18 through 22. It goes all the way through 55, 11. So, okay, you was with them at the condo afterwards. I was there. I mean, that.
All of that, we would object to it being redacted out. All of this is Mr. Copeland talking about.
Okay, so, all right. The.
Not Mr. Copeland, Mr. Zachary, my apologies. So I don't know how.
Okay, so now I'm seeing Mr. Shard as I read on further. He's going back to the, well, that's what they say. I don't know for a fact.
Right.
I see what you, no, I mean, I hadn't read that part before. Who did they say? God, I don't even know if we're talking about the street here because you was with them at the condo afterwards. I was there, but shoot. That what they say? I don't know for a fact.
Right.
I'm saying, who did they say killed him? He may at this point mean, who did they, the people you are at the condo with, say? So can anybody actually point me to who the they is? If I flip back far enough?
In this particular interview, no, not as it relates to.
Oh, good
this
Lord.
statement right here. Because it's one of those.
It's all over the place.
No, it's, as it relates to the way that Dennis is talking to Zachary.
Yeah.
He means it just like if I were to just pop up and say, who did they say did it? There's no they identified.
Is there a video of this?
Yeah.
All right, I may need to watch the video of this part because maybe the inflection will let me know whether he means, let me watch the video on this. Can y'all send me that and then give me a timestamp for this part? Let me revisit that whole thing, including the 18 through 22 part.
If you send, I don't know if you have the times marked, but if you send the video that shows Mr. Zachary's face kind of zoomed in, I think it's an MP4 video. I think it's right around 27 minutes, 30 seconds.
27 minutes, 30 seconds?
I believe so.
Thank you.
Per my notes.
Okay, thanks.
Are we gonna move to the next one or just?
Yeah, no, I'll take a look at that offline unless y'all got it queued up right now. I'll take a look at that offline if y'all will send me that video. So yeah, let's, if 5722 through 23 is a separate kind of issue, we can move on to that one. All right.
I have 3 digits. meant to be a typo. Probably, is it just 5722 to 5723? Because it has 223.
I think so. Your objection, Mr. Short, here is 57 lines 22 and 23.
I'm going to withdraw that.
Okay. So that one is not objected to. All right. Moving on to number 14, which is page 60, line 19 through 61, line 20.
So, Your Honor, this is
I'm going to withdraw that one as well.
All right. Okay, then our next item is on page 65, lines 8 through 20.
We're on number 15.
Yes.
It's, and my objection to this is just incorrect rendition of the law, explaining, Investigator Dennis is explaining to Quindarius Zachary why he's guilty by association.
Yeah, yeah, and I suspect he was not offering that as here's what the law is. He was offering that as here's what we law enforcement consider you to be, but I can understand that. You wanna agree to that, Ms. Love?
Judge, is the court will give my counsel is sitting here whispering in my ear. The court will give you 1 second.
To get there and consider it, yes, I will give you a second to do that.
I'm here in the court.
We'll see. I'll give you about 10 more seconds to make your decision, then I'm just gonna make my ruling.
I don't object to 65-8 through 65-20 coming out.
All right. So that is out by agreement.
And Your Honor,
Yes.
yeah, I don't have any objection. All of number 15, and then 16 starts at 66. Line 12 through 66, line 18 is what I understand. Your Honor, this is one of the acts that's listed as an overt act in this indictment. As I'm reading it, page 66, line 12 starts out talking about the gun that Mr. Zachary got caught with on May the 7th, and then investigator Dennis goes on to say the assault rifle you're in the video with, and he's saying what it came back to. And then you have Mr. Zachary saying that's Moon's done. But he is acknowledging that he and Mr. Sledge, who the state alleges, Mr. Sledge already pled, but Mr. Zachary is indeed YSL. So they're swapping guns. We would just argue that this is evidence of count one and the gang count.
With
12 to 18, 7th shooting of Lucci's Bennett's
Okay.
mom's house. And there's a couple reasons. A, it's not Bennett put in evidence.
Okay,
yet.
well, hang on. Maybe we can address your objection and still have in the portion that Ms. Love wants it for
So it's
by
really 16.
redacting a smaller part of it.
I should have said 16 to 17, if I was
Okay.
to be more precise.
Okay, so any issue with just taking, with redacting out 16 and 17, Investigator Dennis's statement about it having come back to that?
Not for the purposes of Quindarius Act. No objection.
Okay. So that's 66, 17 through 18 out by agreement. Okay, and next we move to 68, 24, and 25.
It's,
I was,
yeah.
we're asking.
I don't, Mr. Sharp, did that have some issue?
Right, 60, they're going back to Lucci mom's house, and then they're saying the gun you got caught with has something on it until you didn't know until you went to court yesterday. So I think that should come out 6819.
Okay, so that's, and then maybe we just aren't lined up with line numbers.
Yeah, that's my.
So 68, 19 through 21, right?
I would say,
25,
because then they go to Lucci mom again.
well, 24 maybe?
Right, okay,
Okay, like, right?
yes.
So 19 through 24, out.
And then,
All right, hang on, let's make sure that we've got agreement on that.
So 19 through 24, so that's page 60.
It's page 68, lines 19 through 24. Do you agree? It's basically the same issue.
The issue that I have here is that I would object to that because Mr. Zachary admits that it has shootings on it. We know it's one of the guns used in one of the shootings. So even though, as it relates to the previous portion that I agreed to, and arguably even with the previous portion, the effect on Mr. Zachary, him not denying that or him not expressing surprise, but instead saying, oh, that's no Moon's done. In this particular case, when Dennis says what he says, Mr. Zachary doesn't say, what? Oh my gosh, no. Instead, he says it has shootings on it. Yeah, it has some shootings on it.
he says that because they told him in court the day before. He didn't know.
But Judge, Mr. Sharp can't be the witness in this particular instance.
I'm going by what the transcript says.
I'm saying though that he can't speak to why Mr. Zachary said, yeah, it has some shootings on it.
I'm gonna exclude that. I mean, honestly, it looks to me like he's saying, yeah, I mean, now that I know, I'm not surprised, but I mean, if that's what you wanted in for, make that argument, but I didn't hear that argument, so that would be lines So you're saying, hang on, Mr. Sharp, on 68, where are you proposing that redaction start?
19 to 24.
19 to 24, okay. I am gonna exclude that. All right, now moving to 69, lines 2 through 6.
And it's starting on January 26th, halfway through too.
Okay.
The state loves to admit hearsay in all their evidence. It's just ridiculous. You can't speculative information, hearsay. You can't do that, man. You got to have
Lines
concrete
2 through
evidence.
6,
We're in a RICO trial,
starting with
lady.
on January 26th. I mean, they're basically again saying, hey, you had this gun at some point and we know that it was involved in this shooting. We'd like to know who gave you the gun. And they don't have an issue with, we'd like to know who gave you the gun. Just we found out later this came back to the shooting.
That's fine.
Okay, so that is 2 through 6, starting on January 26th, are out by agreement.
I see why Weinstein put yentas in his motion, because they love using gossip as evidence. You can't.
And then 17 we already did. So the next one is actually 18, page 69, line 25 through 7213. And okay, so
Facts. I'll question it too.
Judge,
mm-hmm.
when Detective Dennis
Everybody
asked,
put prosecutorial misconduct in the chat. Like to chat up with prosecutorial misconduct. I told y'all about this, didn't I? Didn't we talk about it? I'm telling you, that video I dropped, man, a lot of people like, what? I'm telling you.
sir,
Mm-hmm.
I would argue that all of this is information that I should be able to ask him about. And if he doesn't, if he testifies inconsistently, he should be able to come in. I'm not looking at his reason for asking me to come out, so I will.
Yeah, what's your
There's no indication.
how he knows?
To the extent that my client was there, as he claims, there's no indication that he was there, and there's no indication of what his source of knowledge is. I think he's just passing along rumors. And so if he says,
Facts, Ricky.
I was there when Lucci's mom's house was shot up and it was Shannon Stillwell that did it, then I don't really have a leg to stand on. But I don't believe he's going to say that, and he needs firsthand knowledge or another exception or another hearsay exception, and I don't see it, and the state just kind of saying, oh well, he knows, so therefore it's admissible. There's just so much rumor and back and forth in this case.
Thank you, Mad Max.
And I think that the investigators, I'm not trying to criticize them, but they're just trying to gather information, not in preparation of trying the case, but just trying to get some broad generalized what the word on the street is.
So, Your Honor, as with any evidence or testimony that we elicit or tender, we have to establish a foundation before it's admitted. So we would not be seeking, and this we don't believe is just rank hearsay. So we just have a different position, and we ask that the court just allows the opportunity to lay the foundation and present it.
All right, and I assume that your foundation is going to be co-conspirator exception, that they all know this because they're in the gang and they communicate and they need to be able to know that argument. I mean, I would think so. And frankly, even on 73, when they asked about what about Thug's stepdad's house, he actually says, I don't know for sure who did that one. So, I mean, he's clearly, if he doesn't know,
We
he's
got you,
like,
D-Pill.
beats me on that one.
Well, I think, I don't speak for Mr. Zachary, but I could see a world where he's a layman. And so he's saying, well, I haven't heard, I don't know for sure means I haven't heard anyone, no one's told me about that. And I just think, I don't think the co-conspirator, and I'm not saying that Your Honor said this, but I don't believe that the co-conspirator exception is satisfied by just saying, oh, well, it was a bunch of co-conspirators talking. I think that they need to establish who said what to whom and where in the circumstances of that statement, so we can see if it falls under 801 D2E. And
Well.
so that's, I'm in the blind right now as far as how the state plans to get into that. But what I don't want to happen is the state, when Mr. Zachary's on the stand, to try to bring up, well, who do you know who shot Lucci's mother's house? And he says, I don't know, I wasn't there. And then they say, well, didn't you tell the investigators that Woody and Shannon and Pokey did it? And it's like, it was just based on nothing, but it's already out there now.
And Judge, that would be a leap. That would be to say who did it and then didn't you tell them? I would at the very least establish a basis for his knowledge, either from things that he has said previously or from things that he says on the stand. So it wouldn't be as if it would be some kind of backdoor way to get in somebody's name that, you know, is sitting here in the courtroom. It would be the proper pulling out of evidence of the witness on the stand. It would be establishing a foundation for his knowledge.
Okay, but we're assuming if this comes in, that it's coming in because it's coming in as an inconsistent statement, you're impeaching him, right? I mean, obviously, if he gets up and you ask him about it and he testifies to all of it on the stand, then there still might be a foundational objection, but then we deal with that then. But if you're getting it in because you're having to impeach him, that's what we're trying to decide now. And so I don't want to wait and have the jury there and make the jury go away while we figure out the basis of his knowledge, you know?
Yes.
So I don't know if we'll swing back around to that one. Okay. Let's see. I mean, and frankly, it's probably going to be the same. You're going to need the same information for a foundation, regardless of its as to his testimony on the stand or as to this, you know. But yeah, it kind of let us know what that's going to be, so that I can make a determination of whether it comes in, you know, potentially. Well, that was 18. You agree about 19, so we're moving to 20. And y'all just let me know when lunch gets here and we'll break. Oh, it is here? Okay, we're gonna break then. All right. Great. So it's 12:15 right now. So far, Ms. Rosser has not been able to reach Mr. Melnick. So, you know, it's probably more likely that it'll be tomorrow than today. So why don't we, I don't know, maybe I'll know more after lunch, but let's break until 1:30. Is that enough time, deputies, for getting everybody fed? Okay. See y'all back at 1:30.
All right. Let's do some work real quick. Let's do some work real quick. Let's go back, since they're on lunch right now. Let's go back to Woody on the stand. All right. Let me pause this real quick. Let me see if we can go back. There we go. Okay, that's Woody walking in. Okay, first of all, let's talk a little bit. All right. Because there were some things that was said during this particular part that was just simply I guess she misspoke, or she just don't know. And I'm referring to the judge here, Judge Whitaker. Maybe she misspoke. Maybe she just don't know what the actual agreement was between Melnick and Woody on when it came to testifying in this case. Remember, Woody was saying all week long, y'all been talking to me all week long. Y'all been talking to me and coming to get me and coming to see me and talking to me about this case. I'm telling you, I don't remember nothing, blah, 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 right? I don't recall. Okay. But there was an agreement. There was an agreement between Melnick and Woody that states, if you decide to testify, I am going to withdraw. Melnick said, I'm going to recuse myself. Okay. All right. And so that's called a noisy withdrawal from an attorney, from an attorney. If they try to withdraw themselves, they withdraw themselves from you because they don't know, they don't have the ability to fully represent you properly because information is missing, such as what the state was saying to Woody with behind his back. If you go up there and testify, I cannot represent to say what you agreed or not agreed to testify about when it came to these prosecutors. These prosecutors are coming at you, you know what I'm saying? And they are telling you things and asking you questions, telling you they need you a witness and this and the other kind of stuff. They give you this last minute coercive immunity that they got, this use immunity that they just pulled out their behinds. And so that is something that is just, it has prosecutorial misconduct all over it. But at the same time, Melnick is like, hey man, I can't represent you fully. And it wouldn't be to the best service for you. You know what I'm saying? So I'm going to recuse myself. All right. So sponte. All right. Let's check out this. Let's check out Woody on the stand real quick. And let's go ahead and dissect this real quick.
Copeland, I'm Judge Whitaker. I think you've been before me before in unrelated matters. But I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask you right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you.
I know one to testify.
Okay. The first.
Bram, right there. Let's stop. Let's stop. What that man say? What that man say?
And at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you.
I know one to testify.
Okay. The first.
I never wanted to testify. I never wanted to testify. What that mean? Never means absolutely never. So that means, so if I never wanted to testify, I mean, I did not want to testify when the state was talking to me behind my lawyer's back. I did not want to testify. I never wanted to testify about this case, period. I never wanted to testify even when they handed me the immunity paper on June 7th that morning, when that was my first time seeing that I had use immunity, because they filed the use immunity the night before, June 6th, when they found out that Melnick was representing Woody. What did Melnick say in his email? It has come to my attention that you have been speaking to my client without counsel, without my presence. Without my presence. So what does that mean? That means that you are doing prosecutorial misconduct right then. You are doing wrong right there. You are not supposed to talk to a person who has representation. We didn't know he was a lawyer. Look, it doesn't matter. If a lawyer is on retainer, I don't care if it's for a criminal charge. I don't care if it's for a traffic jam. I don't care if it's for none of that. If I have a lawyer on retainer, that's my lawyer for anything that I need him or her for. Period. Period. I never wanted to testify, which means, and that should have been a light bulb. Like, wait, you never wanted to testify? No. Why you think I pled the fifth in front of the jury like I said I was going to do? Because I never wanted to testify. That's why they grabbed the immunity. That's why they forced it on them. That's why they did the ex parte and coerced them with jail time, coerced them with how to testify, what to say. You can say, I don't recall. You're an attorney. You're not supposed to tell someone how to testify or what to testify. You can prep them. You can prep your witnesses, yes, but you cannot tell your witness what to say on the stand. That's called prosecutorial misconduct. And it's all over those motions are out there that's right now that's open. Stilwell's and Kendrick's motion for mistrial and a fair trial motion, all those motions has prosecutorial misconduct all inside of it. All inside of it. And this is the reason why, they should go, the defense specifically should go after prosecutorial misconduct. Brady material is potential. Now, that hasn't even been addressed. I had to write some stuff down for you. That haven't even been addressed. You said, Yana, that you take Brady very seriously. You have potential Brady evidence, and you're still trying to admit redacted statements from a transcript. Like, what are we doing today? Like, what are we doing? Why? Why are we doing this? The man said he never wanted to testify. And this immunity came out of just thin air. It fell from the Fonnie Willis heavens, and it landed down on his sacred desk on the morning that he had to testify, or when he said he would now, because what they say, well, if you don't testify, we're gonna hold you in willful contempt, and you got to go to jail. Coercion, forced immunity. Really? So let's go ahead. Let's break this down. Let's go. The chat lit, man. I feel y'all, man. Hold on, I feel y'all. Let me go to the chat real quick. Woody asked specific questions. Yes, he did. Absolutely. She's going to follow the law to the T. Follow the law to the T. Says facts. It was coerced. It was forced. I never wanted to testify. Oh, no doubt. I got you, D-Pill. I got you. No doubt. They knew he was going to plead the fifth because he said he was going to do it. They knew ahead of time. They knew ahead of time. He said, in my opinion, she's slowly on the record getting everything. So if questioned, the mistrial will be illegal. Look, it's been a mistrial, man. It's been a mistrial in the opening statement of the case. It was a mistrial. You know why? Because they withheld evidence, and they withheld the evidence in the opening statement to the defense. That's a mistrial right there. But what did Glanville do? He denied it. Prosecutorial misconduct warrants mistrial and also dismissal of charges if you take it too far, and the state has taken it way too far. Way too far. So this is beyond prosecutorial misconduct. That's the name that we have to use legally, but this is really called corruption. And like I always say, if you are the state, if you are the prosecutor and you're trying to prove the burden of proof is on you, your case in chief right now. If you are the prosecutor, it's your job to make sure you have concrete evidence that whatever you say in your opening statement, you're going to show it in your case. And if you do not show the evidence in your opening statement inside this case, that is a mistrial.
Well, right. Want to is maybe the wrong term. But my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney. I would think that would be a no then if you don't know
I
whether.
was saying, I was talking to Melanie, but
Melnick?
Yes.
Okay, didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
I don't.
You don't remember? Okay, does anybody know whether that actually occurred?
Ms.
I
Love
don't
can't
believe
wait
it
to talk.
occurred.
Okay.
I believe that Ms. Bumpus,
I know she was stand-in. and
she was standing and I believe something was said on the record to the effect that Ms. Bumpus was relieved. But
Yeah, I know
don't-
she was,
There was
but,
nothing about Mr. Melnick to my knowledge.
okay, maybe there was.
Okay, so the question is, did Woody sign the paper? Did Woody sign the document? No one knows. No one knows. Question would be, if he did not sign the document, technically, is Melnick still his lawyer? In order for me to get myself relieved, I need that document signed. Now, I think somebody in the chat said something about Melnick might come back pro bono just to get back at love. That would be hilarious. That would be lovely to see. That would be absolutely lovely to see. So the reason why, right? We exactly, Abundance. We talked about that in just a bit. That we talked about the fact that if you testify, okay, I'm out of here, man. I'm out of here. Now, technically, did he sign any paperwork? We don't know. See, that's knowledge. That's knowledge that we don't know about. There's more stuff to discover, Judge. And this is what I'm talking about. She playing too much. She laughing too much. She got the Kamala Harris laugh. Like, what is wrong? Nothing is funny. Okay? Nothing is funny when a head of lettuce is $5, Kamala. Sorry. Ain't nothing funny right now. It's nothing to joke about. There is so much to discover and unpack in this case. You cannot catch up. That's what Bruce Harvey was talking about. Melnick is not there right now. They're trying to get him on the phone to possibly show up to court. But if not, I think tomorrow, if they can't get it done today, get him there today, then tomorrow will be more sufficient, I believe. So y'all, I can't stand her laugh either, man. It irritates me. And everything is funny to her. All right. Everything is funny to her. I'm just sick of it. Like, you need to catch up, Mustard. Like, for real.
Miss Bumpus actually said yesterday, I believe, during her testimony, that Mr. Melnick had directed her to tell Mr. Copeland that he could either exercise his,
Well,
he could do
choose
one
not to
thing,
testify.
right? Or if he chose to testify, according to Ms. Bumpus.
Yeah, I remember she said, there's this paper I'm supposed to get him to sign. I'm trying to figure out whether it got signed.
So I never got Mr. Melnick off my case.
Okay, so
I never got Mr. Melnick off my case. Good job, Woody. Mary, put Woody in the chat real quick. Put Woody in the chat real quick, dog. Good job. Good job. I never got, look, he was never off my case, man. Never, ever. Never off my case. Good job. That was a good job, because now it redirects everything about being represented. It redirects everything.
still your attorney then?
I guess.
Okay, all right. Well, then that's the answer we've got for that. All right, so I'm going to try to get a hold of Mr. Melnick and see if he can be here with us this afternoon, because some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the state. And there was a discussion that Ms. Bumpus and Ms. Hilton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct. And I want to make sure that you have the opportunity, understanding what it is that the immunity order means, understanding what the potential consequences are if you do testify or if you don't. We're basically going to kind of start over and
So
do
if I
that
don't
over.
testify,
Huh?
So if I don't testify, how long you gonna hold me in jail?
So, I mean, that's still an issue that you can be held in jail through the end of this trial, but I'd rather have Mr. Melnick here to advise you about the potential drawbacks of and benefits of what, if there are any,
This
of any
trial
of
right
your.
To the end of this trial,
Yes,
not the other people.
not as far as I believe, but the state.
Look at her face. Look at Judge Whitaker's face right there. Again, see, this is what we are not. This is exactly, AJ. I appreciate you saying this. She's dotting I's, crossing T's. But see, this is the thing, though. You know, based on the transcript, you know that the information that was told to Woody was incorrect. It was lies. It was lies. I mean, a ton of them. Lies about the perjury immunity, about what it actually does, lies about the statute of limitations, lies about the fact that you having an ex parte meeting, which is improper during a trial at this point, especially at a critical stage. Just lies on top of lies, okay? And that is the coercive nature of the meeting. That's the coercive nature of this meeting. Is that you knew, and then on top of that, to say, and she also said it, and Miss Love also said it when Woody got arrested in court, that he could be held until the duration of not just this trial, but until all the defendants have been tried. Really? And that's not accurate. Now, you are the chief deputy assistant district attorney. You don't know this? You don't know this stuff? You don't know this? You know that's not accurate. You're not witness, and the defendants are severed. It's about what, maybe 8, 9 of them that's severed from this case, period. So what are you even talking about? What are you talking about? Coercion, man. Coercion. I hope Judge Whitaker finds this out, man. First of all, there should be no more furtherance with this thing, man. No, there's nothing to continue with. And Glanville, exactly, Vanessa, and Glanville joined in and said, yeah, absolutely. As a matter of fact, let's say, for instance, if you did a big whopper, if you just told a big whopper of a lie, then then there's not much I can do for you. You know what I'm saying? You lied and coerced the man. You all know y'all coerced him. And see, this is the thing. This is what damage control looks like. This is the reason why you should be forthcoming with who you are as a person, what you stand for, and you don't bend and break for nothing. Now, Miss Love got a backpedal because she muddied the waters from the beginning of this case. You don't have any concrete evidence, and you're making it up as you go. And you're trying to admit videos and redacted transcripts and things of that nature of witnesses and testimonies and all this kind of stuff about what people said that somebody else said to them about what was said to them. You are absolutely destroying the integrity that ain't got much. It's not much integrity in the law anyway. People don't have faith in the law like they used to years ago. As a matter of fact, I don't think people ever have faith in the law. They probably have faith in the law with naivety until they found out that the law don't really care much about what you got going on. Again, y'all know my story. For those of you that watched one of my lives, y'all know my story. It doesn't matter. Even if it's the state fault, they still gonna find a way to punish you, even if it's the state fault. And that's the whole point. This is the reason why there is no possible. You have 2 attorneys, 2 prosecutors, and a judge who was involved in a coercive act. They are witnesses of doing something corrupt behind the backs of the defense, and they were never going to say anything. And then I'm going a little bit to the potential Brady here, because that information needs to be dealt with right then and there. And again, I referred to before, and I think even Lisa Butterfly said it earlier in the chat as well. The Rush trial, Alec Baldwin versus state, versus the people versus the state. Prosecutor Morrissey withheld Brady evidence under a different case number and did it with prejudice to teach him a lesson, to throw him under the bus, to do all this kind of stuff. It's with prejudice. And this is the same thing. It's prejudice. The ex parte meeting that was on June 7th, the day that Woody decided to plead the fifth in front of the jury, there was an ex parte meeting after that. You can't just ask for ex partes for no reason, for just what? Just because? Just because, really? And in that meeting, what did they do? They gossip about what they see in the court, about this person, that person, about Miss Bumpus hugging Thug and this and that. You're having a secret meeting, and then the judge is going along with it, like, yeah, I'm noticing some stuff in the background. You know, it's some outside agitators going on over there. So this is all wrong, all across the board. All across the board.
State, what, did you want to do some further research on that?
Yes, just to advise the court.
Let's go back a little bit. I want to look at Judge's face.
Not as far as I believe, but the state, what, did you want to do some further research on that?
Yes, just to advise the court of.
Okay, so I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, then your attorney may have some information, advice, and research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least. I don't know who was in communication, but we need to reach out to Mr. Melnick, see what his availability is. So just be on standby in case I need you here, like at 2 or 3 this afternoon.
2 or 3?
Yeah.
Like,
we're
what?
about to take a lunch break
What you
before too
mean?
much longer. So you're
What you mean?
okay to leave for the next couple of hours, but stay where whomever reached out from the state can reach you to let you know whether you need to be back here this afternoon or potentially tomorrow instead, okay?
All right.
All right, thank you. So, I don't know who. Okay, my litigation manager is going to reach out to Mr. Melnick, see if he can get a hold of, see if she can get a hold of Mr. Melnick and find out what his availability is. And depending upon his availability, we'll just see when it is that we have Mr. Copeland back. Because I want him to have the benefit of counsel. And then I also want y'all over the lunch break to work on whatever you think ought to be the correct advice to him. And if you, the state, believe that it is possible to hold him past the trial for which he is under subpoena, then you show me what authority lets you believe that. Okay. All right. Yeah.
One thing, I think that the transcript reflects this from June 10th, and as well as Ms. Bumpus's testimony yesterday.
Mm-hmm.
She was emphatic that Mr. Melnick said, if you testify, I'm not representing you. So, and with the fact that Mr. Copeland said.
No, what he said was, if you plead the fifth, I'm not representing you. So I don't know.
False. False. That is not what was agreed upon. Again, this judge is she is all over the place, man. The agreement is if he testifies, that I'm going to do a noisy withdrawal, which means I'm going to remove myself because I don't have all the information about what the state told Woody behind my back for the first 4 days of the week. The judge continues to cut people off, act like she knows a lot about this case because she's skim reading. She don't know nothing about this case, man. She doesn't know anything about this case. And the fact that they are going through this rigmarole of admitting evidence and redacting transcripts of testimonies and interrogations and all, it's just ridiculous. It's just ridiculous. Because if they do get a hold of Melnick, he can correct that. But it's just ridiculous. That is something that I'm seeing about this judge that I don't like. I don't like her rushing and her like trying to rush people's statements and what they got to say. Listen, there are so many details to this case. You need to be listening to everybody first. You need to be seeing if you have discovered a reason for a mistrial, prosecutorial misconduct. You need to see what's going on about that. You need to spend time with that. We shouldn't even be in court today about admitting anything. This is the reason why Bruce Harvey said what he said earlier. Let me see if I could get that too, because that was important as well. Let me see if we can get to that. I'm not sure if I'll be able to. Because he said, listen, I'm not about to do anything until I know what your decision is with these motions. Okay, basically. And that's something that I can agree with Harvey. I mean, yeah, with Mr. Bruce Harvey. Why would I do anything for any reason when I don't even know if this is going to be an actual mistrial or not? You haven't even decided on what you're going to do. So it's so much going on, man. Yo, I appreciate everybody rocking with me, man. Let's go ahead and look at the chat a little bit more. Let's see what everybody has to say. I know I missed some stuff from earlier too. I'm sorry, y'all. Lisa Butterfly was in the building. She was like, I feel some type of way. Ain't nobody mad at you. Let's go ahead. Let me see what's the chat looking like. Okay, everybody's saying pretty much the same things. Yeah, exactly. Look, no, Judge, you're wrong. You're absolutely wrong. Judge going to correct herself after lunch about that. I hope she does. I hope she does. Let's look at again. We were looking at Bumpus on the Lead Attorney's channel. But I want to reference something real quick. There was a video, and I want to shout out Dear Woke Christian on this video. Where he talked about the potential, the candor towards the court with having inartful.
So I was watching.
Here we go. Having inartful rhetoric in one of her motions, one of her responses. And man, Dear Road Christian, man, shout out to you, man, and shout out. I'm going to make sure I'm going to update my description and put the link in the chat of his channel as well. You all can subscribe to Dear Woke Christian. He does an excellent job commentating and things of that nature. And he did a video about Judge Whitaker telling Adrian Love pretty much that you had some blatant errors in your response or motion, and And so I'm seeing that you might have slipped up and did some plagiarism or some AI stuff. All right, some chat GPT. You feel me? But there is a website called AI Lawyer where you can actually, it's pretty much AI for lawyers, and basically you can pull up, let's say you need to do a motion or file a motion or something like that. You can actually put in what you needed for it. It'll just write it out for you. It's kind of insane. But I want to talk about, I want us to look at this real quick, because this was absolutely insane, man. Again, shout out to Dear Woke Christian. This is his video. This is not my work, but this is his video. You go ahead and subscribe to his channel, and I'm going to put the link to the full video as well if you want to watch it again or anything of that nature as well. Let's go ahead and take a look at this real quick. Since they on break, let's go ahead and look at it real quick.
Watching this, and I just could not figure out, why did this seem like such a weird exchange? Why does Judge Whitaker say certain things like whomever authored this, and questions whether or not ADA Love actually authored this motion, and then proceeds to excoriate her over all the mistakes and errors that they have in the motion? And I think it's because Adrian Love might have got caught a form of AI to write this motion, a legal AI, if you will. I'm not 100% certain, but just listen again to how Judge Whitaker and Adrian Love have their exchange, and listen to what she says at the very end.
All right. The state has a motion to compel defendants' compliance with the reciprocal discovery obligations and to exclude evidence intentionally withheld and not timely disclosed. And
okay, y'all remember that? Do y'all remember this? Put a 1 in the chat if you remember this. Okay, put a 1 in the chat if you remember this. Okay, this is where Brian Steele went off about the fact that she keep asking the defense to render over evidence to them, but the prosecution is the case in chief right now. It is not incumbent upon the defense to render any evidence that they discovered until they are actual case. This woman asked this before, and when Glanville was over the case about reciprocal discovery. In other words, give me what you know. I'm not helping you with your case. I am not helping you with your case. This is why I think that the prosecution is trying to build their case as they go along in this trial. They're trying to build evidence as they go, because it's not my job to give you or render to you any type of evidence that I have. It's your turn to prove. I don't have to prove anything. I'm the defense. You accusing me of something. The nerve. Again, that's prosecutorial misconduct.
I had via email asked specifically as to the authorship of this particular motion, and to have whomever authored this motion be present in court. The response I got back was Ms. Love saying, "I will be present." Does that mean, Ms. Love, that you are the author of this motion?
Yes, Judge.
Okay. So I have some problems with some of the representations made in this motion. Specifically on page 3, the citation to U.S. versus Young, and then to U.S. versus Waddell, and then the statement, quote, "A defendant has a duty," underlined, "to disclose prior to trial and an ongoing duty to timely disclose," in bold, any evidence he intends to use as both impeachment evidence and as substantive evidence of innocence. See id, meaning see the above 2 cases, Waddell and Young. I've read both of those cases.
No, put a no in the chat. Put a no in the chat. No. No. Look. No. Put a no in the chat. No. No. It is not the duty of the defense to give you anything. No. Listen. I'm so glad this case is happening because we get to see the foolery in real time. And let me tell you something, real talk. This prosecutorial misconduct situation is ridiculously common in all 50 states of America. There it is. They're lazy. You know why? I'm gonna tell you, Abundance, I'm glad you said this. I'm gonna tell you why they're lazy. Because they have immunity. They can do whatever they want. They can do whatever they want. That's the problem. Can one of the mods go to my channel and copy the link to the prosecutorial misconduct video and share it with the chat? And chat, if you want to watch it on your spare time, if you haven't, go ahead and do it. And this is for the people that's going to watch this later on as well. I appreciate it, mods, if you can. If somebody can. They're lazy because they have been given a reason to be lazy. They can do whatever they want to do. In order for you to sue the state or for you to do or hold the state to any accountability, you have to have full evidence all the way down to the concrete evidence, eyewitness statements, all kind of stuff. Eyewitnesses to testify. Thank you, Abundance. I appreciate it. You have to have all of that in order to actually sue the state for prosecutorial misconduct. It is absolutely absurd to say in a response to, in a motion to the court, that the defense has a duty to give over or to hand over any evidence or any type of reciprocal discovery of any evidence, and you have to do it in a timely fashion. And then you put two case laws that has nothing to do, that it doesn't even say that. Man, watch this exchange. This exchange was crazy.
Show me in either of those cases where there is a proposition that discovery and reciprocal discovery obligations of the defense applies to evidence that's going to be used solely as impeachment.
I didn't say solely as impeachment. I said as both impeachment and as substantive.
Which implies that the use of it as impeachment evidence triggers the reciprocal discovery obligation.
No, unless I wrote it inartfully. What I was saying.
Well, you wrote it inartfully.
I did then, because what I was saying was that it has to be both. That.
What you mean, unless I wrote it inartfully? Well, I did then. Didn't you write this? Didn't you write this? You don't know what you wrote? You are a freaking attorney, man. You don't know what you wrote? Oh, I see. I see what it is. You don't know what you wrote because you didn't write it. Oh, okay. Yeah, you didn't write this motion. That's what that is. So you can't remember what you wrote because you didn't write it. And as a matter of fact, you so lazy. Look, I'm going to tell you how lazy Love is. She's so lazy, she didn't even proofread what the AI wrote out for her. She didn't even proofread her own lie. You didn't even before you didn't even try to proofread it yourself. If you go dot the I's and cross the T's of something that's of dishonesty, you need to dot the I's and cross the T's yourself to make sure that you know what you're doing. But you lazy. And guess what? She know you didn't write it. She know it because you put in 2 case laws that is irrelevant and does not prove and back up your inartful, another way, full of there it is, full of it motion. It's just ridiculous. This is what happens all across America. Got chat GPT AI lawyer.com writing her motions, man. It's just ridiculous. This is ridiculous. And this is the problem right here. She got caught on that motion. That's why she has until Friday to respond to the others. And this is the problem right here. She should have been held to a level of accountability right here. I mean, am I tripping? Look, I'm so baffled at this. My voice is going high. I can't believe this, dog. This is what our taxpayer dollars go to. They go to people like this. They go to people like this. Oh, you exactly. You thought she could. She thought she could fool the turkey. See, she thought she was rocking with Glanville. See, Glanville don't care as long as the state name on it. He just sign off and order it. Nah, we read. We read around here. This should have gotten removed. Removed. You understand what I'm saying? You are trying to play with me, is what Judge Whitaker saying right now. You tried to play with me. You think that you could do this. No one has checked you, boo. Ain't nobody checked you, boo. That's the problem. You ain't been checked. We checking you now. Yeah, it's more to this. We checking you now. We got until 1:30. Let's unpack this some more. Prosecutorial misconduct.
That is the representation that I made. And then when I amended it,
I didn't see an amendment.
I have a copy for the court.
Did you fix that?
What I did was
Thank you.
Just say no.
Elaborate on it. Or yes.
Love, you didn't fix it. Just say you didn't do it. You didn't fix anything. You didn't elaborate. You didn't do anything. Your lazy hind parts went on Chat GPT, AI lawyer, or whatever you use, and said, hey, I need you to write a motion for discovery and reciprocal discovery, blah, 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 blah. That's what you did. You went on AI lawyer. That's what you did. Huh? This is ridiculous. She is so full of it. Well, what I did was Your Honor, what I did was I tried to elaborate. You're lying. You were elaborating lie. Got the nerve to have the name love at the end of your name. It should be hate. Lazy. Adrian Lazy. This is ridiculous. This is what your taxpayers the dollars go to. And even in our local state, go ahead. Go ahead. Go to your local area of government and just sit in the courtroom and see what type of prosecutors you got and see where your taxpayers where it's going. Because they always say the people versus, right? If anytime a person is in court, it's the people versus. I told you when I had to go to court, it was the people versus Asante Foster. After they made a mistake on my address, that I gave them my full address. They messed my address up. I'm messing up stuff. I'm sorry, y'all.
So I was watching this and I just could not figure out, why did this seem like such a weird exchange?
Sorry about that, y'all.
Why does Judge Whitaker say certain things like whomever authored this and questions whether or not ADA Love actually.
Oh, no, I'm sorry, y'all. I got caught up. My bad. I got caught up. They messed up my address, and they still wanted to do something towards me. I'm like, really? Y'all still want to bother me? Hold on, y'all.
Actually,
I'm gonna get us right back to where he was at. Okay. My fault, y'all. I got hyped. That's my bad. I got hyped up. All right. I got hyped up. I'm sorry. But this is what I'm talking about. This is what irritates me. What irritates me is the fact that they can mess up. They never get in trouble at all. Go to your local courtroom or whatever. Go there and you will see what type of prosecutors you got. You will see what it is because they always want to fight for you. Okay, well, if you're going to fight for me, then you can't be corrupt. How about that? You can't be corrupt. It's an abuse of power. Right here. This is just what raw power looks like. It's just another example of how our justice system has been turned against us. Yeah. Let's go ahead and continue real quick.
And what I said in the amendment, Your Honor, was.
My bad, y'all.
Did you email the amendment to my chambers?
I did.
Okay.
Yesterday.
Yesterday. Okay.
Yes, it
Well, that
was.
may be why I hadn't seen it, although I've been looking at y'all's stuff nonstop. Okay. It's in front of me now. So.
So what our position is, Your Honor, as I state on page 3 of the amendment, is outlining what Georgia's statutory requirements are. Of course, the court is aware of what OCGA 1716 4C1 requires. And then I go down to subsection C on that same page where I cite Aggie versus the state 311 Georgia 340 at 343 and go on to say Georgia's discovery law does not explicitly apply 1716 4C to evidence used simply for the purpose of impeachment.
Okay.
And then I say it unquestionably applies to that second intended purpose, use as substantive evidence. And then in section D, Your Honor, I cite to relevant similar federal laws, pointing out that federal law requires the defense to provide the government with materials that are within the defendant's possession, custody, or control. Possession, custody, or control. My apologies. Where the defendant intends to use the item in the defendant's case in chief at trial. And that's.
They're not case in chief right now, though. And how much y'all want to bet? Put a 1 in the chat if you think this is her first time reading her own motion. And put a 1 in the chat if you think this is the first time she read this, dog.
Federal Rules of Criminal Procedure 16B1 alpha.
All right. So it can be used in the state's case in chief and maybe be impeachment evidence, maybe be substantive evidence, maybe be both. It's not where in the trial it comes in that matters. It's whether it's used and intended for use as substantive evidence or not.
Yes.
Okay. So as long as we're all on the same page with that, and I actually do think that to the extent anybody might.
Hold on, give me 1 second, y'all. Just got a cash app from D Pill. Thank you so much, sis, for supporting your channel. I appreciate it. Thank you for the $25 cash app. I appreciate it so much. Everybody put D Pill in the chat, man. Put D Pill in the chat for me real quick. Put D Pill in the chat. I appreciate you so much. Thank you so much for being so generous and so kind. She's also a member of the channel. She's a mod. Thank you so much. Thank you so much.
Might want to take a closer look at what those distinctions are. I think it's Waddell,
yes,
where the court actually says, hey, you know what? These can be tricky. These can be dicey. here's what it means. Here's the difference between the two. So I would recommend for everybody's reading pleasure the court's exposition of that issue in the Waddell case.
And in this amendment, I did correct the Waddell site.
Okay. All right, so we'll follow that law as well.
The legal analysis is wrong. There is no distinction in Georgia on substantive or impeachment. What you were told is wrong, and this lawyer knows it.
Still, I'm telling you, man, Brian still cannot stand lawyer love, for real. Thank you so much. Look at D Pill say you're welcome. Thank you so much. I really, really appreciate it from the bottom of my heart. I really do. Thank you so much. Look at all the love that you're getting, D. I appreciate you. Oh man, look. He said, still is, he an absolute boss, man. He's like, this lady knows it. And you know what? So many people have said that Brian Steele's demeanor is nothing like this. So it's kind of coming out of him when he doesn't like it when you try to do something. You could tell he doesn't like it when you try to do something dishonest. Oh, he doesn't like it at all. You can tell he doesn't. Look at Brian Steele, man. This is my guy right here.
Because she sat here in court and I did the same thing without being tempered.
All right.
That's 4 times.
Thank you for clarifying that.
Did you see Ms. Love face?
Do you have it?
Look at Ms. Love face. After he said, this lawyer knows it.
What you were told is wrong. And this lawyer knows it.
Woo.
Because she sat here in court and I did the same thing without being tempered.
Look at it. Look at her face. Woo! She is making this man hot right here. I'm telling you. This whole situation is too much, man. It's way too much out of bounds, man.
All right.
That's 4 times.
His face. Look at her face.
Thank you for clarifying that.
He like, I know he didn't just point at me like that. No, he didn't. No, he did not. Your Honor, he just pointed at me like that, Your Honor. Your Honor. Judge, we would like to, Your Honor. Oh, he was hot. Abundance. He was hot. The man was blazing hot. I'm telling you, the man was blazing hot. I feel him though. I feel him. Stop asking me what I got. I'm not the case in chief. I don't have to turn nothing over to you. You will never know what kind of evidence I have. I'm not turning nothing over to you. Hilton was looking like I ain't got nothing to do with it. I got nothing to do with that, dog. Let's go, man.
Thank you, guys. Do you have any Georgia law that represents what you have asserted in your motion and amended motion?
Your Honor, that's just it. I have been clear in my amended motion, and
Which
to the
I
extent that
just
it
got
wasn't.
a copy of.
Yes.
Okay.
And also I just want to
So
say that
no Georgia law.
right. Georgia law does not define. It does not define case in chief.
Just say no.
It does not break
We
it
all
down.
know what a case in chief is. Don't we? I think we all know what a case in chief is.
Yeah.
Is there any support for your assertion that reciprocal discovery is required based on the concept of substantive evidence?
Your Honor, what I have said and what I maintain is
You said, no, not you said, what Chat GPT said for you was impeachment and substantive evidence. That's what you said. She asked you specifically, do you have a Georgia law to support that? Your answer should be no.
that one, there is and absence. And I'll point the court to 3 different cases. Harris versus the state, 314, Georgia 238 as one. And these are just instances.
238? What did you say?
Yes.
Okay. What are the other 2 and what are they gonna represent?
307 Georgia 171, which is the 2019 Green case that Mr. Steele cited for the court, and 146 Georgia App 423, which is Phillips versus the state. And
when is that from?
I'm sorry.
What year?
Oh, just 1 second, Your Honor. That's a 78 case.
Okay, so that.
Did this motherfather say 78? You cited a case from 1978. Did I hear this motherfather right? 1970. You don't think the law codes in Georgia have been updated since then? You 1978. Put a what you mean in the chat. What you mean? like Woody, what you mean? 1978, man. You got to be kidding me.
Just 1 second, Your Honor. That's a 78 case.
Okay, so that one's not relevant at all.
Old case.
Because we have a new evidence code since 78. So, okay.
And Your Honor, even with respect to the older case, the only thing that I was citing Phillips for was the proposition that in the absence of specific legislative or decisional case law on the particular issue that is at hand in Phillips, we commend the Federal Rules of Criminal Procedure, Rule 16, for guidance. That is,
well, we've got a specific rule here now, don't we?
Well, when you say we have a specific rule, is the court speaking of the discovery statute that says?
That's what we're talking about in this motion, right?
Right, yes, Your Honor. We are talking about that, and the state's position, the state maintained. First of all, let me be real clear. We didn't file a brief. This is the first brief that we have filed where we've asserted these things. We have asked that the court require Mr. Steele to turn this stuff over, but we've never argued it out. Mr. Steele has stood up and said he's not required to, and he has pointed to the discovery statute. The court has said, okay, yeah, he doesn't. And we put that in our motion to the court, that the court has previously made a ruling that we thought deserved a second look at. Defendant Williams has adopted as his witnesses all the state's witnesses in the witness list that he filed. And so, Your Honor, when we
look at the judge. Look at the judge. Do you see that body language? Look at the body language of the judge. Look at the judge now. Look, I want you all to pay attention to the judge. As Lawyer Love continues to talk, pay attention to the judge's body language. Just the judge. We all know she lying. Don't worry about her. We know she lying. We know everything right here is a lie. But check out the judge real quick.
A second look at. Defendant Williams has adopted as his witnesses all the state's witnesses in the witness list that he filed. And so, Your Honor, when we assert based on Waddell, and Waddell also speaks about work product, and it makes this distinction between factual history and work product and what the state or is and is not entitled. The state stands on its assertion regarding what the requirements are because of the fact that I understand the court's position that there is no misunderstanding about what case in chief means in Georgia. But as there was this expounding on its meaning in Waddell, I think it's important to recognize that there's not been a similar sort of expounding in Georgia. And we can all presume or take for granted that it just means when the defendant is putting up his particular case. Right.
Okay, so Do you have any case law
In Georgia,
that supports the position you took in your motion that reciprocal discovery requirements are triggered based on whether you're presenting something as substantive evidence? That's my question to you.
Your Honor, the only, what we have in support of the motion is cited in the amendment and in the motion itself. We have not ever presented or represented to the court that there was a Georgia case that addressed this issue, and the conclusion that is asserted in the state's filings are the result of the fact that, one, from our position, it's not addressed directly, that, you know, what case in chief specifically.
So you are telling me that when our
Love just gave up, dog. Love, no, she can't win. Love just flew her hands in the air like, you know what? She did it, Joe Biden. She's like, you know what? Whatever, man. Whatever. Right in mid-sentence, dog.
It's not addressed directly, that, you know, what case in chief specifically.
So you are telling me that when our discovery statute says that the defendant is to produce or permit inspection and copying of whatever it is that they're in possession or control of, which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at the trial, you think that there's some kind of lack of clarity about what that means? Is that what you're representing to the court?
Your Honor, I'm representing that. That was the position that was taken. That was what was analyzed in the cases that we have cited in our amended amendment and supplement to our motion to compel. That is, in our position, a reasonable interpretation. And as we've
a reasonable interpretation. Let's look at what case in chief mean, people. I got it right here. And I mean, we know what it means, but let's just read it. Let's just read it. In a trial, a case in chief is the main part of a party's presentation where they present evidence to support their claim or defense. Claim or defense. Main part of the party's presentation. It takes place between the beginning of the trial and when the party rests their case. The party with the burden of proof presents their evidence during the case in chief, which is different from a rebuttal where a party tries to contradict the other party's evidence. You are case in chief right now, and it's only your responsibility to present evidence, not Mr. Steele, not Max Sharp, not Bruce Harvey, not Weinstein, Matthews, none of them. This lady is absolutely outside of her mind, man. Again, fellas, you can't break up with a woman like this. You got to leave. You got to go. Like Sheely said the other day, you got to go to another state. She is relentlessly crazy. You have to be insane. What you mean there may be a different interpretation of case in chief? No, there's only one definition of case in chief. You can't have this woman right here, any man dealing with her, he can't have a reasonable sit down conversation. Hey, you know, I got some things in my mind. I want to just, you know, no, you got to just walk off. Or like Lisa Butterfly say, run. Don't even walk, run, dog, run off.
As we've said in our filing, Your Honor, there was the requirement in Waddell.
She on thin ice with that.
Anything that was within the defendant's possession, custody, or control, where the defendant intended to use the item in the defendant's case in chief, that be turned over. The Waddell court, Your Honor, in analyzing the meaning and understanding of case in chief, as the court correctly pointed out earlier, said that if it is going to be used as both impeachment and substantive evidence, that constitutes case in chief. From there, we made the assertion, the state's position, that if the defense intends, because there's nothing in Georgia law that analyzes it at this level, if the defense intends to introduce evidence as both impeachment and substantive evidence, then they have a duty to disclose it. And that is the origin of the state. That is the basis for our position. If you
All right. And have you heard Mr. Steele argue 2 or 3 times before that that's not at all what Georgia law means?
We've not made this argument before. So
I don't mean in writing. Y'all have not had
we have
any
literally
discussion whatsoever in front of Judge Glanville about.
As I have said in my motion, Your Honor, what we have argued, the state has said, Your Honor, they have a duty to disclose this. This is stuff that we are entitled. And Mr. Steele has said no, in citing the Georgia statute. He said we do not. I have never asserted, I've never made this distinction. I've never said that case in chief means if it's being presented as impeachment as substantive evidence. I've never made that. I've never made that argument in a written or oral filing.
Okay.
She's
all
nuts.
right, well,
she is nuts.
I would like for you to take your duty of candor to the court with a little bit more seriousness in the future. Ms.
Respectfully, I take it very seriously.
You a dang lie. You a dang lie. Ooh wee. It's getting hot in here, so hot. Exactly. But hold on now. Hold on now.
Okay, so anyway, we'll be abiding by the discovery requirements set forth in our statutes. And Mr. Steele, thank you for the clarification.
Here's a close-up of Adrian Love's computer monitor on Wednesday. And this website that she's using is
Oh, look at this. Looky. We're on our artificial intelligence website. Let us continue this. Let us continue this investigation.
computer monitor on Wednesday. And this website that she's using is AI Lawyer. Basically, it's a website where you can type in what you need and it will actually write your motions for you. And here's a picture of the website. I believe that's why Judge Whitaker asked who wrote this, because there were so many errors in it and it wasn't very clear. That's why she also ended by saying Adrian Love needs to take her candor with the court more seriously. Basically, she was saying that you were being deceptive, you were being dishonest, and you need to be honest with the court. And being unartful is not just a statement that she used. She's saying that you're not being honest and you're being a little bit sloppy. So you can say sloppy, you can say dishonest, but she definitely lets you know that she's talking about being honest by saying that you need to keep your candor with the court. Such an interesting exchange. Can't wait to see what happens next.
Yo, can you say what? Can you say what? Huh? Huh? You got caught red-handed, yo. You got caught red-handed. Your motions have been written by an AI. This is absolutely crazy, man. This is laziness at its finest, man. This is lazy at its finest right here, man. Unbelievable. Make sure we good. Make sure we good on the live. All right. They'll be back in 5 minutes. Plans and Pen says, hey, might have missed it, but what channel posted that video? Go to Dear Woke Christian. Dear Woke Christian. Somebody put, if Ahmad can grab Dear Woke Christian's link or that and put it in the chat for for Plans and Pens, and we can go ahead and make sure that she's able to see that. That video shed light on oh, no problem at all. That video sheds light on the corrupt, lazy, just conniving prosecution that's going on right now. We've been talking about prosecutorial misconduct for a little minute now, okay? And we're going to continue because there's so much evidence of that than it is of RICO. It's more evidence of prosecutorial misconduct than it is of actual RICO. And again, one of the things a lawyer and a prosecutor have to do when they are prosecuting you, they have an opening statement, and in the opening statement, they will present factual statements or evidentiary statements to the jury. They're presented to the jury. And if they say that they're going to show evidence of this thing, show evidence of that, the evidence will show that this person did this. The evidence will show. If they don't present the court with evidence, mistrial. It's a mistrial. Oh, we know. Oh, Lisa, we know it's not just prosecutor, but that's what they have. That's what they had. See, the defense has it in so many different ways. It's in transcripts now, it's in these ex parte meetings, it's in the fact that she withheld evidence, or she withheld certain evidence from what her opening statement was in the very beginning when she tried to quote Rudyard Kipling, like the wolf pack. She tried to be Maya Angelou. She tried to. And the wolf is the pack. And the lead wolf. She tried to cite. That's one of my favorite poems from Rudyard Kipling. Stop it. And her opening statement had a slide that had Brian Steele's name on it, and she was supposed to remove it. That's one thing. Then she tried to sway the jury, burden of proof, or burden swinging in her statement when she said, and the defense must prove. No. The defense will not prove that this, you can't say that. You can't say that. Just like the example that my man gave in the video that I did, the prosecutorial misconduct video that I did, where he said, let's say, for instance, you're trying to admit a 911 tape in the court. And the court says, you know what? I'm going to exclude that 911 tape. That 911 audio, I'm going to exclude that for evidence. Okay, it's excluded, which means you can't talk about it. And then the prosecutor comes up and says, and starts asking you questions about the 911 tape. That's misconduct, misbehaving, and misconduct. Prosecutorial misconduct can lead to case dismissal of charges, and things of that nature with prejudice. This is with prejudice. Look at Lisa. Says, right, there are about 50 things here that calls for immediate dismissal with prejudice, and yet it's just a silly game. Exactly. This is absolute craziness. All right? This is absolute craziness. The candor of the court. Ms. Love think it's a game, man. I'm telling you, Ms. Love think it's a game. And she's been getting away with it for so long and then Simone Hilton is in there. I'm telling you, man, somebody from the DA office about to quit. And so we about to see somebody quit and somebody about to work for Brian Steele or something like that. I'm telling you, man, I wouldn't be surprised. I wouldn't be surprised if somebody from the DA's office said, you know what? I worked on this Young Thug case. I'm done. I'm good. I'm cool. All right, we are back in court. Here we go. I got the volume going on. All right, let's go.
We got everybody? All right. All right, what I
I wonder
know
if Woody
about
coming back.
Mr. Melnick at this point is that he is going to be available by Zoom 3-ish, and he was going to, I didn't talk to him. My lit manager talked to him. So I'm not sure we have a super clear answer on whether he currently represents Mr. Copeland, but Mr. Melnick was going to reach out to Mr. Copeland. And maybe by the time we hear from Mr. Melnick at 3, we'll know the status of that representation.
Good job.
All right.
Shout out to the litigation manager.
Yes. Am I cold? Is the court cold? No, the court's never cold because these robes are really heavy and hot. So no, but I mean, I realize that it is probably objectively a little cold in here. So I might nudge it up a half a degree for y'all. And then if y'all, hang on. Now, there are 2 other thermostats somewhere in this room, and if y'all want to nudge those up, somebody just go back there and do that. That's fine. Okay.
I'm telling you, it's catty in there, man. It is so catty in there.
All
Oh,
right,
my
so we were, I think, on item number 20. Were you able to look through any more of them? And
So what I was doing was the other assignment.
Microphones.
Oh, perfect. Yeah, that's probably more pressing. So, okay. What do you know on those?
So I'll start out with just the fact that the language of the statute itself is part of the basis, well, actually was the basis for the interpretation that we had regarding.
Okay, let me get maybe to the statute. Give me a second to get on Lexis. Unless you have a copy of it for me.
I don't have.
That's fine. It'll just take me a second to get it pulled up. So you're talking about 24.5.507?
Yes, Your Honor.
Okay. All right.
So just the plain language of the statute. So just the plain language of the statute, Your Honor.
Turn the microphones on, y'all.
Which is essentially a statute not saying that the court can grant immunity, but that the state can grant it and we have to move the court. It lays out very specific steps that we have to take. And in
Hang on a second. Can you not hear her?
No
All
one
right,
can.
can
Thank
you, I don't know, do those mics move?
It wasn't on.
Okay,
It wasn't on.
there we go.
So as I was saying, the language of 24.5.507 lays out very specific steps. Only the state can grant immunity, but the court can compel the testimony, which we obviously can't do. And 24.5.507 is a statute that allows us the leeway, the grounds rather, the pathway to get a witness to testify after they have pled
Right.
the fifth. And so section B of 24.5.507 says, if a person refuses to testify after being granted immunity from prosecution and after being ordered to testify as set forth in this code section, such a person may be adjudged in contempt and committed to the county jail until such time as such person purges himself or herself of contempt by testifying as ordered without regard to the expiration of the grand jury. I don't know why it only references the grand jury and not a petite jury, because the top portion of the statute in section A refers to both. And it talks about the fact that if you're needed in a criminal proceeding before a court or a grand jury, if your testimony is deemed by the district attorney necessary to the public interest, then the DA may ask the court to compel that person to testify. In any event, the last line, which says that if the grand jury before which such person was ordered to testify has been dissolved, such person may purge himself or herself by testifying before the court. I don't have the reason that they refer to the grand jury and don't reference the trial jury. But given the fact that the statute itself refers to them almost interchangeably in section A, when they say if you're either brought before the grand jury or a criminal proceeding. And so the fact that even after the grand jury is dissolved, the court can keep you there until you purge yourself of the contempt by giving the court testimony. The extrapolation that I made was you can be kept until you purge yourself of the contempt by testifying, because you don't have a right to assert your Fifth Amendment privilege.
Right. So one thing I would wonder about with regard to that argument is it's sort of a kind of basic canon of statutory construction that if certain language is used in a part of a statute and then it is not used in another part, that there's a reason that it's not used, that there's some significance to at one point saying before a court or grand jury, because they clearly knew they could use different language. So the fact that they didn't include it all in the second part, there might be a reason for it. So that I think kind of cuts against the argument that I can hold Mr. Copeland throughout all three trials. So I think we need, if there's some sort of case law that indicates that if the testimony at issue is before, like for a trial, that somebody can be held even after the trial is over until such time as they decide to come testify in front of a court about it. So
someone sent me a case, but I
Okay.
haven't fully got it. It's in re Long, 276 Georgia App 306. I'm reading it.
Okay. And if anybody on the defense side of the room's got a case that says the opposite, then that would also help us out. You know, that answers the question the other way. It just seems to me like if he's under subpoena for a trial, then the point in which it would logically end would be when the trial is over. And I get he may never still purge himself of the contempt, but
And it's a 2005 case, Judge, so I haven't looked carefully at it, so I don't know if it's cited in the annotations.
It is for a different proposition. I haven't read it myself either, but. I don't know that this case really answers the question we're asking. Anybody have any other kind of case? I mean, my position without a case to say it clearly one way or another is, I sort of feel like it couldn't go past the end of the trial. But I know that. I mean, one way or another, I'm willing to be persuaded differently if we've got law.
Your Honor, I don't have a case on point, however, it would make logical sense that it couldn't go past the end of the trial. How would Mr. Copeland purge himself of contempt at the interim time between two trials?
Yeah, I mean, I guess the same way that they suggest that if the grand jury is over with, you can come purge yourself by testifying in front of the court. Not that either of those really achieves the end that is sought by the immunity order, but it's a way to purge. But, you know.
And arguably, the testimony would be under oath and available.
It was not going to be available at, I mean.
Not at that trial.
Right.
Yeah.
So I'm sort of going with through the end of this trial unless somebody tells me differently. All right, has anybody come up with anything else that he ought to be advised about?
No, I know that the court did advise him that. Westmoreland, can you hear me? I know that the court advised him that he was told some things that were not entirely accurate. And just listening to the testimony and looking at the transcript of what he was told, as the court sits now, are there particular points that the court has concerns about? Because regarding perjury, the statute sort of lays it out. And I know that before he testified the last time, Judge Glanville, I think, gave him a copy of
Ms. Bumpus to give to him, I think.
No, actually, while Mr. Copeland was on the stand, I think that
in court.
Yes,
Okay.
he gave to Mr. Copeland read to him or gave it to him a copy of the statute and apprised him. I think he made
Okay, right. But all of that was before the ex parte. Y'all, it's already too hot, so I'm gonna have to turn it back up.
Okay.
But I went up a whole degree, so I'm seeing if a half degree will make a difference.
I will survive. So
what were we saying? Oh, yeah. So that was in court, but then the ex parte occurred after that.
It did.
And much closer in time to when he ended up testifying. So I'm thinking that probably was well, who knows, but that may have been the thing on his mind at the time. So one thing, and I mean, there's, this is he comes in on page, at 10:03 and it goes until 11:30. And I mean, there may have been a break or two in there, but so I realized that it's not just he's told one thing at one point in time, and that's really unclear. I mean, it may be that the gist of it gives him the right information, but for instance, I know there was one thing about perjury that I didn't think was exactly accurate. just as an example, if I can find it. Okay, so on page 51, the example, and I know what Ms. Hilton means. I don't think that anybody is purposefully trying to mislead anybody. I think we're all, you weren't there by the time Mr. Copeland came in, but I think Ms. Bumpus, Judge Glanville, and Ms. Hilton were trying to make sure he understood. But Ms. Hilton says, your example that you gave me, what if I said I did something and I know you didn't do it and you said before you didn't do it? That's not perjury. That is a prior inconsistent statement. Well, I mean, yes, it's a prior inconsistent statement, but it might also be perjury. It might not be, but I mean, yeah, there'd have to be some, proof that it's a lie. But to say that's not perjury is technically not necessarily correct. And you're also talking to a layperson. And he clearly, I don't think understands, I mean, he even says, I don't understand any of this at the outset. And, we're talking about purge versus perjury. And I just think we need to make sure we give him clear instructions and then he can make a decision.
Yes, Your Honor. And I know that I think I said on the record regarding his attempt to sort of get that information before he took the stand, when he was trying to speak with Ms. Hilton out there in the foyer area.
Yeah, and then, we also discussed the immunity versus statute of limitations. And yes, the immunity, because he has been given immunity, protects him from being prosecuted based on anything he says, if he says anything. And that is true. But he was also sort of told, you don't have any statute of limitation worries either. And that's not necessarily true. And it may have no practical effect, because if he can't be prosecuted, he can't be prosecuted, even if it's for something within the statute. Right. But it was technically not necessarily 100% accurate information. Whether he in any way relied on that, I'm not saying that at all. But I just want to make sure we do it entirely, to the extent we can, correctly and accurately.
So would the court be inclined to read him the statute and then respond? I don't know. I'm asking. Respond to questions, because for instance, I even heard, it may have just been a misstatement. Obviously, and people communicate differently, but when Mr. Melnick was saying regarding how his testimony couldn't be used, but we could use the testimony we can't.
So I don't know. Some people keep saying he's got use, and then some people are saying he's got use and derivative use. So I probably need to look at the order.
I wrote the order and I literally modeled it after the exact words in the statute. Like I took the statute and put it in the order for the most part. And so the part of the statute that says that no testimony or other evidence required under the order, or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for a crime or offense concerning.
That sounds like derivative use to me.
Exactly.
And so that,
exactly.
that was in there.
Thank you, Lisa. I appreciate you.
All right. And
I realized I was on
do you
mute.
want to, I can, what's the perjury statute?
I will look it up.
And frankly, I'm not sure that either giving him or reading him any of these statutes is going to be particularly helpful, but that's why I would like for him to have counsel, so counsel can explain to him, here's what the perjury statute means. Here's what your immunity order means. Here's what a prior inconsistent statement is. Here is what you face if you decide not to testify regardless of your immunity. And then, sure, if he has any questions of the court, still we can entertain those. But
and I don't know how wise it would be to even make the request that if his counsel seeks to understand the extent to which the immunity exists, like if he would speak to us, but
Well, maybe we
Can
can
you-
dial down from all of that too. That's been several weeks since y'all all made, assertions about whether or not, who knew what when and who was professional and who wasn't. And maybe I'm going to ask Mr. Melnick and you to move past that. And
I'm beyond it. I would.
you're beyond it. Great. We'll see.
Yeah,
if he
right.
is.
She don't lie.
And I would endeavor, I would love to be able to fully explain, to allay any fears that he has or concerns about his client's criminal exposure, but 161070 is the perjury.
Okay.
statute.
And then I ought to know prior and consistent statements by heart, but which one is that? 24 something? I don't know. I'm sure I have it in front of me somewhere, but I think those would be the 4 relevant things: the order 507, perjury statute, and prior and consistent statements. Whatever, I'll figure it out later. I can find prior and consistent statements.
24-6-630. Wait. Twenty-four, 6-6-13. Witnesses prior statement. 24-6-6-13B.
So Ms. Pressfield's been doing some research, and at least the federal statute on contempt related to kind of their version of immunity is that the confinement can't exceed the life of the court proceeding. So that's sort of, I know we're not the feds, but.
Is court proceeding the indictment, or is it the trial of a severed, because if people are severed? Like
I don't know the answer to that. Yes. Yes, I don't, who said that? You did what? Say that again. Okay, to Ms. Firstfield, okay. And do you have a short answer for me?
Yeah, we don't just hold people in custody. As U.S. Supreme Court cited.
Microphones, man.
One from the Middle District of Tennessee, our issue is a deposition, person refused to testify, there were trials coming up, they were not set yet. The government's position is like the state of Georgia.
Thank you, man.
Government's position is like the state of Georgia here, just hold the person because the case is not resolved. And the Middle District, the district court judge gave reasons. And then the footnote they gave the U.S. Supreme Court that the contempt is punishable for this trial. And after that, we don't do for other trials that are not set. And the government can't continue the same contempt over and over again. They can bring an obstruction of justice indictment against the person or a contempt criminal charge against the person. But we don't just hold people, because it becomes, and there's other cases I can send you, at some point it becomes just punishment. The whole point of civil contempt is to coerce the person to do the act.
Right.
And at some point they're not doing the act.
Yeah.
Otherwise, according to Ms. Love, I mean, according to Ms. Love's reading, we could just hold them until it's 50 years later. Yeah.
Yeah.
I mean, at
Which
some
can't
point,
be the law.
And
And I know you're not arguing that,
Could
but
the court permit me a moment to just review the case that Mr. Steele just sent over?
sure. Did you send it to everybody?
He did. I got
Okay,
it.
yeah.
I just want to read it.
And just
Mr. Matthews.
Similarly, is civil contempt, and I'm looking at in re estate of Banks. In re estate of Banks is going to be 339 Georgia App 144. It says under Georgia law, when the trial court orders incarceration for an indefinite period until the performance of a specified act, the contempt is civil. A trial court, however, may not continue incarceration for civil contempt when the respondent lacks the ability to purge themselves. Imprisonment under civil sanctions is always conditional, and a party found in contempt may apply for release at any time upon a showing of inability to comply.
Silver
The moment
Fox.
it appears that there is inability, it would clearly be the duty of the judge to discharge the party because the purpose of civil contempt is to provide a remedy and to obtain compliance with the trial court's orders. The justification for imprisonment is lost when the compliance is impossible.
Thank you. I think you have hit on the exact case we needed.
Put Silver
So
Fox
that
in the
answers
chat.
the question for me.
Put Silver
You can
Fox
look
in
all
the
you want,
chat.
Miss Love, but I think that pretty clearly answers the question. It, you know, logically speaking, that was kind of what I was feeling anyway, but now we got case law to back it up. Good deal.
Yep.
All right, so
Let's go, Silver
so
Fox.
I am proposing that if Mr. Melnick is in fact representing Mr. Copeland, I ask Mr. Melnick to please make sure he understands the order, the scope of his immunity, which I read to be derivative use as well, and what perjury means, what false statements mean, what could get him either of those charges, legally speaking. And I know Miss Love, you and Miss Hilton had said there are certain things that even, okay, well, in your discussions conceptually with Miss Bumpus, but I'll leave it with Miss Hilton, had said, I am not intending to charge you with perjury if you do X, Y, or Z. I am intending to charge you with perjury if you do A, B, or C. And Miss Hilton's not here, but you could speak for the state, I would think, as to if there are certain things that you absolutely know, if you say this, and we know we have proof, whatever you need to establish perjury, that you're lying, then we do intend to charge you, if you know. You know, if you get up and say something that's not material, like, you know, oh, the sky's red today instead of blue. I mean, it's not red, it's blue, but who cares? It's not relevant. Then I'm not going to charge you with perjury for that.
And I think that was along the lines of what the intent was, but you know, the intent isn't really an issue. It's the reading it. I'll just say I agree with what you're saying.
Okay. And, you know, if you then say, I don't know, I don't remember, blah, 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 to whatever, every question we ask you, then we will impeach you with prior inconsistent statements. This is what this means. And you don't have to explain that. Mr. Melnick can explain all of that. But I would just propose to make sure that I ask Mr. Melnick to explain all of that. Then he can confirm, yep, we've done that. And then if he has any questions, we'll take questions. And I'm even happy to say, you know, sorry, when you get a jury question.
There
we
you
can
go.
huddle
Was
and
not
go,
truthful with the
planning to
witness.
say
Thank
this. What do
you.
y'all think? If y'all want me to do that, or I'll just wing it. Either way, if y'all are fine with me winging it, I'll wing it. But don't wing it. Okay. All right. So that's kind of what I'm thinking we do at 3 or 3-ish or whenever we have Mr. Melnick available. And then maybe give him, assuming he is the attorney, overnight to fully advise him of everything. And then we'll have him in maybe first thing and find out what he's intending at this point.
John, I mean, I inquired the court regarding the court's earlier statements about the case that Mr. Matthews cited. When it talks about an impossibility, is the court's understanding of that after the trial is over, after this particular portion of this indictment is over, it's no longer possible to purge oneself?
It would no longer be if you've said, I'd have to have your motion in order in front of you, but as I understand the motion in order at this point. We need his testimony for this trial. Now, you may also need his testimony for some other future trial of some indictee in this indictment. I would think you would need to seek and secure another order. I don't have it in front of me. I can look again, but that is my read on this. I mean, you may never try another person. We don't know that. So how can it not be that, as far as we know, he's no longer able to purge once this trial is over?
Theoretically, given Part B of that statute, would he not?
I've made my decision and I get it, but I don't think that, I just don't think that that supports your argument. So I think unless and until you can bring me more law, I'm done with it might mean with this part of it. Okay. All right, so let's go back to our narrowing down, figuring out what needs to be redacted out from these statements of Mr. Zachary.
Your Honor, may I inquire one more thing? If Mr. Melnick intends to not represent Mr. Copeland, what is our position at that point?
I guess we can ask him, does he want an attorney? And I have inquired, because I don't know the answer, of the public defender's office, whether in a kind of situation like this, where you have somebody who could have been indicted, who's not currently indicted, who's been given immunity, assuming he would qualify for their services, could they or some conflict attorney provide representation?
Judge, I would tend to agree that seems to be the most sensible thing to do. I mean, at any point where someone's liberty is at issue, the court should at the very least inquire as to whether or not there's representation that can help a lay person, Mr. Whittiers, navigate his way through these things. So I would agree with the court's inclination.
Okay. And if for whatever reason, a public defender or conflict defender cannot represent a witness, although I would think they could because of what you said, as long as they qualify, his liberty is potentially at stake, then, but if they can't for whatever reason, then I don't know, we just have to.
Then I would suggest that the court take it upon itself to do the best the court can to advise the witness appropriately without any input necessarily from either party. The court is less vested in Mr. Copeland's testimony than either side, and so I think it will be the court's responsibility at that time.
What's certainly ultimately my responsibility, but I am soliciting from both sides whatever they think would be appropriate to advise him about. And I can then take it all and look at it and put it together. I'm not saying just because y'all asked for it, I'm going to advise it, but I would like your input on it, particularly given issues that have been complained about his prior advisement. So,
good.
All right. Okay, so let's turn to, somebody needs a bathroom break. So I know we just got back here 30 minutes ago. Y'all should have gone to the bathroom before then, but we'll take a bathroom break quickly. I'm just going to stay here.
A bathroom break, really? You just came from lunch. This is ridiculous. Sounds like somebody need more time to get their stuff together. I wonder who need that bathroom break. I just wonder. So I dropped something in the chat while they're on break about statutory immunity. Where you have transactional immunity, where prosecutors can offer you immunity based upon a transaction where you are going to testify about something, of course, and then they can give you immunity or whatever. But when I looked up this statutory immunity, the court ordered a court can order that you could be they could compel a witness. I'm sorry. This is a court order that compels the witness to testify. I don't like that because again, what I'm reading right here, it says prosecutors can grant immunity to witnesses in exchange for testimony in both state and federal law. Okay, we know that. This is called transactional immunity and can be used for a variety of crimes from minor theft to murder. Prosecutors can override a witness's Fifth Amendment privilege by offering immunity, and the government can provide immunity in two ways: statutory and letter immunity. Statutory is when they order compelling of the witness to testify, and letter immunity is when there's a voluntary testimony based upon agreement. If a witness agrees to a deal that includes immunity, they must testify as promised. Okay, that makes sense. Refusing to testify can result in jail time, fines, or being held in contempt of court. However, the government can still prosecute an immunized witness if it can show that it didn't directly or indirectly use their testimony. You can waive immunity. Immunity is a privilege. The immunized person can therefore waive it. One way is to explicitly state the intention to waive the privilege. So you don't have to take immunity. But if a witness refuses to testify on Fifth Amendment grounds, the prosecution has the option of granting the witness immunity and thus eliminating, at least theoretically, his or her fear of self-incrimination and consequently his or her right not to testify. So the loophole of this immunity thing is absolutely insane. So basically, you can do this to anybody. You know what I'm saying? Now, with the fact that Woody, yes, it's going against his rights, and what's happening is D Pill said that is going against his rights, if I'm correct. Absolutely, and that's the thing, is that it's very conflicting. He has a constitutional right to remain silent. He has a U.S. constitutional right to remain silent. And you mean to tell me you place a contradiction in it when it comes to immunity in the court of law based upon testimony? So if a person is afraid that they will incriminate themselves during testimony, they don't want any words used against them during testimony, or if they want to waive the fact that if they say I don't want to testify, of course you can get subpoenaed to testify. But if you say I don't want to testify, then they go to, okay, well, we could compel you to testify. We could compel you by giving you immunity. But there has to be a process that it goes through. And I think that's the actual issue in this case, is that they didn't go through the proper process. There's a process that you have to go through in order for immunity to be granted. It says here, we come with the research, baby. It says here, immunity requests can be made in various contexts, including criminal and civil cases, administrative proceedings, and legislative inquiries. In the United States Department of Justice, immunity requests must be submitted to the criminal division, even if the subject matter is assigned to another division. Okay. So it has to be submitted to the criminal division. Did it get submitted? No. Well, it went straight to Fonnie. Remember, Fonnie is the one that wrote out the immunity. I mean, how powerful is the DA? I mean, I guess the DA can override that process, I guess. I don't know. Let me know what you guys find out, because we're researching this together. I have no idea. Can district attorneys Bypass. Who's attorneys force immunity. Prosecutors, including district attorneys, have absolute immunity, which means they cannot be sued for their official actions as long as they are acting within the scope of their duties. Dang, man, this is crazy. All right, they're back from break. Let's go. Remember, district attorneys, prosecutors have absolute immunity. They have absolute immunity off rip just because they're a prosecutor and a district attorney. They can do whatever they want, man. Yeah, exactly. They forced him to testify, and they building this case around his testimonies, around his interrogation videos and stuff like that. And that's the reason why they want to admit those in the court, because they know that he's not going to testify. He'll sit in jail. He don't care about going to jail. He'll sit in jail if he wants to. You know what I'm saying? So, but you can't coerce immunity. Compel is one thing. Coercion is another thing. He was definitely coerced for sure.
How about resignation? Because, yeah. Fair enough. All right. So, and whenever Mr. Selman joins us, we'll just take a pause.
The microphones, man. I can't hear. We can't hear y'all, man.
All right, so we're now going to be on page. We're now going to be on page 75, lines 10 through 78, line 1.
Exactly. Abundance. Exactly.
Hearsay about who shot at Woody and who shot Boo, and I'll have to look at it. Oh, and by the way, I was, going to circle back and listen and look at the video on that one item, and nobody, to my knowledge, sent me the video, so I haven't been able to look at it yet. Can y'all?
I've uploaded, I've neglected to inform the court, I uploaded that Dropbox link for recording. So.
I don't know if I still have that Dropbox link. I don't know. Can you just shoot me the link again?
Yes, sure.
Okay.
I try to keep the same link for the transcript, so I will resend that link. And there's one long version of the video, and there's a smaller one where it breaks it into smaller chunks. I've used DLC to operate. I don't know if the court has that player on your system.
I think so. I think we have that one.
I will resend that, Your Honor, right now.
All right, great. Thank you. Okay, so let me.
I recommend that you send smaller chunks, so bigger chunks have a harder time.
Actually sending, yeah. All right. And is this hearsay?
So, Judge, what did you,
So we're at 75 line 10 through whatever the next thing is, 70. Where are we? 78 line 1.
So I don't have any objection to 75 line 10, where Dennis says, what'd you hear about them when they tried to shoot Woody? All the way down to line 17, no objection to that part. But when Quindarius Zachary starts talking about, when he says, oh, you talking about where they got shot at, and then Dennis clarifies when they made this post the following day, Zachary says that's when their spot got shot up. That was the next day, though. You're right. And when I think it could be seen a number of ways, but when he says Woody went to the hotel party and basically Kel got locked up when Lucci's mama's house got shot up, and Zachary says, yeah. And Dennis says, right. And Zachary says, yeah. If that portion is being offered for hearsay, if that portion is being objected to on the grounds of hearsay, I would say that that's just a matter of showing the proper foundation. And I would ask that that not be excluded before that foundation is properly laid. If it can't be laid, if we don't lay it, then we don't try to get it in and we don't backdoor it in any way. So I would object to lines 18 through 23 on page 75, lines 1 through 6 on page 76. And as
Okay, well, I mean, that all seems to kind of be like the question on the floor for discussion, right? I mean, they're like saying, okay, what is it we're talking about now?
So, Judge.
Yeah.
Big Boo is someone who's deceased, but sorry. Big Boo is someone who is deceased, but what they're talking about him getting shot at, that was not what killed him, to my understanding. But this is all just nothing that Mr. Zachary, to my understanding, has any firsthand knowledge of. And then they talk about Woody getting shot at when he went to a hotel party. That case was never charged. I've never seen anyone say they know who shot at him, and this is just more speculation and hearsay. I have no reason to believe that Mr. Zachary was at that party. And then
I withdraw the objection. I'll stipulate.
Okay, so that carries us through all of 76 or down through more, it looks like.
Well, then they
Through
start
78 line 1.
Okay, all of it.
Yeah.
Okay,
This is a bunch of hearsay, man.
thank you.
What is going
So
on? Hearsay is not
entirety
evidence,
of
Ms.
what
Love.
is represented by our number 20.
Jeez, oh, Pete, get it through your
is
skull,
rejected
man.
by agreement. All right, 21. That's page 79.
She is
line 14
hard-headed,
through
dog.
22.
She's a hard-headed chick,
Speculation
bro.
about who shot up.
You cannot use hearsay as evidence, okay? Please stop. Please stop. Thank you. They have no case. You're right, Vanessa. Thank you. They have no case. Please stop. You have nothing concrete. The most concrete thing we have seen throughout this whole case is a gun
It's pretty clearly speculation.
and some shell casings.
We don't have a problem.
Okay,
That's it.
So that is out by agreement.
This falls under the hearsay
So we pick
exception
up
of this would hurt my.
there
It's not allowed, Your
on
Honor.
line 23 down through 81 line 5.
Why is she trying to add something? Because she's crazy.
Your Honor,
Okay, this is why
Tyreek, I think there's a gentleman named TJ Rivers.
Uh-huh.
I believe that's his last name. He's not charged in this case. And then Tyreek was his brother, and apparently he was killed by someone at some point.
Yeah,
Gee.
I mean,
It has-
that all seems just like, they're kind of like, well, while we've got you in here, what might you know about any other shooting that ever occurred?
Right.
Yeah.
It has nothing to do with this case, as far as I know.
What say you, Ms. Love?
I have no objection to, I'm just gonna go down the list, the latter, page 79, 23 through 24. I have no objection to, page 80, the entirety of page 80. What do we want to do? And up through page 80.
They're saying 81 line 5. Let's deal with that. I mean, that all looks like,
So Slug Trontavia Stevens is a member of YSL. He's already entered a plea in this case. And Quindarius Zachary's association, knowledge of, affiliation with Trontavia Stevens. When investigator Dennis says it went quiet for a little while, and then Mr. Zachary, that is, gives this explanation.
is that supposed to say?
I can go without that. So
All right,
1 through
so-
5 I'll
Okay,
stipulate.
all right. Thank you. All right, and then our next thing is so that one's incomplete, it looks like. 81 line 13 through 82 line what, Mr. Sharp?
I think to the end of 82. Oh, well. You know, I would say 82 line 6. Or actually 82 line 3. I don't really have a strong opinion about it. I just, my problem is when the police start talking about ballistics and this matching this. I mean, if it's relevant, that information obviously can come in if it's relevant and you know, fulfills all the other requirements, but that would come in through a GBI expert matching ballistics, not through Investigator Dennis sharing information with Mr. Zachary.
Yeah. Okay, so Ms. Love?
I have, if it is, and Judge, I apologize, Mr. Atkins just apprised me our server's down, so he wanted to get my external drive to share those videos with you.
All right.
So I was.
That's okay. So we're talking about 81 line 13 through 82 line 3 and
No objection to the rest of 81. So from line 13 down, no objection to that. So 13 to 23?
No, yeah, through 82 line 3.
No objection.
Okay. Thank you. All right. Now we are looking at 83 line 18 through 84 line 21.
That's already been agreed to.
Oh, perfect. Okay. We're looking at 88 lines 1 through 13.
So, Your Honor, let me be clear. This is my understanding. Mr. Zachary, after I read this and then I've since read his other statement. I reviewed them both. I should
Right.
say. I've read them before, but I was unclear if Mr. Zachary was claiming to have been present at the club compound incident. After reading the first in time, second in that I reviewed statement,
Mhm.
it's clear to me that he does claim to have been at compound.
Okay.
My understanding, but there seems to be a blending of what he saw versus what he was told, because my understanding is at some point he flees from the area. He is definitely, by his own words, not on 285 when Lil Wayne's bus is shot. So he can testify, or he has firsthand knowledge, presumably, about things he saw while he was there. But when he says Pee Wee ain't do the shooting, he wasn't there for the shooting. And when he says, I know who left and went behind it though, and he says DK and Shannon. So he's saying Walter Murphy, who's entered a plea deal, and my client went behind Pee Wee's car, Jimmy Winfrey's car. So to the extent that he has firsthand knowledge of things, I concede that he can testify to what he saw, and anything he has firsthand knowledge of that is inconsistent, if he had in fact had firsthand knowledge, he can be impeached. But there's certain things that he speculates, or maybe someone told him, I don't know, but it's not clear to me. So Pee Wee didn't do the shooting. That's a conclusion. He did not witness the shooting. He did not witness anyone do the shooting. So I think that's inappropriate.
Okay, so that is 88 lines 1 through 3, basically. And even the police are like, yeah, we know he didn't do the shooting, so.
Well, people in Cobb County would be interested in that, but.
Okay, well, I don't know. I mean, maybe they're just saying that to see what he's gonna say.
But then he says, I don't know who was exactly in the car. I know who left out and went behind it though.
Yeah.
So to the extent that if he witnessed a cars leave compound, I get it.
Right.
But beyond that, things that he did not witness, that's what I'm objecting.
I understand. So I'm trying to kind of take it piece by piece, because you're saying he cannot say with certainty Pee Wee did not do it unless Pee Wee was with him at the time. Okay, do you have any basis for?
Well, the portion of it where, so Mr. Zachary, like Mr. Copeland, makes assertions about the shooting itself and who was doing what. And the way that the shooting happened is a person is driving down the road next to a bus. And in order to be able to both drive the car and shoot the bus, from the way that both vehicles are positioned, you would literally have to have one hand on the wheel, and it was a precarious kind of circumstance that would be needed for the driver of the car, who is Mr. Winfrey, to also be able to at the same time fire the gun and shoot the bus. So in as much as it reflects his personal knowledge of all the people who were there and what was going on, we would argue that his assertion that Pee Wee didn't do the shooting would be subject to a foundation that, you know, we would seek to lay, and I can't say that we have laid that part yet. I think that he is just saying he didn't do the shooting. He was a party to the crime, but he didn't do it. He was driving. He couldn't have.
So is Mr. Zachary in a second car that's involved in this?
So he is in another car, but he is not shooting. He's not in that.
He's not in the shooter car, but he says, you know, me and these other people went the other way. So he's
compound.
right.
Everybody shows up at this one place where
Yep.
Wayne is in about 5, 6 different cars.
Okay.
And 2 of them at least follow the tour bus.
Okay.
He is not in one of the ones that follow the tour bus.
Okay. But he's there when you have reason to, you have evidence that will support that he was there to be able to say at least that as to the car that wasn't, as to some car, the car that went behind it, that he saw who was in those cars?
Yes, he
Okay.
says, Mr. Zachary says, I know who left out and went behind the car. So he
Yeah.
says, and the fact that he's asserting Buchanan Shannon, if he's crossed on that I would argue that goes, it's way not as admissibility of Mr. Sharp.
Okay, but yes, and thank you. But I guess what I'm at, or what I'm trying to get clarification on is Mr. Zachary, it sounds like from what he's saying is he's there when everybody kind of goes in whatever direction they're going. And you're saying that that's his basis of knowledge for who's in what car, right?
Yes.
Okay.
Even at the point where, like in line 14 of page 88, he's saying, me and Trontavious, we don't went the other
Right.
way. Yes.
It sounds like that's all kind of contemporaneous that they're leaving out. Okay, so then I get that there is a basis on which to believe that he has firsthand knowledge to be able to say, I know who left out and went behind it. Who was that? Well, here's who it was. But coming back to the Pee-wee ain't done the shooting, if that's something you want in, then how does he know that, what's your basis for him being able to say that?
At this time, I wouldn't even proffer it. So I would agree to it unless something is said that changes.
Okay.
Because I don't have, there's never been a time where I heard him say, you know.
Okay, so then by agreement then, well then why do we need 2 and 3 and 4? Because they're just confusing without line 1, right? So 1 through 4 are out by agreement. So then 5 through 13, well, 5 through, how about?
So, but 5.
How about that? I mean, the 5 through 9, I see as kind of a one little answer that he seems to be able to know. They say truth was with them. Well, and then what about that part?
I don't mind 12 through 13 coming out.
Okay. Okay.
So we're at, the next one is 90, page 90, 11, page 90, line 11 through 90, line 14.
Correct.
Let's keep in mind, you all, that we're doing all this and we don't know if it's going to be a mistrial or not. Just keep that in mind. It's absolutely insane.
Those are words of the police.
Oh, Mr. Melnick is here now. So he's not here on the Zoom, virtually here. Do y'all all have the Zoom link? I mean, you're welcome to, I see that'll show up on, does it show up on that big screen? All right, so y'all can just watch it on the big screen.
Are you ready for me?
I am. I think I say yes, and yet I think I need to probably turn my camera on. There we go.
Thank you so much, Deborah. I appreciate you. Deborah Riley says, just showing a little support, $10 Cash App. Thank you so much. I really, really appreciate it. Everybody put
Hi,
Deborah
Mr.
in the chat.
Melnick.
Good afternoon, Judge.
Everybody put
can't get
Deborah
enough
in the
of you.
chat, please.
All right, so the reason I have asked
Thank you so much.
again for you to join us, and thanks for doing this by Zoom at very short notice, but so I have essentially determined somewhat with agreement of the parties that we are just going to start over with Mr. Copeland. And he has an immunity. There is an immunity order in place. He has immunity protection. And I plan to bring him in and find out what he wants to do. And I would like for him to be counseled. And I just had him in here a couple of hours ago and asked him if he had an attorney. And he seems to think that you are his attorney still. And so I'm checking in with you to find out whether that is the fact, either still or again, whether you're going to be representing him, because I'm looking for somebody to just ensure that he is properly advised of what the immunity order means, what he could face contempt-wise, what perjury means, what inconsistent statement means, you know, the typical things you would want to advise your client who's going to be a witness in a criminal case.
Sure. So I've talked to him about all that stuff.
Okay. And so are you his attorney currently?
I am his attorney. Yes.
Okay. All right. So, and you're representing that you have in fact already advised him of all of those things?
Yes.
Okay. All right. So I would propose to, unless he just wants to come back this afternoon. I mean, I did think I told him to be available maybe 3-ish. But if you want to be with us by Zoom, but are you available tomorrow to be here in person if we can have him here in person? That way, if he does have questions as anything's going along, and we're not going to take testimony, I just want to find out tomorrow, does he have any questions? Make sure we clear up a few things and then, you know, find out what his intent is as to whether he's going to testify in this trial or not. We're just essentially going to wipe all of what he already testified to and start over.
Your Honor.
He could be there right now.
Okay. Oh, he's here right now. Okay. Apparently he's outside. So do you want to just stand by with us? And if he has any questions?
Sure.
Okay.
And Your Honor, before he's brought in,
yeah,
I would object to him being asked at this. I'm gonna just talk loud. Your Honor, I would object under all of the circumstances for a number of reasons to him being asked at this point whether or not he is going to testify. There have been so that he's made statements. Obviously, the state has brought him in as their witness to proper testimony against people in the courtroom. And he's made representations, true or false, he's made them regarding concerns that he has. He's made them in previous interviews with investigators, not just you.
Okay.
So, Your Honor, in the interest of not having sort of the opposite effect on him, and I'm not suggesting the court would, I'm just suggesting that perhaps asking him at this point might have a
when do you propose I ask him? Because if you're, I don't know exactly what you are suggesting, and I could be entirely off, but if you're suggesting that he has, are you suggesting he has safety concerns?
Well, he has made statements about people being willing to have him killed. Okay.
All right. Well, to the extent that those might be any of the people currently on trial, he is at some point going to have to sit in this witness box and say, with all of the defendants present, yes, I am going to testify because y'all are forcing me to because of the immunity order, or I do not care, throw me in jail, you know, essentially. So that's going to have to be in open court in front of everybody. So If that's your objection,
Just the timing of it.
so would you rather I do it Friday? I mean, what, I don't understand what it is you want me to do.
It was a preference, but I'm gonna, of course, defer to the court. It's just, you know, as I work through everything that I know has taken place, I'm just, trying to, make certain that the interests of everybody are protected.
Okay, I'm
not trying to create a.
no, I understand. And I mean, I'm just not sure what else. I can do it at a later time, but I don't know what that gets us really, other than more uncertainty. And I also realize he may say one thing right now and then another thing right before he is brought out in front of a jury. You know, I don't know. We can still check with him again because we are not at this point having a jury in here tomorrow. So at the point when we get to a jury, if we get to a jury again, then I can ask him again to make sure. I think that would probably be advisable, but everybody's here right now. So I would propose that we do this kind of right now. But before I bring him in, does anybody have anything they want to make sure I make clear with him?
Not for me, Judge.
Okay. So Mr. Melnick, you weren't here when we had our discussions about what was the outer limit of how long the court could hold him if he chooses not to testify. And it is my belief that the longest he could be held on contempt would be through the end of this trial. So if you need further discussions with him, let me know that.
I don't think so, Judge.
Okay. All right.
And Your Honor, and I know Mr. Melnick obviously knows how to do his job, but he wasn't, and I don't know how much he's reviewed the transcript.
Let me actually ask him, have you reviewed that transcript of the June 10th ex parte?
Mostly. I haven't. I can't say I've sat and studied every single word of it, but I've mostly reviewed it. Yeah.
So, I mean, the defense believes, and I don't necessarily disagree, that there, in addition to a different interpretation of how long he could be held, there is currently a different interpretation of the correctness of the advice about statutes of limitation. And we also think it doesn't ultimately matter because what is protecting him should he testify to something that he did that's criminal is not whether a statute has run or not anyway, it's that he has immunity. But it's possible that a couple of, every statute that you could be worried about has run is not accurate. So, I think you were aware of where in there they said something about a statute, and you're probably aware that there are things he could still be charged with. And does he understand that not every statute has necessarily run on everything he might be criminally involved in, but it doesn't matter because of this immunity order? Or I don't know whether, go ahead.
Yes, Your Honor.
Okay. All right. And then, are you confident that he has a sufficient understanding of what might subject him to a charge of false statements or perjury?
Certainly he does.
Okay. Anything else y'all can think of on either side of the aisle? Okay.
Yes,
The
Judge,
fact that he
can we
got
inquire as to,
misinformation should be
whether or
enough to
not
just
Mr. Melnick,
remove the
and I'm
whole
sure he
thing.
has had an opportunity to discuss with him any potential federal ramifications he may have in regards to his testimony here.
Okay. And my interpretation of the immunity order is use and derivative use. But of course, we're not the feds.
And Your Honor, the court has every ability to do this, but I would object to counsel for the defense.
I've asked them to raise anything that they think we ought to be thinking about. So You know, I invited them to say that. So I don't know whether you want any additional time, having heard that potential issue, Mr. Melnick.
Mr. Copeland and I have had enough time to talk.
All right. All right. Okay, is there a screen where he can actually see Mr. Melnick over there?
Let's go, man.
Somewhere? Okay, thank you. All right. Let's go ahead and get Mr. Copeland in.
Here we go. Everybody put Woody in the chat. Everybody put Woody in the chat. Let's go.
See you later.
All right. Hello again, Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning from the bench and the stand to talk about the fact that the state is not interested in you pleading the fifth, and in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify, because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for, if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility. But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said at the beginning.
Didn't understand anything. All right, so.
No, I'm saying, like, I heard you, but I don't know what you're talking about.
Okay, so tell me what it is that you'd like more information about.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay. Does anybody, I think I've got the order. Mr. Melnick,
What
have
you
you
mean in the
reviewed
chat?
the immunity order with him?
Oh, you saying it's the same from last time?
Hang on a second. Yeah, the same one as last time. Yeah,
Yes.
that one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
All right.
So what has changed is, it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier, and I don't think that is
So I ain't got to wait
accurate.
till every defendant that's not here.
Correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while, but that would be the end of it, would be the end of this trial. Okay. So do you have any other questions? Okay. And do you want to talk to Mr. Melnick anymore about this particular issue?
No.
All right. So I'm going to ask you right now, because I'm planning to have the jury back on Monday. And I am going to tell them we would essentially start over because I want you to have a voluntary, to an extent, choice and knowing choice whether to take the stand and be questioned and cross-examined or not. Knowing that if you do, other than if you lie, as Mr. Melnick's discussed with you, and it's something the state knows and can prove, they could charge you with perjury or false statements, but they can't, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime. And they can't say,
Well, can I speak?
You can,
I
yeah,
have
if you
told
have
the
a,
state,
huh?
I have told the state I have lied and lied and lied and
I
lied.
know, and
So how are they gonna be able to question me?
I mean, that'll be their problem. That's their case to make or not make. I mean, that's not for you or me to worry about. So
They said they're gonna be able to charge me if I lie. Like when it's up to them to choose when I'm lying.
not prior. You've said you've lied and lied and lied in every, I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know, I mean, give me an example of something that you know he didn't do, and well, maybe not, never mind, don't do
Can I
that.
give you an example for what they told me?
Yeah, yes, and then I'll see whether that's what I think or not, yes.
So she said that the only reason she won't lock me up, I just want to know if it still applies.
Okay.
She said if I do two things, if I plead the fifth and I say that I killed Donovan Thomas.
Okay.
She said if I don't say them two, she will not lock me up.
All right, what was the first one?
Pleading the fifth.
Say it again.
Taking the fifth, Judge.
Taking the fifth, okay, right. And you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you could then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can say, I can admit to a crime on the stand, they can't charge me with it. They have said, you no longer have a privilege against self-incrimination because we have committed to not being able to prosecute you, not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. If you say, well, I committed some crime, here's what I committed it with, I buried it in the yard. They can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. So that's why taking the fifth at this point would get you in trouble. Being held in contempt is what we
So where they don't have
formally call it.
they facts together, like they saying something that they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now, if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime. For instance, somebody gets robbed yesterday and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe, and they got video of you in Europe and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying. And so that they could charge you with perjury for, okay? Or false statements for.
Okay.
Okay, so what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated to come, and I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me, I'll tell you whatever I'm going to tell you? Or are you going to say, nope, I don't care if you throw me in jail. I'm not saying a word. I am not getting on the stand.
It depends on how I wake up.
Okay. All right. Well, then we will just revisit it on Monday morning. So plan to be here at 8:45 on Monday morning. You're free to go for now. All right, Mr. Melnick, please be with us at 8:45 on Monday morning. Can you do that?
Okay.
Thank
I'm
you.
on a trial calendar with Judge Barwick, but I'll notify her what's going on.
All right. Thank you. Appreciate it.
Wow. Depends on how I wake up. Let's go.
All right. So there we have our answer to the extent we have an answer. We will revisit this on Monday morning.
Miss Love don't like
By the
that.
way, when I plan to have the jury back.
Look at Miss Love. She don't like it. You
We
can
at
tell she don't
least-
like it.
I have some degree of confidence that he understands what his choices are and what his consequences are.
That boy been in the system all his life. He
back
knows
to
what's
Mr.
going on. He is not
Zachary's
slow at all.
testimony.
He understands all of this.
Everybody good? I mean, I know
Don't
we
get it
just took a
twisted,
break.
man.
Anybody need a break before we dive back in again? Yes, all right. I didn't take a break before, so I could use one now. Let's take 10 minutes. Be back at 5 after 3.
Woody, you never disappoint, man. You never disappoint. Good answer. I'm telling you, it's a good answer. I'll let you know how I feel about it when I wake up. Look, Woody understands what's going on because he was able to see the judge, man. The judge cuts him off, just cut him off because he mentioned something else. He said, I can't admit to the fact that I unalived Donovan Thomas. It's the fifth, and it's that too. It's either or, you know. And so, man, this is interesting, man. So Monday morning, 8:45 is when she's saying the jury come back. I'm not sure. I mean, look, I don't understand, man. I'm a little bit off with this because, again, you know, the fact that it has come into question that there was an off the record situation, and the situation has something to do with being able to exonerate the defendants. I don't understand how you could say the jury will be back by Monday if you have not ruled on the motions for the two motions from Shart and Weinstein, and the fact that you haven't even considered the potential Brady evidence that occurred under Caleb Bumpus's witness testimony yesterday. Exactly. That y'all peeped that. See, that's what I'm saying. She cut him off when he said Donovan Thomas. Yeah, he doesn't fully understand it. I get what you're saying. Yeah, he doesn't fully understand the immunity deal. Because again, derivative use and use, they're similar. They're pretty much similar to each other. Whatever. It's nothing. It's nothing. You know what I'm saying? And so the fact that it's not going to change is an issue. Again, if I mean, total immunity would be more sufficient for this. Lisa Butterfly says it would be hard to find a more clear example of a disallowed ex parte motion for which the sanction of dismissal with prejudice is warranted. If not this case, which one? Exactly. I just it is so it violates so many things. And again, they gave him misinformation, or they gave him the wrong, incorrect information throughout that transcript. And that should be a strike, a huge strike against the prosecution. A huge strike against the prosecution. Absolutely. There is no way that the prosecution, they said these things to coerce him, to compel even more, because they're banking on his witness his testimony as for the case. They're banking on him. He's the star witness. But you gave him information that you knew was not correct. And if you didn't know it was correct and you misspoke, then again, you have done some more misconduct. So you should not. So if I'm the judge, or if I'm thinking correctly, and Chad, help me out if you're still with me. I mean, shouldn't the immunity should be revisited? I think the immunity part should be revisited. If you're talking about getting him to testify or whatever, since we know statutory immunity is a thing where they could just compel you to testify and override your Fifth Amendment right, which is absolutely crazy, but prosecutors can have absolute immunity, which is insane. Shouldn't the immunity be eradicated and gone through the proper steps so he can have the right to choose whether he wants the immunity or not? I mean, most of the time, for the most part, immunity is transactional. So why are you not? If you got somebody you try to compel this man to testify, but you give him the weakest immunity possible. And then on top of that, you have an ex parte meeting that you should not have had, and you give him information that is untrue the whole time. You in there for 2 hours, 2.5 hours. You gave him information that was untrue the whole time, and you had the big dog Glanville in there to do the same, to impose more fear into this thing. This right here is insane. I think the immunity should be completely eradicated and revisited. If you want to revisit it and say, hey, my client would like to have total immunity, because again, what Melnick said in his email is that you need him more than he needs you. And why did Melnick say that? Because Melnick knows they don't have a case without him. Abundance said, remember, Melnick said he would have said immunity for everything and every level. Exactly. Total immunity. Total immunity. So you don't have a case without Woody's testimony. You're banking everything on that, because all the people you've had on the witness stand, you haven't delivered any concrete evidence about this case. So Woody is the only evidence you pretty much got, because everything about this whole situation revolves around him. It revolves around him. It was his fight. It was his people. It was all him. So you don't have a case without this man. You're gonna give him use, and then you're gonna force the use immunity without going through the proper steps. I know for a fact that the DA's office did not go through the proper channels to get that immunity deal. You found out you knew this boy had a lawyer, and you talked to him behind his lawyer's back, behind counsel's back, and then Melnick emails you and says, look, you are talking to my client without my permission. You are talking to my client without my permission, okay? And so you should stop doing that. That's prosecutorial misconduct on the highest levels. Oh, we didn't know. He told us you didn't have an attorney, blah, 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 whatever. Lies, lies, lies. You knew he was his attorney for a long time. And then what happened? All of a sudden that night, that evening, there's an immunity deal from Fonnie Willis, and you serve it to him the day that you need him to testify, June 7th, that morning. When they walked up to Woody on June 7th that morning and gave him that piece of paper about that immunity, that was the first time he seen that. That was the first time he seen that. And guess what? That's the first time America even knew this. We all found out that he had immunity, including him. Melnick said right there in court, in open court, My client wishes to invoke his Fifth Amendment right. Okay, stop right there. Even if he's held in contempt based on this immunity for pleading the Fifth because he has immunity. If he wants to invoke the Fifth and go to jail, that's his prerogative to do that. If he wants to do that, that's his choice. That is his choice. The Melnick told the court. Melnick told the court he's going to invoke the Fifth. That's what he wants to do. You slap this immunity on him that day, and then all of a sudden he's like, okay, man, I guess I'll testify. Because he doesn't know, he's confused. And that's the reason why Melnick was like, look, I might have to do this noisy withdrawal on you, dog, because I don't know what they told you or what they doing over there. I don't even know if I can represent you properly as a witness in this case. He's not only was Woody conflicted in this situation, also Melnick was as well. And the state knew this. This is not best practice of law, man. This is disgusting. I got to be honest. I'm disgusted, man, at our judicial system, period. And this is the reason why we can't get caught up in the world and what the world does, man, because this world is corrupt and evil, sinful and destructive. It's crazy. I mean, I'm talking about as a body of people, man. This is absolutely nuts. We have people in that's supposed to be prosecutors, that's supposed to be upholding the law to the highest level of its integrity, and they will do whatever they can to take a shot on it. Seriously. Like I said, with my situation, I got my first taste. I'm like, you know what? This right here ain't good, man. It is so much that goes on behind closed doors in these courtrooms, man, in these court offices. And then you have prosecutors who, I mean, and again, there's nothing wrong with it, but they donate to people's campaigns and stuff like that. And, you know, just like Brian Steele did for Judge Whitaker, they hosted a re-election party for her and gave her donations and stuff like that. And that happens a lot of times. And in the state of Georgia, there is an allowance of a certain amount of money that someone can donate. I believe Judge Glanville donated like $2,000 to Judge Krause before for her reelection. You know, that I think she got reelected earlier this year. So again, this is just a wicked system here, man. And this is totally disgusting. I'm just like disgusted right now because there is nowhere in the world we should even be entertaining. We should not even be entertaining this situation right here with Woody, because you know, based on this ex parte transcript and the previous ex parte transcript that was included in the supplement motion from Weinstein, the ex parte of June 7th, after court was over with, that there was some bias, gossip between the prosecution and the judge. Then you have another ex parte meeting that Monday morning, and Woody talked about what happened in between those few days where they put him in jail, didn't give him no food, all that kind of stuff. He didn't get a lot of water or whatever the case may be. They took him from one jail to decab. I covered that. I covered that video. I did a video about that too on my channel, where I was interested in what happened in between those days, because after this ex parte meeting, I'm like, okay, so what happened? Like, did they transfer him or what did they do? And that's exactly what happened. I was just pondering in my thoughts about it. And I'm like, this is absolutely crazy. So you mean to tell me you can coerce somebody? Like, this is an ex parte meeting. You can coerce somebody now, man? This is insane, man. And you can get away with it. You can get away with this stuff. This is absolutely nasty work. Nasty work.
Okay.
Everybody put nasty work in the chat, man. All right, we back. Here we go.
All right, so I think we are on page 90, lines 11 through 14. Okay.
She about to go ahead and deny these mistrials. Watch. This is sad, man. I feel like you, Ricky E. If you still watching, man, I feel you. I don't think there's. I don't see no
That's law
mistrials
enforcement
being granted.
speaking, basically saying that how Shannon involved in everything. So when they hear his beef, it's almost like call Shannon. That's the detective.
Mhm.
And then the other detective follows it up with Shannon, the shooter.
Yeah.
Now, I will say on page 90, line 14, I should add this. I've reviewed all these statements and I've written notes where I feel that the transcript is insufficient. And my notes I have on 90, line 14,
Mhm.
Underwood, Investigator Underwood says Shannon the shooter. And then Dennis says because, and then Underwood says Shannon the shooter again.
Okay.
So that's my objection is the police
All right.
labeling my client the shooter.
Well, the answer is good for your client.
I understand that, but I just.
But yeah. All right. What does the state say?
Your Honor, it's a question,
No.
it's not an assertion.
No,
They're
it's-
asking is Shannon the shooter, and the inflection given by any person repeating it wouldn't do as much justice as listening to it.
Well, I will happily listen to that as well. But even if line 17 is a question that is saying Shannon the shooter,
Right.
then we probably could just go with line 17 and not like the 11 through 16.
So.
What do you think?
So 11 through 13, we would object to being excluded because that's Detective Dennis asking of Mr. Zachary something about one of the defendants currently on trial based on Mr. Zachary's relationship with him and affiliation with him. I don't have any objection to 14 through 16 coming out.
Okay.
That's what they want, but we would ask that the court, I think Mr. Atkins has had an opportunity to send the link to the, no, he hasn't. He said it's taking 31 minutes.
Yikes.
So I may be able to, I don't know if.
I mean, if y'all have it and could just pull it up, I can listen to it right now.
Then also I'll bring it to you.
Talk into your mic, please.
On line 21.
Yes.
Investigator Dennis, my notes say, where it says indiscernible, says about that action.
About that action?
Yes.
Okay.
Speaking of Shannon.
And let me ask y'all, are y'all actually providing a transcript to the jury when you play these statements?
I believe we may have done it once, not with everyone, but I did intend that we clean up the ones that we have and provide a copy to the defense and see if they disagree with any
Okay.
cleanups and allow the jury to use the transcripts because they tend to prove helpful, but that we hadn't gotten to the cleanup part yet. We haven't cleaned it up entirely, and sometimes if the defense has a transcript they'd like us to use and like us to we welcome that as well, but right now.
Okay. And I don't know if the defense would have any kind of a position on whether on that issue.
There's a lot of issues with these transcripts, a whole lot, and just in all honesty,
Okay.
Your Honor, I don't see how we could agree to a transcript without all of us just sitting in here and going
yeah.
through with a fine tooth comb.
No, I agree. And it may come to that, but it may be, a lot of times I think when audio video is played, at least in my courtroom upstairs, there are a lot of times when it's hard to hear. It's kind of like muffly. Even if I take it in my office and listen on my computer and I can hear it crystal clear, for whatever reason, once it gets out here and gets played through, whatever, it's not as clear. Now, maybe down here in 1C, it's a better audio video system and everything's been clear. But I guess if it comes to it, we'll sort it out then. But
Judge, I can, on behalf of Mr. Williams, I can tell you at this point that we're going to object.
Like I hear this voice who is talking. All right.
Is God.
Yeah.
No, I can tell you now that on behalf of Mr. Williams, we're going to object to the jury being provided any transcripts.
All right,
just based
and
on everything
what-
that's happened so far.
What would the basis of your objection be?
It's been our experience thus far that we just have significant disagreement with the state on the transcripts that they've provided thus far. And we
Okay.
think, quite frankly, it's better for the jury to make their own determination about what's being said.
Okay. All right. Well, and I mean, it just may be that as we go on, if and when one day this trial wraps and a jury is deliberating, they may want to hear a whole lot over again, and we'll just all have to sit here and listen to it too. So y'all know that, and if that's what happens, that's what happens.
And Your Honor, we would also posit that there is the instruction that the court could give the jury about the transcripts not being evidence, and that they are indeed supposed to listen and take what they hear versus what's written on the piece of paper as
Sure.
evidence.
Yeah, I mean, so I just was raising that to find out, had y'all already come to any kind of an agreement? What was the practice here with this trial? So it sounds like if you want to do that, first off, you need to endeavor to the extent possible to come to agreement on what a transcript says. And then second, if it's necessary, I will sort out whether I'm going to permit that or not. And I'll listen to the legal reasons for or against. But okay, so if you can tell me, I know that first thing you gave me 27 minutes, 30 seconds. So for this one, where would I be listening? Oh, we're going to play it here. Never mind.
We need the Zoom link.
Oh, it's the same one as it was a minute ago when Mr. Melnick was on.
Okay.
And for this, because the only sound appears to be coming out of those two little strange white speakers, can y'all turn one my way? And I think that may be the subject or the reason for the squelch, but I'm not gonna be able to hear it otherwise, unless somebody wants to come up with a little speaker that I can have up here with me.
Again, doing all of this with no
Judge, could the
response to the
court give me just a minute?
mistrials.
I'm trying to get it open
So
and then.
Yeah.
you know what's going to happen.
Okay. And as long as we're going to do this, we might as well listen to both of the ones, and I don't care which order we do it in, but.
Man, I wish I could do IT for them for real. Yeah, no mistrial, man. Yeah, I think we're gonna get those revoked. They're gonna be denied. Yeah, they're gonna be denied. I don't think this is gonna happen. It's crazy. There's an actual budget for courtroom audio systems in Georgia, in the Georgia budget, in particular, the Fulton County budget. I actually was able to find their budget for the year, and I was able to find the budget that was under Fulton County. I think they had like $36 million-ish of the $1.2 billion that was given to the state of Georgia, and they had the upgraded audio in the budget. That was a part of their budget, is to have upgraded audio system in the courtroom. Another part of the budget was also to rebuild or redo the
Y'all can go ahead. I mean,
Fulton County
look,
jail. They
Is
haven't
the
done any of that.
video matched up with the audio when y'all are showing video in court, or is there a lag?
Sometimes there's a lag if we use a server, but if we do it from a hard drive.
Okay, so that's what y'all been doing, is using a hard drive?
We've done both, and
Okay.
that's what happened.
All right.
Exactly.
What are we gonna be doing right now?
A hard drive.
Okay, perfect. Because honestly, sometimes it helps to see what they're saying in addition to listen.
I believe we went over the Georgia budget one time too. Live. I think we did a live about it one time. I included it in the live that we did. And come to find out, they had a lot of money. And they had a lot of money for these special prosecutors that they do not do background checks on or anything. And that's one of the reasons why Nathan Wade was able to be a special prosecutor, because Fonnie wanted him to be. That's it, because I want him to be one. And gave him a $700,000 per year salary, man. 700,000. Yes, all of the funds have been misappropriated. Absolutely. 100% facts. 100% facts. We even talked about the Fulton County Jail and the conditions that they're in. Terrible conditions. Terrible conditions. Young men are dying in there. And it's due to the conditions literally of the jail, as well as the violence that goes on in there as well. It's absolutely sad, man. I'm more disgusted today than yesterday was a little bit more hype around, but I'm a little bit more disgusted today, man. This is just out of hand. So why they turn the sound off? Come on, Miss Love, get it together, man. Miss Love gave away how crazy she was when she walked around that table yesterday. When she walked around that table yesterday the other way and tooted her fanny in front of Melnick. Y'all remember that? No? Oh man, yeah. Her and Melnick was going at it, man. She tooted her fanny and said, "Kiss my fanny," and walked off. She did the runway. She did the runway. She was standing right here, right? She was standing right here talking to Melnick. And then he said something that she didn't like. And instead of her coming this way, she went all the way around this way, all the way around this way. I'm like, yo, she is absolutely crazy. You are absolutely insane. Absolutely insane. Yeah. Yeah, this is a good, yeah. The men that's been in there for 3, 4, 5 years. Listen, again, we talked about with the video I dropped, that it was a guy there that was there for 5 months without an attorney. Just imagine the ones there for 5 years, 4 years, 3 years. I mean, it's hundreds and thousands of them like that, where they're sitting in jail waiting for representation, waiting for an attorney, waiting for a public defender. This is crazy. No, I wouldn't. I wouldn't want to be a first of all, a lot of prosecutors don't make a lot of money, but they got a lot of benefits, absolute immunity, and benefits from the state, benefits from their county, all that kind of stuff. But I wouldn't want to be no prosecutor either, man. I would practice private. Retain me, dog. Give me my retainer. I have a yearly retainer, a 6-month retainer, a 3-month retainer. A year, annual retainer. Retain me, cuz I got you. Pay me up front. Put me on some. Look. Yes, she did, Ricky. Said Love walked around that table like 5 times yesterday, acting crazy. Acting absolutely insane. Huffing and puffing, having an attitude. Crazy, man. All right, they're just trying to get their audio together and the video together here. Miss Love have absolutely no idea what she's doing. You can tell Miss Love don't know what to do without Hilton. This week is actually Hilton leaving is actually exposing more of love and how bad she is. You know, there are some people that are easily influenced and easily persuaded to do things, and they may have an admiration for someone.
Which one are we
That's
targeting
Hilton.
first?
But Love is the first one, and she is
Okay.
evil, man. Super evil.
I'm just trying to get,
All right, here we go.
so where we are, the
I'm
line
gonna
he's
stop talking.
at right now is the line 25 on page 89.
Okay.
So if I may, I'll just.
Sure, that's fine. Yep.
That ain't Slug real. Just take care of him. So Slug ain't go on the bus yet? No. Well, I told you he grew up even on that. He got jail, he hadn't grew up even really on that no more. But you said Shannon. How Shannon get involved in everything? So when they hear his beat, it's almost like call Shannon. Because that's what they say because Shannon the shooter. Now, Shannon always be quiet. Right. He did. Yeah. He's scared. Yeah, he's scared. When it comes down to it, he's not scared. Who shot Shannon? Who shot Shannon? They say he smoked. I don't know. I was locked up.
All right.
It's just jail. I read you jail.
I heard what I need. Okay. That's definitely a question. Shannon the shooter? And then the answer is no. He's quiet. So 17 is fine to be
Can the court remind me of the one before?
Yes, so that was with regard to item number 13. And y'all said it was around 27 minutes, 30 seconds. And I'm wondering, and we may need to play more of it than that, because I was asking, who is the they that they're talking about? And I was just gonna maybe listen a little bit in front of that. But then, so anyway, that was the issue there. So I don't know how much we're gonna need to listen to find out who the they is. Or if we can find out who the they is. But your item number 13, which was on page 54, but I'm thinking we need to go find the beginning of whatever this portion of questioning is. There's a whole lot of days in here.
I think that it would be helpful for the court.
To just have the whole, listen from the beginning. That's fine. I'll do that. That'll be my homework.
Does the court have, or Ms. Frisfield, have a thumb drive? Because I can easily just copy it onto that thumb drive. That's probably the easiest thing to do.
Probably not here, but definitely in my actual chambers. We've got one. Maybe Miss Bugs could bring us one down before we finish for the day. Okay. All right. So I think that answers on our number 25, which was page 90. We were gonna, by agreement, strike 14, 15, and 16, because you can't hear what they're saying anyway. But leave in, not by agreement, leave in 17 and 18. All right, so okay. right, that takes us to 92, line 11 through 94, line 22. Dennis, who's Dennis? It's investigator Dennis. Okay. So. Okay. So it's not the entirety of 92. That's just to give me context. Is it is it 93 line 21 where the real objection starts?
Put Spanx in the chat.
92 line 15. Oh, if y'all don't mind turning those speakers back around now so we don't have squelch.
So,
Matthews, bring around the corner. Bring around the corner.
Thanks.
Yeah, and it's trying to this way already. That's good.
Okay.
So investigator Dennis was present. He was working an extra job at Club Compound, and he's already testified, and he's provided live testimony about what he observed at Club Compound. Right here, and I think admittedly in the statement, he's just kind of going off his memory and he's confused, and he's testifying about, not testifying, but he's talking to Quindarius about what he saw.
Right.
And we've already heard from him sworn in court testimony about what he saw that night. And this is, in several of the interviews, he goes into what he saw that night. And I just think it's inappropriate for the jury to get investigator Dennis's version of events through unsworn out of court statements. And they're likely to confuse it with what he said on the stand.
Okay. So can you pinpoint for me on page 92, is there anything? Well, I guess line 15, like.
Right. He's leading into it. He's talking about DK, who's Walter Murphy, and I believe it was Pokey. That's Kai Kendall, and he's actually wrong about that. Fatty is Kai Kendall. And so he's just kind of setting the stage of the people he saw. And then
Starting at where? 15?
15.
Okay. Yeah.
And then he's talking about the gun that DK had a gun and he recovered the gun, and how he pulled out his gun, and Jeffrey's sister Max took offense to it, and how the gun was put on Dolly. Dolly is Max. That's the same person. It's on Dolly's truck.
Yeah.
And so he's just reliving what he observed that day, and I just don't think it's appropriate for it to be played in an out-of-court statement like this.
What's the state's response?
Your Honor, with respect to the sections about Detective Dennis relaying and receiving input from Mr. Zachary, information about the Little Wayne bus shooting, as Mr. Sharp said, Detective Dennis was there that night, and as he relayed what he saw, Mr. Zachary's reactions are the more important thing. Obviously, the jury has heard Detective Dennis on the stand, and particularly at line 93.
On which page?
I'm sorry.
Oh, page 93, line
15 through 17, for instance. Where Detective Dennis says, but DK had a gun. I recovered a gun from DK that night. And Zachary says, yeah, I saw that. So Detective impact on Zachary and his responses to them are the more important thing than us trying to have him, as Mr. Shar said, testify. That's not what we're trying to do. Now, there are parts of these that we don't have a problem, you know, consenting to.
All right, well, tell me what those parts are.
Well, let me.
Or the opposite. Tell me what parts you really maintain you want / need / believe you're entitled to get in.
So starting with taking out, I don't mind page 92, lines 11 through 25.
Okay. Well, so we'll redact that by agreement.
And I'm sorry, I missed what the court said.
I said we'll redact that by agreement.
Page 93. Lines 1 and 2.
Okay.
We would object to page 93, lines 3 through 6, 3 through 9.
Okay, so that you believe should be in. All right, and
that's because as investigator Dennis is talking about cooking dog fatty and DK being like this, Mr. Zachary is making his assertions about who among them was actually there.
so he's actually showing I've got knowledge of this and, okay, all right. Any response on 3 through 9 of 93, Mr. Sharp?
No, I'm
All
fine
right,
with that.
so that is then in by agreement, essentially. All right,
As we go on further down,
and then
I have no objection to 19 through 23 coming out, where investigator Dennis is talking about cooking dogs, not cooking dogs, but DK's gun having been taken.
right, okay. All right, and so up above then, where he's saying DK had a gun, I recovered a gun, yeah, I saw that. Is he literally mean, yeah, I saw that on the scene?
Yes.
Okay, yeah, that seems like that could come in. All right.
So lines 20.
Mm-hmm.
And 25 on 93 lead into page 94, lines 1 and 2.
Okay.
We would object to that coming out.
Yeah, I mean, that seems like that's still the firsthand knowledge.
We have no objection to page 94, lines 3 through 6 coming out.
Okay. 3 through 6.
Actually.
3 through 7. or,
Yeah, 327. Line 8 through 10. In, we would object to that coming out.
okay.
We would object to line 11 through.
I appreciate your abundance. That's what's up.
18
Be safe now.
Mhm.
We're just doing all the little boring stuff right now.
Actually, we would object to line 19 through 25 coming out as well. Specifically, were only that Detective Dennis said lines 19 through 22.
Right.
But then Mr. Zachary gives.
Is sort of agreeing and yeah, okay. All right. Any further argument on basically like lines 8 through 25, Mr. Shart?
No, Your Honor.
Okay, all right. I'm gonna permit that in.
And so
So is everybody clear on what's out and in, or do you want me to, good?
I'm clear.
All right.
So the next section, Your Honor, is kind of picks up right where we are. And I flagged this because it was unclear to me at the time whether Mr. Zachary was claiming that he was there. But I am satisfied that he is claiming that he was at the compound, but I think we need to review it with the knowledge of where he was at the compound and where he wasn't.
Okay.
What is based on firsthand knowledge versus what is speculation.
Can you speak to that, Ms. Love?
Which part are we talking about?
I mean, essentially like through the 94 line 24, I guess through 96 line 14.
So my first issue is on 94, he says, yeah, she swapped cars with him. With who? DK and Shannon. Okay, if he saw that, that's fine. You know, if he, of course, if the foundation is laid to ever play.
Right.
But then after he says DK and Shannon, investigator Dennis says are shooters. And Quindarius Zachary says, yeah. He wasn't present for the shoot.
Okay.
It's going back to, he has no firsthand knowledge to affirm investigator Dennis's theory. So I would have a problem with lines 1 and 2. And then I have a problem with investigator Dennis, who wasn't present, saying
Right.
Pee Wee in the white Camaro was just a driver. He doesn't know that. So I'm going to start out 95, 1 through 4.
Okay. So I think essentially that one is, okay, this is the law enforcement theory at this time, but
So we're starting on 90.
95 lines 1 through 4. Or, yeah.
At this time, Your Honor, well, I'll put it this way for open reserve, right? If I ask that the court allow, if we are able to establish that foundation, then I ask that the court not exclude.
Okay, and that foundation being the foundation that he actually does have.
Personal knowledge of it.
Okay.
Or some other.
Okay. Or, okay. Yeah, so that one is, I guess, a TBD.
And Your Honor, I want to also, say, so with respect to Mr. Zachary, he has, and the reason we have some TBDs by some of this is that he has not been the most cooperative person. And I would leave it.
Okay. All right. So we'll just see on that. I understand the objection. I understand that it can't actually quite be answered yet. There's a foundational issue. We'll just have to see. Okay. So then we've got, I guess, what? 6 through 14.
I don't have a problem with lines 6 through 8. But then again, he starts theorizing about who's a shooter and who's not. And he says Troop wasn't no shooter. He was there though. I think he was following them too.
I don't have an objection to, is that 9 through 13?
Yeah.
I don't have any.
Okay.
And then I have a problem with 14 through 22. 14 through 25, really.
And is that same basis, like, how does he know this?
Correct.
Okay. Is that also by necessity TBD based on your frustration with your witness? Okay.
And that leads into 96 as well.
Well, I would say 24 and 25, 95 lines 24 and 25 to 96 is really 96 line 14 is all speculation about why Jimmy Winfrey pled guilty. I don't think that's TBD. I think
Okay.
that would be.
All right. So hang on. I'm sorry. Maybe I'm just not up with y'all. So 95, 14 through 23 is TBD. Is that right?
That's correct. Yes.
And then when we start on 24, line 24 and going on. Okay. This. Yeah. I mean, so the objection is on page 96, what lines?
I don't have an objection to 96.
95 line 24 to 96 line 14.
I don't have an objection.
Okay, out by agreement. Okay, so are we now at number 29?
Yes.
Okay. Uh-huh.
So, Your Honor, the context of this is there's a gentleman named Rico Rich.
Mm-hmm.
Is it Rico Rich? Rico Rich. And he ran or owned a studio on Metropolitan that allegedly was also used at times by Mr. Williams.
Mhm.
And at some point, this studio was raided. And marijuana was located at the studio, and I think Rico Rich was charged with it. It was his studio, my understanding. July 15th, 2015 is when that raid occurred, and it has nothing to do with this case. And so they're just talking about Rico Rich being upset because his perception that the attention drawn by the gentleman in court led to the raid. And it's just about something that has nothing to do with this case.
All right.
And Judge, if I can just add to Mr. Sharp's
All right.
position, the state, we've actually addressed this previously, the state agreed that this would not come in.
Okay. Well, I will find out what Ms. Love says about that, but I think that maybe Ms. Love hasn't had as much of a chance to study this in detail as she would have liked and as I would have liked. And so, Ms. Love, is that correct that y'all had already agreed that this part needed to come out?
And this part, I mean.
99, line 18 through kind of, I guess, what, maybe all of 100? 100, line 10.
Just one second.
Yes or no, ma'am? Pretty simple.
So I don't have an objection.
Okay.
Page 99, lines 18 through 23. And I don't have an objection with that.
Okay.
It continues on to page 100.
Yeah, go on to the next page through about line 10. It seems to be the same topic.
So we don't have any.
Thank you all so much for rocking with me, man. 7 hours in. 7 hours and some
Frankly,
change in. I
14,
appreciate you
I
all.
think.
Thank you all so
Or
much.
15,
Thank you. I really
right? I
appreciate
mean,
it.
isn't that
Everyone
all
watching
the
today.
same? Okay. All right.
All those that's at
And
work,
so
in and
that would
out,
also
coming in and out, I
encapsulate-
appreciate you all too.
Encapsulate, encompass 99, line 24, which I think we accidentally left out of there. So, all right, by agreement, all the way through 100, line 15.
So that would be 99, lines 18, 24, all the way into 100, up to line 15.
Right. All right.
Now, Your Honor, if I could go off the list for a second, I believe
Sure.
one of my co-counsel has a objection
My
to
pleasure.
page 100, line 20 to 101, line 5. It talks about Jeffrey's family.
I appreciate
How
it. Thank you.
he
No
he
problem.
likes to be in the hood, and he likes people that are going to be right there with him, same people he grew up with. And then investigator Dennis says, right, that makes you guilty by association, and that's improper. And then they talk about Mr. Bennett's aunt being shot.
Okay.
So, Your Honor, the state has no objection to page 100, lines 24 through 25, but we would ask the court to listen. I think I have a different take on lines 20 through 23 than Mr. Sharp. I don't think he's talking about Mr. Williams' family so much.
He's saying though, I'm saying though, Thug is family. He likes to, yeah, okay. I can listen to it. Do you want me to listen to it right now?
Regardless, it says he's hanging out with the same people he grew up with, and then investigator Dennis improperly.
Oh, yeah, no. She
Yes.
says she's fine with 24 and 25 coming out.
Oh, okay. And then that continues on to 1 through 4.
I think 1 through 4 can come out. We don't really need, that is not additive to the issues that we're on trial for. Okay. Huh? Let's just, yeah, you agreed, so. All right, so then, so 100 line 24 through 101 line 4 are out by agreement.
And then at 101.9, they start asking Mr. Zachary how he would feel if his mother got shot while she was
Okay.
asleep in the bed and all of those things. And I don't think that's appropriate either.
So Judge, based on the court's ruling regarding 1 through 4 up through 11 would be. Okay?
Yeah, all right, well, you agreed with it.
I
All right, so all the way through 101 line 11. Thank
She
you.
trying, ain't she? Love is
mean,
trying, dog.
It continues beyond 11.
Okay,
It continues.
yeah,
But Judge, with
Yeah.
respect to the ones after 11, Mr. Zachary is saying his expressions, I believe, are relevant. I don't think that is the same
all right.
as 1 through 11.
And when you say his expressions, then you mean like facial expressions when he's talking, or what do you mean?
What he expresses, they
Oh.
just shot up my cousin's house. I'm mad, and I don't disagree with respect to
Yeah, I think it goes to.
line 20. I don't mind all of that up to.
Okay, so now we're to 101 line 20 out by agreement.
Judge,
Yes.
if I may, the conversation continues on. It's this well beyond 101. I don't think reference to that incident ends until we get to page 102.
So maybe through line 8
I was thinking 18.
or 19.
Yes.
Okay. Yeah, I mean, yeah, essentially they're saying bad things happen. How would that make you feel? And he's not saying anything other than maybe how he would feel, but that's, you can feel whatever way. Aren't these kind of hypotheticals? All right, so through 102 line 19 out by agreement.
This is crazy, man. I'm sorry, y'all. This is absolutely crazy. The state should have been worked on this themselves.
Now, the next section.
So the next objection, okay, so that's carried us through 30 and 31 then. Okay, right? Yes. All right, so we're now on item number 32, which starts on page 104, line 3, and goes to the next page, line 3.
And this is involving the Donovan Thomas case. And
Yeah.
I will say that in the other statement, Mr. Zachary asserts that Mr. Stillwell and Mr. Kendrick made some sort of statements against their interest
Okay.
as to who was in the car. But he never asserts that they told him about these details. And he's never claimed that he was there on Cleveland Avenue when he talks, here he's talking about a gentleman named Kelvin Treadwell, also known as OG Bentley, basically taking the guns and taking the car and disposing of those things. He never claims to have been there. And I don't think anyone's claimed he was there. He claims he was at a kid's party, and I think the state has accepted that. And he's never said that he got that information from Mr. Stillwell or Mr. Kendricks. And I don't know where he's claiming he got this information from, but until that is established, I don't believe that it's admissible, even as a prior inconsistent statement, hypothetically.
So, Judge, what Mr. Zachary said in his prior statement is that he got that information from two of the defendants on trial now, following the shooting at one point the night of at Mr. Williams' condo, and I believe the next one on the way to Miami. My memory may be a little bit fuzzy on that, but because he corrects one of the detectives when they're saying, so both of them told you at the condo. And he says, no, one told me at the condo, the other told me on the way to Miami.
Okay.
So our argument is that his recitation of what happened would have come from, he wasn't there, we've never said he was, would have come from the same place that he was made privy to the statements that we caught nuts down at, which was at the condo, on their way to Miami, because they were together. And by they, I mean various members of YSL. They didn't all go in one car together down there, but they traveled to Miami in the days after the murder. So
Okay, but this is about Bentley's potential involvement in getting rid of the guns, is that right?
So OG Bentley is alleged to have, yes,
Okay.
gotten rid of the guns after the murder.
Okay.
And our argument would be that Mr. Zachary would not have, he's not the only one that says that. They wouldn't, this collective knowledge wouldn't exist, but for his involvement in the gang itself. So this is another spot where I would say, where I would object to it coming out. But of course, I'm going to follow whatever ruling the court makes.
All right.
And I just want to be clear. I actually agree with Ms. Love's recitation of facts to the extent that he said that he got certain information from those individuals,
Right.
but it's not this information.
Yeah, I mean, it does seem like, I mean, he could legitimately have gotten the information about two other people saying they're involved, and that's one thing, and that's not what this is about. This is about what was OG Bentley's involvement, and did he, get and hide guns? And literally, even on 104, like towards the bottom, and they're asking about, they gave him the guns. He's like, that's what I hear. He doesn't even seem to be saying, hey, I know this from one of my in-gang sources. He's just like, oh, I mean, I don't know.
In the 2015 interview,
Uh-huh.
a little bit more detailed and a little bit more specific. He
Okay.
references it. So at the very least, I think it.
All right, so how about if you can point me specifically to where in the 2015 thing it shows that he actually has the legit knowledge of this, then I'll reconsider it.
Okay.
Okay? All right.
So I'm just gonna put, okay, contingent on.
Yes.
This is, and this would be all.
All, basically 104 line, what, 3 through 105 line 3? Is that right?
Yes,
Okay.
104.3 to 105.3.
All right. So moving on to item number 33, which is a little portion of page 105.
So the state has no objection to 11 through 14 coming out.
All right. All right. So that takes us to page 107. Our first
I'm gonna withdraw that one.
34.
Yes.
Okay. And how about 35? We're still gonna sort out?
35?
Yes. Item number 35, which is 107 line 23 through 108 line 1.
I didn't remember talking about that one.
Well, it's in your list.
No, you said we're still gonna.
No, I'm asking you.
Oh, yes.
So that's what we're moving to next,
Oh,
right?
yes.
Okay. Sorry.
I
You're
thought you
like,
were
wait a
saying
minute.
we had already discussed it.
No,
I got it.
no. Okay. All right, 107 line 23.
Just a random discussion about a fight in a club that Mr. Kendricks allegedly got into with a man named Lil Tony.
Okay, does that have anything to do with this case?
Yeah. No, it doesn't.
All right, thank you, Mr. Shard. I'm asking the state now.
So actually, Judge, going back to 106.
Okay.
So 106 just gives sort of context of time frame, but from 1 to page 107, line 1, when Dennis is asking,
Right, is this about the time the beef's kicking off? Okay, well, they don't have an objection to that.
So it's going back to the gambling house shooting, and they thought the quote unquote the mob did it, but then we find out that apparently Kelvin Watts pillow talk with a young lady led to it being revealed that Kelvin Watts did it. And essentially they're asking, why did you think the mob did it? Why did you mistakenly think the mob did it? Assume. And they're saying, oh, because Mr. Kendrick beat up one of them named Lil Tony.
Okay.
And so I don't know why.
Okay.
and this is all around as Detective Dennis said, this goes back around, this is all around the time that
Right. So as I understand, the objection, it is to, well, it may be a little further up than
Right.
Line 23, right?
It really starts on 14. Why
Yeah.
did you think the mob
Yeah,
was shooting?
all right. So starting at 107, line 14 through 108, line 1.
So when Detective Dennis asks Mr. Zachary, why did you think the shooting was taking place? And Mr. Zachary is telling Detective Dennis, yes, he might be speculating about why they did a rival party did what they did, but he's also stating that Diamante Kendrick had just beat up one of them.
But this isn't, I'm sorry, it just for my clarification, this isn't one of the IF people, this is some other group, right?
Where it says why y'all thought tomorrow, and then
Phonetic or something.
Right there on line 14.
Right.
If you listen to it, it says why y'all thought the mob was shooting, not tomorrow.
The mob?
The mob.
Okay.
And that's the gang that they assumed. did it.
Okay. All right, so why do we need this? What is your position as to why this would be admissible? Line, 14 through the next page, line 1, hey, man, I mean, we thought for a while it was this other group because of this other beef that had gone down.
So as it relates to 14 through 17, we would stipulate to that. But line 18, where Detective Dennis says, y'all had beef all over the place. Y'all being his acknowledgement as he was telling Mr. Zachary of them as a group.
Okay. And Zachary at 21 says, yeah.
Yes.
Okay. So then 18 through 21 seems like that legitimately could come in. And then that brings us then to 22 through the next page, line 1, about, okay, here are the details on this mistaken beef again. So that out, and then just 18 through 21 in. Because it seems like 20, you're okay with that?
So I don't have a problem with, you're saying 23?
22, yeah. Well, actually through the next one line on the next page.
Correct.
Okay, so thank you. Okay.
Are we at 109:23 now?
Yes.
Can we go through the exact?
Yes, so on the ones that I just said, okay, so if we go back to page 107, 1 through 13 are in without any objection. 14 through 17 are out by agreement. 18 through 21 are in over objection. No, was there an objection to that, Mr. Short? 18 through 21?
No.
Okay, are in because there's no dispute about it. And then 22 through 108, line 1 are out by agreement. All right.
And then we're moving to line 23.
Yes.
I have no objection to 23. 23 through 25 on 109. And 1 through 13 on page 110.
Okay. All right, which I guess means that if there is objection to 110 lines 14 through 19, is there?
Yes, because,
Wait, so y'all want that out?
no, we won't.
Yeah, so I'm asking the defense.
Well, if 14 through 19 is played, there's going to be no context to it at all. Because it starts with, they've been shooting at each other for how many damn months? And no one's even going to know.
Right,
The last time we talked, they were talking about
right, somebody
Nut
else.
and Greedy and
Okay.
Kel being half brothers. And
Right. So,
I mean, honestly, I'd be okay with. I've identified this as hearsay. I don't have any problem with it coming in, to be honest with you. But
okay,
you know, if the state needs to play 14 through 19, I just say play the whole thing and you know,
Okay.
give context.
all right. So then that actually starts with 109, line 23, or no?
Yes.
Okay, all right, so basically they're withdrawing their objection to that. Page 111, lines 7 through 9. Okay, what does the state say as to that?
That Mr. Zachary's response, no, just stopped messing with booty.
Uh-huh,
And the subsequent lines are important evidence in this case. Obviously, Woody is Mr. Copeland. He's the one on the stand right now.
uh-huh.
I can't, you know,
Yeah, no, and he doesn't object to line 10 and 11 and 12. He objects to 7 through 9.
7 through 9 is necessary because they cause the response. That is line 10 through further down. And it is necessary, it is Mr. Zachary's reaction and response to Detective Dennis's question
It's not a question, though.
between.
Yeah, it is a question. I mean, it might not have a question mark at the end
Well,
of
it says,
it. I mean,
word I got is Shannon started putting in more work than Woody. That is a declarative statement, and it gives the impression that other witnesses have told Investigator Dennis that, and that I've never heard someone tell Investigator Dennis that, and
yeah,
even if they had, that needs to be come from the stand.
He starts out with how did Shannon.
yeah. So the how did Shannon part's really not a problem. I mean, could you redact out after the dash? How did Shannon? And I know we then don't have the word Woody in there, but Mr. Zachary provides the word Woody. No, Thug just stopped messing with Woody.
Why don't we just start with line 9, just with why Thug start pushing Woody?
That works. Thank you. Thank you.
Thank you.
113, line 20 through 114, line 3. So do y'all, before we dive into the substance of this, we're not gonna unfortunately get through the entirety of this one statement today. So we can look forward to doing more of this tomorrow. But there are, how many, two other statements? Okay.
I can provide all of them to the court.
Okay. Here's the thing is, some of this I am having to make rulings on, but a lot of it, it's like, it might be, and I'm not saying it's the first time you're looking at it, but it's the first time you're looking at it for the purpose of trying to think about whether you're okay with redactions. And that's not really the best use of court time, by which I mean time that we are all here between 9 and 5 in court. So can you endeavor, and I know this is a lot, but y'all should have done a whole lot of this before now.
Facts.
So can
That's the only fact I heard.
we sort of maybe by the time we all reconvene tomorrow, have a whole lot more of this sorted out so that y'all can hone in on the things that I need to make an evidentiary ruling on.
I have no problem with that. I know
Thank
that
you.
Mr. Sharp was endeavoring to give us enough.
He's got, this list is great because I just need, okay. I need the responses to winnowed. All right, great.
Okay, he gave it to us from one of the other interviews. We need the last one. It's 3.
Okay, well, do you have that one ready yet? Mr. Shart is ahead of y'all on these interviews, so maybe while y'all catch up through the rest of these two, he can be finishing the third one, if he doesn't have it yet.
I'm trying to remember. I'll talk to the state afterwards. I want to make sure I'm on the same page with them about the 3 different statements.
Okay. So I'm sort of thinking I don't want to do any more of this. How about that? Because y'all can maybe do some things to make it all easier. So I will take a look at the beginning of this video. Y'all, the state, are going to go through what you have so far, which is the rest of this statement, potential redactions, and then whatever the second statement, not in time, but you know what I mean, potential redactions, and have it crystallized more for tomorrow. And tomorrow we also, I think, can't remember what I told you to turn in by tomorrow, but what was it?
John, we do the open court exhibit.
Yes.
And I have a very nerve-wracked and nervous person working on that. They're asking, what if we don't have everything?
I'm gonna throw them in jail. I'm kidding. I understand this is a monumental task, which again, should have been done before now, but given that it wasn't, we're doing the best we can. If they do the best they can, it's not what we're going to be dealing with, but it's not for me anyway, it's for the defense. So to the extent they have whatever they have tomorrow, turn it over, and then the rest of it by Friday. How about that? That seems reasonable. All right, what else?
And also, the court asked us at the beginning of the week to have the next.
Yes, the next tranche. Yes.
Yes. So
where are we on that?
we count. You win that tomorrow night at the end of the beginning of the week, but I don't know. So we're together.
You're okay. All right. I'll check in with y'all again on that one. Okay. Mr. Harvey is going to produce a potential 105 limiting instruction within the next couple of days before Friday for me to consider.
Will the court give the state an opportunity to?
Oh, absolutely. Yeah. I mean, but we got to have something to at least start with. Oh, y'all are also all supposed to be thinking about what it is that we tell the jury about why we're starting over with Mr. Copeland, which may not, necessarily need to be a whole lot of detail, but we are going to be starting over with him. So it's going to be a disregard everything you heard so far, and then we either hear from him again or we don't. I don't know. We'll find out depending on how he wakes up that morning. But I'm gonna have, that'll be, it's gonna be a strike everything you heard, and then we'll see what happens next, But any kind of suggested instruction as to that as well, since we're starting over on him.
Okay.
Yeah.
So you're not talking about trying to offer it up and work it out now?
And no, I think, didn't some people have objection to any of that? Right? I mean, hey, if y'all want to, super, that's easier. But the gist I was getting earlier today was that there were some defendants who objected to that, and that it might be just cleaner to just start entirely over. And frankly, if he ends up, it depends whether he ends up testifying or not. So, I mean, yeah, I'm happy with if he ends up testifying and y'all are like, yeah, we're going to use this day, whatever, all of it, whatever. I don't care. But that's going to have to be because y'all agree to it.
Your Honor,
Yes.
I thought the people charged here position was, and I think the state's position was just to include the 7th, which really was not anything, and then the 10th, which is Monday, the 12th, which is Tuesday, and part of the 11th, 10th, 11th, and 12th, part of the 12th, but nothing thereafter, not strike everything. There was a lot of exculpatory information on the 10th, 11th.
Here's the deal, though. And if he ends up testifying and y'all want to say those 3 days, great. But if he ends up, since what I am trying to do is sort of circumvent the whole issue of potential coercion and give him an opportunity, fully and correctly informed, to make a decision about whether to testify, then if he says, no, I don't want to, throw me in jail, then that means none of his testimony should come in unless everybody wants to agree to it, which would be kind of, an odd scenario.
If we don't get to cross-examine Mr. Copeland, we would like to strike all of his testimony under
Okay,
that
right?
circumstance.
Yeah, right. So, and then, if y'all want to try to call him as your witness, if anybody's calling a witness, then try that. I don't know. If you want exculpatory parts of it, but then that of course comes with risks. So it just, a lot of this is up in the air depending upon, I think if he says, now that I'm fully informed, which I am not saying that any of his decision before was because of any incorrect information. I just think, like he said, it depends how he feels when he wakes up in the morning. So, but anyway, yeah, in order to try to tackle all of the issues surrounding this, this is the best I have been able to come up with. So, so y'all be thinking about that.
Did Your Honor get the thumbs up?
Yes, magically. All right. Anything else before we break for the day early? Because I'm going to go do some work on it, not in court.
Just for your edification, we'll file a written motion. The state yesterday gave us a Dropbox link, and it includes additional telephone numbers that I was unaware of.
Okay.
Where an expert, he's already been qualified, His name is Agent Bernie, Berni, from the FBI, has done now an analysis of historical cell site location data. And I'm objecting to that very late, I believe, notice. And then the state has a couple other, they changed charts. I personally don't have a problem with that, but I need to study them. But the new reports and data and a new phone number, I am not agreeable to.
Okay, an entirely new phone number. Tell me some more, Ms. Love.
Yes. So the new phone number there was another person in the vehicle during one of the murders in this case that investigators were still investigating during the time we began this trial. They were trying to hash out whether or not this particular person was even in the car, if you will, with some of the alleged parties to the crime.
Okay.
Since that time, during the course of this trial, the investigators with the Atlanta Police Department that were doing their deep dives into forensic data determined that this person, I don't think that person has been arrested, but this person was also in the car with the co-conspirators during this particular murder. We got it before now, but we got it after the trial began, like between, I think, January and now. And I think it was inadvertent that it had not been disclosed.
All right, can I stop you and get some clarification?
Yes.
When you say we got it, do you mean we got this report from this agent, or we got information that there might have been yet another person in the car and that person had XYZ phone number and that was going to be investigated?
So those are two separate things. The report from the investigator, from Detective Bernie, involved plotting.
Sure, I understand what that means. When did y'all get that?
We recently asked him to plot those two, because the green store is a thing that came up recently during trial, and the other location was.
Dude, man, this is crazy.
So we have two understandings of what the court is asking. So we're not talking about the plotting of those cell phone numbers. We're just talking about the Boyer cell phone records. We're just talking about the cell phone records.
We're talking, I don't know what we're talking about. That's what I'm trying to pin down. So
there was.
Hang on, yes.
We were given cell phone records linked to a last name Boyer.
Boyd, B-O-Y-D?
B-O-Y-E-R.
Boyer, okay.
On Monday, yesterday.
Okay.
Yesterday. And so that is the late disclosure that we're speaking of.
Okay.
And they were charted as well.
Okay. Nobody really, I'm sorry. Do y'all care? Is the objection to the charting, or?
It leads me to believe that they've had them for a while if they've plotted them.
All right. So the plotting of the cell site location information report done by Agent Bernie, that's of this Boyer phone number?
Yes.
Okay. And y'all just recently asked for that based on some testimony about something?
No, that's a different thing. I literally sat there and conflated two different.
Okay, all right. So then let's let's back up to the original issue.
This is what a liar sounds like.
When did you find out that law enforcement believed that there was another person in the car and had a cell number that they were going to investigate with regard to that to find out whether, in fact, that was a reasonable lead?
Your Honor, I'd like to check with another team member.
Okay.
Because I don't know the answer.
Can you give me an idea? Let me clarify. You said about something that it was sometime between January and May, and that might have been that you got something. What was that about?
So the conversation that I had with the team member most recently, like 2 days ago, was that I have to turn over these phone records.
Right.
This person was someone that they believe might have been in the car.
Okay.
And they got phone records, and now we know that based on the phone records, this person was in the car.
Okay, so when did they ask for, we or they, not we, but y'all or they ask for the phone records because they thought that might be?
I beg the court to allow.
All right, find that out. And then, do you know when y'all got the cell phone records?
When you said we, I thought you were talking about us. I don't know the answer at all for the Atlanta Police Department, but I can find out.
Okay, so unfortunately for you, we equals, y'all equals, the state equals both the DA's office and the Atlanta Police Department. You know that. And I know sometimes there's a little lag in communication, but I need to know, was it, if they were provided to the defense on Monday, was it last week or was it 4 months ago?
Okay, I can find out.
Because, okay. And
You don't know when you
what
got
do
some
these
records.
cell phone records reveal? That this person did appear to be also in the car? And
There's 2 cars.
okay, do you know which car? I mean, there are 2 cars that obviously one, well, not obviously, at least one contains at least one shooter, right? Is there any assertion that others contain shooters as well, or just people that are involved?
The state
Okay.
is alleging that there's a white car with my client and Mr. Garlington in
Right.
it, and then another car with Mr. Nichols and Mr. Farley in it. And now it sounds like they're saying that this Boyer phone, whoever owns this phone, was in one of those cars. And I'm inquiring what,
Mm-hmm.
I don't know anything
I'd
about
like to provide that information, if I can.
You don't know, you want to check and make sure on that, okay.
Because it was not a part of the original. Yes.
Okay, how long has the defense known anything whatsoever about this person named Boyer?
Your Honor. Oh, except for this, I could tell you from my understanding of the discovery, there is zero information on Mr. Boyer except one mention in a jail call. That is it. That from my whole database, I have one mention. That is it. And I have no reports. So the police been investigating and found out that this person allegedly was involved in this killing. I still, to this day, have no reports on it. I've
Okay.
never interviewed him. I didn't open on him. He could be
Right.
a great defense. I have no idea who this person is.
Yeah, I mean, yeah, this is, I mean, potentially significant information for the defense to know about.
I can't say that at the time we did opening that the police had it. I'd like to be able to say.
All right. All right, we'll find out, but there's been a long period of time between opening and now. 8 months to be,
That was 24, okay.
7 or 8 months. So, Yeah, we need a lot more information about this. I love how y'all save all of the like bombshells for late in the day, right before we're wrapping. Y'all like going, hey, guess what? So, okay. I mean, it is what it is. Okay. So we'll need to find that out and put that on the record and sort that out tomorrow. Okay, so exhibits, next 30 witnesses, and then you also, I believe, we're going to get by tomorrow actual, like a list to the defense of here's what we think is a co-conspirator statement, right? Okay, so we'll be waiting anxiously for all of those. Anything else? As if that wasn't enough.
Your Honor, somebody I wrote down said that there are 3 Mr. Zachary statements. I have 2.
Okay, and I might have misspoken. Did I misspeak? Ah, Miss Love misspoke. Did Miss?
I might have put a date wrong, but I'm talking about a 2015. I think it's August 2015. I believe March 2017 and the proper. So I'm sorry.
Miss Love is trash without Hilton.
Okay, so you think that maybe there only are 2, but you'll confirm that for us tomorrow? All right, and so if there are only 2, then Mr. Shart, you've done all of the proposed redactions because you've done redactions to 2 full statements, right? Or proposed redactions.
I have. I didn't quite finish the second one, but I don't believe that the state is going to be trying to use it. It's a discussion with ATF agents and.
All right, y'all, we're going to get together and sort that one out too. Okay. Sounds good.
And Judge, if the board needs to finish the report, just allow me to get this thing copied.
Mr. Love is terrible, man. Terrible. Hilton being gone has truly exposed Love's lawyer ability for sure. I mean, Hilton is not that great either, but she was doing a lot of the work. You could tell she was doing most of the work. Now you got some information that you should have given to the defense that you didn't give them, or that you gave them last minute, and and now you don't know when you first got the information.
All right, that's fine. That'll work. Thank you. All right, see y'all at 9 tomorrow. We'll be 8:45 at it when we have the jury. Okay.
Let's make sure that they like to come back on you. Yeah, they like to come back on you.
All right. Adjourned.
All right. So that was the day. That's it for the day. As you can see, Lawyer Love is terrible as a lawyer when it comes to dotting her I's, crossing her T's. She don't do a good job of that at all. I don't care what nobody say. I don't care what nobody says. She is not good at getting case law. She's not good at making sure that she's not good at making sure that she speaks clearly about what it is that she needs, wants, or whatever, and then she's trying to talk around everything. It's just all bad, man. This is just all bad, and this case should be completely thrown away. Again, another thing that Love has done. This is at the tail end. It's like, oh, we never got this and that. We never got this, and then we got this last minute, like yesterday, some new information about cell phone tower records and all this kind of like all that, and you worried about the defense giving you evidence or turning evidence over to you in a timely fashion and reciprocating evidence to you as their duty, but you don't have, but it's you're the one that's supposed to give the evidence over to everyone else. I mean, it's just ridiculous. Just ridiculous. So all right. Again, I want to thank again D Pill and Deborah for the for the Cash Apps. I really do appreciate it so much. Thank you so much once again. I'm gonna thank everybody for rocking out. We did 8 hours again. We did 8 hours again. All right. I appreciate it, man. I appreciate it so much. Marion Hale says she is a joke. Absolute joke. Absolute joke. I mean, I'm talking about just regular common sense, man. Common sense stuff, and lazy. And she's very lazy because a lot of this stuff, like the judge said, we just saw the judge say, a lot of this stuff you could have done talking to the state ahead of time, way ahead of time. You've been doing this case for almost 2 years, man. You've been on this case for almost 2 years, and the trial opened up in what, January? First day of trial. The first trial was what? The first day of trial was in January, December of last year. It's August, man. It's August, it's August, and the prosecution has not rested their case. Like, what are you talking about, man? Like, why is it taking so long for you to get you? Because you're trying to build your case while you're in a trial. That's what you're trying to do. It's a tactic. Judge, Your Honor, can you give us a little bit more time to make sure that we give this over to the defense? I mean, well, the defense stop it. Stop it, man. Just completely stop it. You've had more than enough time to do whatever you need to do. You should know how to respond to emotion. You should know how to do all kind of stuff. You don't know how to do anything, Lawyer Love. What have you been doing all day, all these years? Literally years. Since you've known about this case, you don't have a case. Everybody can tell you don't have a case. Everybody knows this. I know it. The chat, we all know it. And we're just regular, everyday people that can just common sense. You're trying to put hearsay in evidence. You're trying to, your own witness don't want to testify. You had to compel him to testify using statutory immunity. You tried to coerce the man to testify even with immunity in an ex parte meeting. Talking about he's going to have to be in jail for the duration of the entire of this trial and all the other defendants that's a part of the trial, including the severed defendants. Are you kidding me? Gave him bad information, bad advice, bad insight, didn't explain the immunity properly, all that kind of stuff. This is all trash, man. And this is Miss Love. She's the chief deputy assistant district attorney. This is on her too. This is her. Like, you got to be kidding me. This is the best you have done. We are literally been watching this court today, watching the prosecution finally get some type of I would say relevant information inside of a case based on transcripts or interrogation videos or whatever. You're finally getting some evidence in, or relevant evidence in, and it's taking you how long it has been taking you? Right. You mean you still unprepared? That's what I'm saying. It doesn't make any sense. That's why I said about the and no shade to Caleb Bumpus, but that's what I said about Caleb Bumpus, man. You've been an attorney for 5+ years. You don't know how to testify, even if you have been caught off guard. You don't know how to just tell what happened. Yeah. This is ridiculous, man. Where are the skill sets of these people? Paying attention to detail, being observant, retaining information, understanding how to research the case law, understanding how what the law means in certain cases. You just put a case in a motion, and you just hope it sticks, trying to say, well, this is the reason why defense have a duty to give us evidence that they are holding on to. They're not case in chief, ma'am. They're not case in chief, ma'am. This is your duty to hand over all of your evidence. This has nothing to do with the defense. Where are the skill sets? You don't know how to project what it is that you're actually doing. You don't know what it is. You don't know how to project yourself with professionalism, but you project your attitude all the time. Like you did yesterday when you try to be a runway model around that damn desk. Okay. This is ridiculous. We are sitting here. You are wasting everybody's time all day going through. The line on page 40, lines 8 through 10 can be in there. That's cool. And you going precept on precept, line by line on all this kind of stuff. And it's like, dude, you mean to tell me you couldn't do this before? Didn't you have these transcripts, and didn't you have these depositions and transcripts from depositions or whatever? Didn't you have this stuff before? Why didn't you just prepare yourself for the case, actually build a case, and then present it? And then while you're waiting for a trial date, work with the defense, who is a part of the bar, and you can have a conversation with them and meet with them about what you want to admit to evidence, what you don't want to admit to evidence according to these transcripts or whatever. And then by the time you get to the court, you can just give the judge an actual conglomerate of information that you both agree upon, so you can actually have a real trial here. I know, right? This is my bad. This is my fault. I am trying to make logical sense out of stupidity. You know what? This is on me. This is me. This is my fault. I am trying to be logical. Why am I doing this? Why? Oh, this is on me. You know, I do that from time to time. Sometimes I hear something that is so ridiculous, or I see something that's so ridiculous, and I try to make sense out of it, and I just can't curl over. Like, remember Luther with the curl? I couldn't curl over like Luther, okay? Because this makes no sense at all. We been knew you don't have a case. You're trying to build a case while you're in a trial. This is absolutely insane, man. Oh man, I'm going to digress here. But it's been a long day. Look, we have been here for 8 hours. Again, I want to shout out everybody who has been rocking out with your boy. I appreciate you so much. I do. I want to give y'all some props for love. Yeah, I'm trying to make sense out of this craziness, and it's impossible. Like Bruce Harvey said, I should have learned from the lawyer. He said, "Listen, it's going to be impossible. It's going to be impossible, Judge, for you to be able to catch up with everything." And he was right. He was absolutely right. Okay. It's impossible to catch up. It's too many details, too much misconduct, too much illegal stuff going on. I mean, it's just way too much. All right, but this your boy Tay Biz, man. Look, again, I want to thank D Pill and thank Deborah for the cash apps. Again, I want to say thank you so much from the bottom of my heart. I appreciate you all supporting the channel. And thank you. I mean, this means a lot to me, and I appreciate everybody stopping by and rocking out with me for over 8 hours, man. Thank you all so much. But until then, I don't know if I'm going to be able to stream tomorrow because I do have some things lined up for tomorrow. However, if I am able to stream, I will. But and it may be later. But if not, then I'll just probably stream probably on Thursday. I think Friday there is no court, so I may be able to stream on Thursday. But I'm not sure about tomorrow. But we'll play it by ear, family. You know how we do. This is Biz Nation. I can't wait till Monday either. Monday is going to be off the chain. So we definitely gonna do some Monday. But yeah, I appreciate you all rock with your boy. This your boy Tay Biz, man. Y'all have a good day. Have a good night. Hey, get you something to eat. Spread love. Take care of your family. Take care of yourself. I love you. Peace.
No stress, no biggie. Baby, I'm just too jiggy. Better know I brought that with me. Case they get too iffy. Baby, don't stress, don't sweat it. Put it all on my baby. Know how I'm coming. And they know what we hate. Run around through that left side, low end. All of mine need more wins. If you got beef, don't come out. Cause my young hitter might go in. Uptown GN. Working all through my weekend. Hoping these don't show out. Cause all of my hitters too deep in. With the boy, I'm so ashamed. Ain't worried about long as my money and my green. Baby, I ain't got work tomorrow. Tell me what the business is. Ain't about no club hop. I'm trying to start some businesses. Shorty, you thought it was, they better know it's not that. Talking all that online, they knowing that it's not fake. Sliding through my hood, I make maneuvers like a Uber, baby. Got a 10-year plan, these can't tell what they doing lately. And I'm way too clean, I'm Listerine, I thought they been knew it. All in my lungs, I got my red cup full of that Henny fluid. Young middle Mad Mac, I'm swinging that leg, I'm banging that do or die. And I ain't that Lily before I get crucified. Living in my bloodline, this place in my family tree. How the they pressed, I did my best out of what they handed me. Straight out of that country, know my shawty dick as human air. And I need not mention no extensions, that's human hair. Boy, we